Good morning, Mr. Lee. Just want to test your audio
Yeah, can you hear me?
perfectly.
All righty.
Very good. See you in a bit.
Bet. Where is everybody?
They're in the waiting room. I'm just waiting for Anthony to join, and I think he should be a co-host, so he should just be let in, but we'll see. Good morning, Commissioner.
Good morning. Sorry about that. My microphone was blocked by pop-ups that I couldn't get rid of. I couldn't unmute.
Yeah. All right, so we're just waiting for Mr. Medeiros, hearing examiner Medeiros, and so there he is. And I will now admit all.
Good morning, Mr. Lee. It's Peter Gould. Can you hear me?
Yes, sir, I can.
Thank you. Am I loud enough?
Yes, sir.
Debris is always complaining I'm not loud enough.
She doesn't know you like I do.
Good morning, Mr. Lee. This is Henry Monroy. Can you hear me?
Yes, sir, I can.
Great, thank you.
And Mr. Lee, this is Mr. Albright, working from a couple of different computers and multiple screens. I'm not sure how I'll fare here, but can you hear me all right?
Yes, sir, I can.
Thank you.
Mr. Lee, it's Gideon Elliott, just following the trend. Sound check.
Yes, sir.
Okay.
Good morning, all. Apologies for the slight delay. I had some slight technical difficulties here with some issues that I won't get into. But before we go on the record in this PNM Ray case here, quickly, is there anything else, anything to address technically or issue-wise before we do go on the record?
Mr. Hearing Examiner, this is Mr. Gould. My co-counsel Kelly Gould had a technical issue. I'm going to get up so she can address it and make sure the microphone picks her up.
Hi, good morning, everyone. I sent an email over the weekend. PNM had informed us that there was an issue with uploading all of our exhibits to Dropbox. And so I had emailed hearing examiners and the parties of the 6 exhibits that were not uploaded to Dropbox. But I did want to ask the hearing examiners how they wanted to proceed, if they wanted us to update the Dropbox or basically the exhibits were listed on our exhibit list, and I'm not quite sure what happened, but we had put all of our exhibits in a folder and then just dragged and dropped the folder up into Dropbox, and it just didn't upload some of the exhibits. We don't know that we'll use all of the exhibits because it depends on how PNM's going to ask the questions. So either we can update the Dropbox, or just at the time, if we need the exhibit, PNM's on notice that we might use it, and then we could ask for admission at that stage if we need it.
Your examiner Ryan?
Yeah, so what I want to happen is the Dropbox that was initially exchanged should be preserved exactly as it is. And to the extent to which there are additional uploading of exhibits, and this is for everybody. Unless there's some problem with the size of an exhibit, which precludes emailing, which, you know, we had that happens from time to time. We'll just exchange exhibits via email, but it is essential that Mr. Lee, the court reporter, be a recipient of that email. Any questions about that?
Could we get Mr. Lee's email address?
Yes.
It's
And then, of
C-
course, you don't want to email him outside of us. He should be included on the email that goes to everybody with the exhibit. So sorry, Mr. Lee, go ahead.
CUMBRECOURT@comcast.net. That's CumbreCourt@comcast.net.
And I had one just clarifying question about that. Is do you want us to email the whole service list and Mr. Lee of the exhibits we might use, or only now that Dropbox is over and closed, or only ones that we actually use and actually get admitted?
Well, the only issue you have there is having everybody have access to the document if you're going to utilize it. And you're saying you don't know. I mean, I think at this juncture, I would suggest that you just send all those documents, and then Mr. Medeiros and I will be keeping a very close watch on what is admitted, what is not admitted throughout the course of the proceeding, as to assist Mr. Lee in that process.
Okay, and did
Okay.
you yourself and Mr. Medeiros receive the email I sent with the missing?
Yes.
Okay, so I'll just send those also to Mr. Lee.
Very good.
I did send, okay, thank you.
Mr. Hearing Examiners, I also had a question. Reviewing the pre-hearing order that was issued yesterday, and particularly the attachment A thereto, the times for the CCAE cross-examination of witnesses is incorrect. We had filed a second memorandum, pre-hearing memorandum on Friday, which reduced the cross-examination by 20% as instructed. And that was not reflected in the document. So for purposes of today, I allocated only 20 minutes rather than 30 minutes for Mr. Monroy.
So, Mr. DeSalen, you're saying that I didn't capture, so you have 20 minutes with Mr. Monroy. I'll go through and correct those, but you reduced your time to 20 minutes, is that right?
That's correct.
Okay, this matrix okay, thank you.
I understand.
Did anybody else?
Thank you.
As you know, at the pre-hearing conference, I predicted precisely this would happen, so it's good that it happened early. Did anybody else see any discrepancies or errors in the Exhibit B to the matrix? The Exhibit B, the cross-examination matrix, Mr. Gould?
Yeah, Mr. Hearing Examiner, maybe this is something you want to do on the record. We wanted to move some of our cross times
We'll do that on
around.
the record, Mr. Gould. But yeah,
Just do
let's
on
do
the
that on the
record.
record. That wasn't my question. My
Okay,
question
thank you.
was-
I just want to make sure.
Right,
Thank you.
thank you. We'll do
But-
that on, and we're
Okay.
going to be doing that for folks out there in their internet world on YouTube and also on this Zoom video conference call. Throughout the hearing, counsel will be requesting revisions to their cross-examination time as they evaluate their cross-examination of witnesses, and they may reduce time from one witness and add it to another. And so we'll address that. at the appropriate time with the particular witness. Anybody else?
Mr. Hearing Examiner.
Good morning, Mr. Albright.
Good morning. I would raise my hand, but I don't see the icon for that. But I wanted to just mention that we also had an additional document. I think your guidance is clear with regard to that we may use for cross-examination purposes only. So we will ensure we comply with that and get a copy to the court reporter as well. So
Okay.
thank you, sir. I think we're covered then. Thank you.
Thank you, sir. Anybody else? All right.
Mr.
Ms.
Nassi
Barrett.
has
Ms. Nanazi, good morning.
Good morning. Good morning, all of you. I wanted to say that in the Dropbox, there is a mistake in the description that I wrote for New Energy Economy Exhibit number 14. It should have read, this is the only change. It should have read, instead of 15,261, 16-00276 UT. That's the only change. It was a mistake, just in the description, nothing else. Thank you.
Which exhibit is that?
That's New Energy Economy 14. If it's possible to change that description so it's accurate, but everything else.
Okay.
Everything else about it is correct. The other thing is that I have emailed, but I will email in a few minutes, Mr. Lee, on New Energy Economy 19, it didn't have a label on the internal document. And so I resent the exact same document. There's no change, except it has a label now internally on the document itself that says New Energy Economy 19. Thank you.
Great. Thank you, Ms. Nanazi. Anything else from the folks? Ms. Barrett, please unmute yourself.
Morning, Your Honor. This is a logistical question. Because this is going to be quite a long hearing, there might necessarily need to be some comings and goings or, leaving.
Well, I'll address that on the record.
Okay, great.
Request for excusals?
Yes, sir.
Okay, that's right after my introduction for you. A very soon coming attraction, hopefully. Anybody else? All right then, Mr. Lee, good morning. It's so wonderful to have you. Are you ready to
Go
go?
ahead, sir. Yes, sir, I am.
All right. Okay, thank you. This matter before the New Mexico Public Regulation Commission will please come to order. This is the time and place set for the evidentiary hearing in the matter of Public Service Company of New Mexico's application to revise its retail rates pursuant to advice notice number 595. This case is docketed as case number 22-00270-DP. Good morning. I hope everyone had a good Labor Day weekend. My name is Anthony Medeiros. I am the hearing examiner Christopher Ryan. We're assigned by the commission to preside over this matter and issue a recommended decision on the merits of PNM's rate application and the myriad of requests for relief in this case. The record should reflect that participating in concert with the hearing examiners in this hearing are Commissioners Gabriel Aguilera and James Ellison. Our third commissioner, Chairman Pat O'Connell, recused himself from this proceeding early on because he was a witness in a prior proceeding that includes a contested issue in this case. I'd like to start today with the appearances of counsel for the parties, starting with the applicant. So who appears for Public Service Company of New Mexico, or PNM?
Good morning, Mr. Hearing Examiners and Commissioners, other counsel. Rick Alvidres and Debria Terwilliger are appearing on behalf of PNM in this case.
Good morning, Mr. Alvidres. I also have Mr. Gifford, Raymond Gifford listed. Will he be appearing as well?
He will, yes.
All right, thank you. Now for the intervener parties in order of cross-examination proposed by the parties and approved by the hearing examiners in their September 4, 2023 pre-hearing order. Who appears for Bernalillo County?
Good morning, hearing examiners Maderos and Ryan. Jeff Albright of J. Albright Law LLC on behalf of Bernalillo County, and good morning to my colleagues as well. Thank you.
Good morning, Miss. Thank you, Mr. Albright. New Mexico Affordable Reliability Energy Alliance, or NM area.
Good morning, Mr. Hearing Examiners, Commissioners, and colleagues. Peter Gould and Kelly Gould for NM area.
Good morning, Mr. Gould and Ms. Gould. Albuquerque Bernalillo County Water Utility Authority, variously shortened to the Water Authority, ABCWUA, or more simply WUA.
Thank you, Mr. Examiner. Keith Herman with Stelzner, Winter, Warburton, Flores, and Dawes on behalf of ABCWA. Also, at times, we will be represented by Mrs. Nan Winter and Mr. Dal Harris.
Thank you. Good morning, Mr. Herman. Walmart.
Good morning, Jocelyn Barrett, and occasionally Randy Bartel from Montgomery and Andrews on behalf of Walmart.
Thank you, Ms. Barrett. Good morning. Ms. Barrett Capon, or do you just go by Barrett here?
Just by Barrett. I'm transitioning back to just Barrett.
Okay.
We'll show up.
Okay, thank you.
You're welcome.
I'll make that. Thank you. I'll make that correction, and I think it's reflected in the record. So, let's see. Next is Kroger.
Good morning, Kurt Boehm appearing on behalf of the Kroger Company. I'd also like to enter the appearance of Jody Kyler Cohn, and our local counsel Joseph Yar is also on the line.
Thank you, Mr. Boehm. Good morning.
Good morning.
The New Mexico Attorney General, or NMAG, or just AG, or obviously Attorney General.
Good morning, Gideon Elliott for the Attorney General's office. I may be joined by Jackie Ortiz and Serena Wheaton at times during this proceeding.
Morning, Mr. Elliott. Thank you. Sierra Club.
Good morning. This is Jason Marks appearing for the Sierra Club.
Good morning, Mr. Marks. Thank you. New Energy Economy, or NEE, and not NE.
Good morning, all. Marielle Nanasi on behalf of New Energy Economy.
Good morning, Ms. Nanasi. That was a lighthearted joke of sorts. You may use NE if you wish, but it's reflected in the record. So that's NE. NEE also goes by NEE, not KNEE, unless otherwise indicated in the record. Finally, but never lastly, Western Resource Advocates, or WRA.
Sydney Beatles for Western Resource Advocates. Good morning, commissioners, Mr. Hearing Examiners, and colleagues.
Good morning, Ms. Beatles. And finally, but never lastly, for the Commission's Utility Division staff, who appears?
Thank you, Mr. Hearing Examiner. Staff in this proceeding is represented by Bradford A. Borman, that's me, and from time to time will be represented by Gloria Regensburg as well.
Now, thank you, Mr. Gordon. Now, I'm about to get at least one hand raised because I went through the order of cross-examination, and I just recalled that there are some parties who have not requested cross-examination, and I may have skipped over some parties as well on this list who, when I did this last night, I may have missed. So let's go back to Coalition for Clean Affordable Energy, or CCAE.
Thank you, and good morning, Mr. Hearing Examiners. Good morning, commissioners, and good morning, council. Charles DeSalen representing Coalition for Clean Affordable Energy.
Thank you, Mr. DeSalen. And are you joined in this proceeding by Ms. Carol Lynch?
I should go ahead and enter appearance for her. I don't anticipate that she's going to be participating, but there's always that possibility. So Carol Lynch is my co-counsel at Coalition for Clean Affordable Energy. Thank you.
And forgive me, Mr. DeSalen, in my haste for trying to move through appearances quickly, I simply skipped over you. You're in the number 8 slot for cross-examination. Apologies.
Okay, no problem.
City of Albuquerque, Ms. Park.
Park on behalf of the city of Albuquerque.
Thank you, Ms. Park. Good morning.
Good morning. And Examiner Medeiros, I don't know if I should raise this now. I am requesting to be excused from the hearing. We did not file testimony. And I believe we can just, the city can view the hearing through the YouTube live streaming.
Okay, that's fine, and that conforms to the pre-hearing order, which indicates that only one counsel and the witness testifying per party, one counsel per party, and the witness testifying should be on the Zoom panels. So that's appropriate, and the city of Albuquerque is excused.
Thank you.
Thank you, Ms. Park. Thank you. Anybody else that I may have missed? Mr. Yar.
Good morning, Mr. Hearing Examiner. Joseph Yar on behalf of Coalition for Community Solar Access.
Oh, that's right. Okay. Same issue. You are in the 9th slot on my list here. Apologies, Mr. Yar. For that, are you jointly represented by Mr. Marks for CCSA? Or is that?
Your Honor, that was a one-time, one of the pre-hearings. I was unable to make it. It was a last-minute hearing, and so I wasn't able to make it. I requested to be excused and gave Mr. Marks the authority to act on behalf of CCSA during that one pre-hearing, but not going forward.
Great. So that was a one-off event.
Yes, yes, Your Honor.
Okay, so you're in the 9th slot. Sierra Club is 10. New Energy Economy is 11. Western Resource Advocates is 12. And staff occupies lucky slot 13 on cross-examination for clarification. Now, let's move to preliminary matters. We've already started to move in this direction already. Some of the parties have anticipated this. But I'll address right now on the record the request for excusals from portions of the hearing, which of course are subject to the procedural proviso that council and the parties are deemed to have notice of and waived their right to object to all matters addressed, resolved, and determined in their absence during the hearing per 1.2.2 32B NMAC or the Mexico Administrative Code. Who'd like to speak up first on that? Mr. Albright, did you have a request for excusal from a portion of the hearing?
Yes, sir, I did. As of right now, I have had a slight change in the original schedule of absence that I mentioned. I will not be available on Thursday for Mr. Graves or Mr. Watson, but we had not reserved any time for cross-examination for those two witnesses. Friday, I will also be unavailable again due to just prior commitments that we had made. My return to Albuquerque was scheduled for Wednesday, September 13th. That has now moved to Thursday, September 14th. So I will be available, and we do have time reserved for a cross-examine of Ms. Chan if that remains intact at this point.
Okay. All right. Thank you, Mr. Albright. You're selectively excused, of course, but bear in mind that as we discussed during the conference, you can't bank that cross-examination time. The parties may not, none of the council may take what would they, in previous cases, long ago before we started this process, and I just want to reemphasize that there is no banked cross-examination time for witnesses that you did in cross-examination in your absence. That's simply time that goes away. Of course, time that you wish to shift in real time, as Mr. Gould and I discussed off the record in the beginning, that's a different matter. Okay, thank you, Mr. Albright. Anybody else?
Understood. And just one additional thing, that I may be available for part of that time on Friday, but it's not certain at this point, Mr. Hearing Examiner, but it's certainly understood with regard to the banking of time. So,
Well, obviously, if council's plan changed, including yours, and you're back online, your excusal doesn't mean that you can't participate in that hearing. So, yeah, thank you.
appreciate
Mr.
that.
Gould?
Thank you.
Yes, as we indicated in our revised pre-hearing memorandum, my co-counsel Kelly Gould is not going to be available Monday, the 25th, or Tuesday, the 26th, due to a pre-planned trip. And in addition, we may variously be absent at sort of random times. And my co-counsel has a young son and may need to leave early to pick him up from school or other things of that nature. Do we need to give you advance notice of those sporadic absences, or can we just assume that in the normal course of business, we will be absent, and then we'll live with the with whatever rulings are made during those periods of time?
Mr. Gould, in your case, I'd like just a brief, I know with regard to, we don't need to discuss Ms. Gould being absent on the 25th and 26th, because obviously we added those 2 additional days probably well after she made plans not to be here. But if you could, just at the end of the day, if you know something that you're not going to be available for during the next day, could you just please briefly notify us?
Well, I do know that on Friday morning, I will not be available. I have a doctor's appointment.
Okay.
And
If you could,
co-counsel will be
if-
there.
that's one of the examples where Thursday close a bit near close of the hearing. You just let us know.
We will do
Appreciate it.
that. Thank you so
'Cause
much.
Thank you, sir. Ms. Peter, I have Mr. Herman first, I think. Here, at least according to Zoom, Mr. Herman.
Thank you, Mr. Examiner. I was just going to restate I might need to also have periodic absences as childcare or the hearing progresses, and I will do my best to notify you in advance as well.
Thank you, sir. Obviously, the excusals are granted, but a little advance notice in the case of, in your case as well would be helpful to us. Mr. Bain? And I'm just again, I'm going by what Zoom has up for me, because I see Ms. Beatles has, and Ms. Well, I have clapping from Mr. Yar, but these annoying Zoom.
Sorry about that, Your Honor. Sorry about that, Your Honor. I meant raised a hand.
No worries. Oh, you did? Okay. Well, it's I have 3 hands up. Let's go with Mr. Bain. I'm looking at the panels now. Apologies, folks out there.
Thank you, Mr. Hearing Examiner. The first witness that I have cross-examination for is Ms. Chan. I have I would like to just monitor the hearing until Ms. Chan is up, and I understand that I've waived my ability to weigh in on any issue that I miss. But I would request the commission's leave to appear when Ms. Chan gets up.
And yes, Mr. Bain, that's acceptable. You will be monitoring in the hearing over the YouTube stream. And we'll see you on the 13th of September, I believe. But bear in mind, if we got through the witnesses faster and Ms. Chan were available on the 12th, her cross-examination might actually start under ideal circumstances on the afternoon of the 12th, potentially. again, bear in mind, I haven't looked at all the different pre-hearing memoranda, and particularly PNMs that notes the unavailability of witnesses and tries to corral all of that. So I just want to make that point that we are hopefully going to be moving in ideal circumstances through the witnesses a little bit quicker. So if Ms. Chan starts on the 12th, you need to be aware of that.
Understood. Thank you, Your Honor.
Just as a hypothetical, for instance. Thank you, Mr. Bain. So with that, you're excused. Mr. Marks?
Thank you. Similar to Mr. Bain, with leave of the hearing examiners, I would prefer to be excused except for the days on which I'm either presenting a witness or cross-examining a witness. And that's to conserve my client's resources for matters that we're not interested in this case, or we don't think we're interested.
Well, I thought you were interested in all issues, Mr. Marks.
I am, and we may rely on other parties' cross-examination in our briefing.
Or the examiners and the commissioners' examinations, right? And bench requests. Just kidding. Just kidding. No, I wanted to ask you though, in future, could you see if you could find a better audio feed? Getting a lot of canniness, like feedback or canniness, sort of a canned vocal feed from the audio feed, excuse me.
I noticed it on mine as well, and during the break, I'll play with it and see if I can get it better. And then, Mr. Medeiros, I was on vacation last week, so I didn't participate in the pre-hearing. If things go fast, and I just want to apprise you that Monday, the 25th is Yom Kippur, so I would not be available to move my witness to that day. If things went faster and we want to move Mr. Fisher up, that would not be a day to do it.
Well, we'll say with that, I'm circling Mr. Fisher to save him for the 26th. He will be the witness probably testifying the most on that day. So if staff, Mr. Bortman, would your witnesses, one or more witnesses, be able to move up a day potentially? And it, now, in ideal circumstances, and this, I shouldn't say this because I'll probably jinx this, I was hoping to conclude on the 25th. So would if we move that quickly along, and I don't know that we will be able to, would Mr. Fisher be able to testify on Friday the 22nd?
Mr. Medeiros, I'll get that figured out and let you know.
Okay. Or on because sometimes we could move faster. Right now we're not getting off to that quick start, but you'll see we'll get jamming here pretty quickly. So and this is actually one of the things in every hearing for those out there again on the World Wide Web that in these major rate case hearings, we move witnesses around to fill slots to try and keep the hearing moving quickly and to fill time slots so that we can hopefully complete the hearing quicker than we had planned and move on to allowing the parties to brief all the many interesting issues that the commission has to consider in this case. So that's the discussion that we're having now, along with the request for excusals that we completed. So Mr. Marks, if you could, please work with Dr. Fisher actually on potentially finding another time to be cross-examined and examined if circumstances warrant. Thank you. Mr. Yar.
Thank you, Your Honor. Very similar to Mr. Marks' comments. CCSA has very limited role and issues in this case. And we request that Monday to be excused from the hearing those days where those issues are not at play. We have cross-examination of Mrs. Pitts, and our witness, Kevin Cray, is also going to be presented. So that Monday and Tuesday, we will be here, understanding that if the schedule moves around, I will be monitoring the hearing and communicating with fellow counsel and be prepared to react accordingly.
Thank you. Again, consistent with the proviso that there's a waiver of anything agreed to in your absence, CCSA is excused. Let's see, who else? I still have Mr. Mark's hand up. Did you have anything else?
No, I did not.
Okay. Thank you. Thank you. Ms. Beatles, finally, getting to you. I know Ms. Barrett has her hand up as too, but I'm going Ms. Beatles.
Thank you. If something does come up, Mr. Maderos, that requires our absence, how do you prefer to be notified? During a natural break in the hearing, verbally, or would you and Mr. Ryan prefer an email?
I would prefer a verbal, because we get so many emails that you can tell we may not have responded to everything as promptly as we would like. In this or other cases, like yesterday, the gas company LNP case, but for instance. Yes, just that, like right before a break or during a break. Yes, please, Ms. Beatles. So we have, thank you. Is there anything else? No, okay. Ms. Barrett?
Thank you, Your Honor. Similar to Mr. Marks and Mr. Yar, my clients only authorized me at this point to attend on days when I'm either cross-examining or presenting a witness. Do you want me to list out the days, the specific days that I'm asking for excusal, or is that enough information?
That's sufficient information to
and additionally,
grant your excuse. That's sufficient information to grant your excusal, subject to the rules waiver.
Okay, thank you, sir. And on the days that I am in attendance, I will need to leave at 4:15 to do a school pickup.
Okay, well, we'll do our best. Well, I can't promise that we'll be able to accommodate you on that, but we'll do our best.
Okay,
Thank you, Ms. Barrett. Anybody else? Okay, let's move to the next issue then, which is I'd like to now, as we presaged at the pre-hearing conference, move to some substantive evidentiary issues. And the first is I'd like to obtain the parties' positions. We, the commission, would like to obtain the parties' positions on the 75 exhibits for which the hearing examiners have taken administrative notice on the Four Corners power plant issue of prudence. And of course, those rulings are contained in the September 1st, 2023 hearing examiner's notice of taking administrative notice of portions of the record in case number 16-00276-UT, and as reflected in a transcript of the pre-hearing conference held August 31, 2023. That was held in this case last week. And that's set forth in the transcript. The version that I have has it set forth at pages 216, line 4 through 242, line 9, for those following closely. PNM, what's your position?
Yes, Mr. Hearing Examiner, thank you very much. Rick Alvidrez for PNM. As you know, there's quite a voluminous amount of materials that you are proposing to seek administrative notice of. We have certainly started the review process. There have been some tweaks that occurred as early as this morning, I guess, as to some of the exhibits. What we would ask is
Who did them early this morning? I did them yesterday and put them in the order.
Okay,
And then
well,
footnote.
I'd understood there were changes. I thought it was this morning, maybe it was last evening, but in
Well,
any case.
it would have been yesterday afternoon, Mr. Alvidrez, because that's when I got the order out, and that I can show you where that is in the order, but it's specifically, it's the Van Winkle direct testimony. And there was where I took out something that was which was irrelevant. And then there was another exhibit that was potentially missing some pages, but it's in the footnote, one of the footnotes. So for reference, go ahead.
Well, I think I became aware of it this morning. In any case, what I would like to ask is your indulgence to give us one more day to carefully review what you have presented, and particularly in the order now in which it's been provided. Originally, we had a number of documents, but without any corresponding exhibit numbers to them. And we just asked for another 24 hours to review them and to present our position on them. That's all, just a bit more time.
I'll grant you and the other parties, I'll move off this issue and I'll start tomorrow morning on the polling of that issue. That's fine.
Thank you.
Is there any objection to that approach? Probably not. But Mr. Alvidrez, any suggestion that it was foisted on you this morning would have been inaccurate, and that's why I sort of jumped in to emphasize that we got the order out as expeditiously as possible under the circumstances. And there are lots of circumstances going on that I won't get into. Thank you.
Thank you for the clarification.
Thank you. So we'll skip over that. I will be coming back to all the parties on that tomorrow, but to the extent that there are any changes in there, and also bear in mind, I'd like to, in relation to this, I also issued an order yesterday that sets out a numbering convention or numbering format for separating the commission administrative notice or AN exhibits, those 75 exhibits. And I'd like to get the parties' input on whether that numbering convention or formatting convention that Ms. Nanazi expressly requested in an email, and we reacted to by actually issuing a hopefully helpful order, sets out the examples of formatting for citing those 75 exhibits in briefing. I'll get the parties' positions on that numbering convention tomorrow as well, in conjunction with this particular issue on reviewing and getting the parties' positions on those 75 exhibits. Anything else on that issue of prudence with Four Corners? Okay, let's then move to the rulings on New Mexico area's motions to strike portions of the rebuttal testimonies of Stella Chan and Abraham Casas in the first motion, and Nicholas Phillips in the second contemporaneously filed motion to strike. PNM filed responses in opposition, and the hearing examiners entertained oral argument on the motions during the August 31, 2023 pre-hearing conference. Having reviewed the pleadings and considered the oral arguments, the hearing examiners conclude and determine that both motions should be denied for, among other reasons, grounds articulated in PNM's responses and asserted in oral argument. While this brief oral ruling just issued certainly is sufficiently sound from a legal perspective and should speak for itself, the hearing examiners nevertheless are endeavoring to issue written rulings on both motions to strike in an order to be issued sometime during the course of this hearing. Give a pause to see if there's any reaction to that. I've heard none, so I think the hearing examiners have made themselves clear on those motions to strike and their rulings. Are there any other preliminary matters? I'm looking at the panels. Very well then. Seeing no other preliminary matters. let's
Mr. Hearing
proceed to-
Examiner, I'm sorry, I do have
That's
a
slightly
preliminary.
late. But go
I-
ahead.
We would like,
We do have the Zoom delay. Go ahead.
okay. We would like to adjust our cross-exam times for today and tomorrow, if we could.
Let's go ahead and do that now.
We have 60 minutes scheduled for Mr. Monroy. We'd like to move 30 minutes from Kyle Sanders, which would
I'm
result
sorry,
in
30 minutes from home?
Kyle Sanders, who is the witness tomorrow. We had scheduled 90 minutes for Mr. Sanders. So that would mean 90 minutes for Mr. Monroy. And then we'd like to move an additional 30 minutes from Mr. Sanders
Well, hold on.
to Mr. Heffington.
So, okay, I have 90. What does that leave you with Sanders?
30 minutes.
Okay, and then I've got now 90 for Monroy, and how much to Heffington?
Heffington would change from 30 to 60.
60. All right, done. Anybody else for the next 2 days? Mr. Nazi? Please unmute yourself, ma'am.
Excuse me. This is Marion Lanassi. I would like to delete 20 minutes from Mr. Phillips and 5 minutes from Mr. Heffington. That means I would have no minutes with Mr. Phillips, and I would have 15 minutes with Mr. Heffington. And I'd like to add that 25 minutes to Mr. Monroy, giving me a total of 55 minutes.
All right, let's go through your minutes now that you've changed. I want to make sure I get this right, because I often, as I go along, I'm thinking of other things because I'm trying to move the hearing along, or thinking about questions I'm going to ask myself. And I tend to get sidetracked with this, as you know. So I'm going to go through just to make sure I have New Mexico areas again. 90 for Monroy, 60 for Heffington, and now, what did you say? 30 for Sanders. Is that right, Mr. Gould? Okay.
That's accurate.
Now, thank you. New energy economy, 55 with Monroy. What else was changed, Mr. Nazi?
0 for Phillips.
0 for Phillips. Okay.
And instead of 20 for Heffington, 15.
15 for Heffington. Okay. 55. I'm just stating the changes for the record. 55 for Mr. Monroy, 55 minutes. 15 for Heffington, and now 0 for Phillips. Is that correct?
Yes, sir.
Thank you, Mr. Nazi. Anybody
Thank
else?
you.
Anybody else? Great. Okay. And again, for folks out there, this will change as we go along in real time. So if there are no other preliminary matters, let's proceed to the presentation of evidence. Pursuant to 1.2.233B of the New Mexico Administrative Code, the order of presentation and receipt of evidence starts in this case with the applicant, PNM, who is followed according to the order of witnesses set in the September 4th pre-hearing order. But it should be noted that, consistent with long-established legal evidentiary principles, the burden of going forward with the evidence and proving the merits of the relief requested in the application by a preponderance of the evidence, not substantial evidence, but a preponderance of the evidence, is with the applicant, PNM. Consequently, Mr. Alvidrez, would PNM please call its first witness?
Yes, Mr. Hearing Examiner, we do have a couple of preliminary exhibits before we get into the pre-file testimony that we would like to take up. And specifically, what we marked as PNM Exhibit 1 is the cover letter, executive summary, PNM's application, the proposed customer notice and advice notice 595, that's all encompassed in P&M Exhibit 1. We
Yes.
would move that into evidence.
Is there any objection? Hearing none, P&M Exhibit 1 is admitted.
And in a similar vein, P&M Exhibit 2 is the P&M Notice of Proceeding as issued and approved by the hearing examiners in this case, and as was duly published. We would like to move the admission of P&M Exhibit 2 into evidence as well.
Is there any objection? While it's unnecessary to put it in the record because it's already in the record, nevertheless, P&M Exhibit 2, the notice is admitted.
And then finally, P&M Exhibit 3 are the P&M 530 schedules A through Q, including the errata that were submitted during the course of the proceeding. These are all supported individually by the various witnesses in the case, but we have them assembled as a package as Exhibit 3 and would seek their admission into the record as well.
Any objection to P&M Exhibit 3, B530, A through Q, and errata? Hearing none, P&M Exhibit 3 is admitted as well.
And with that, Your Honor, we would call our first witness, Henry Monroy.
Mr. Monroy, are you ready to be sworn?
Yes, sir. Good morning.
Good morning, sir.
Mr. Monroy, would you raise your right hand? Please. You solemnly swear the testimony you're about to give in the matter of opinion to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Good morning, Mr. Monroy. Can you state your name, employer, and position for the record?
My name is Henry Monroy. I serve as Vice President, Corporate Controller, and Regulatory for Public Service Company of New Mexico.
And Mr. Monroy, did you prepare direct testimony that was submitted on December 5th in this case?
Yes, sir, I did.
And can you confirm that P&M Exhibit 4 is that direct testimony?
Yes, sir, it is.
And does P&M Exhibit 4 include the errata that were submitted with respect to your direct testimony in this case?
Yes, sir.
And is your direct testimony true and correct to the best of your knowledge and belief?
Yes, it is.
Mr. Hearing Examiner, we move the admission of P&M Exhibit 4, direct testimony of Henry Monroy.
Is there any objection? Hearing none, P&M Exhibit 4 is admitted.
And Mr. Monroy, did you prepare supplemental testimony dated January 27, 2023 that we've marked as P&M Exhibit 5?
Yes, sir.
And is that testimony true and correct to the best of your knowledge and belief?
Yes, it is.
Mr. Hearing Examiner, we move the admission of P&M Exhibit 5.
Is there any objection to P&M Exhibit 5? Hearing none, P&M 5 is admitted.
And Mr. Monroy, moving on to P&M Exhibit 6, can you confirm for us that that is your rebuttal testimony that was filed in this case?
Yes, it is.
And do you have any corrections that have not previously been indicated in any errata filing?
Yes, sir. I do have one correction.
And can you take us through your correction in terms of page and line number?
Yes, on page 10, line 15, the words units 1 and 2 should be added after PVNGS.
Thank you. So with the correction that you just noted for the record, is your testimony as set forth in P&M Exhibit 6 true and correct?
Yes, sir.
Mr. Examiner, we move P&M Exhibit 6 in evidence.
Is that correction, Mr. Alvidrez, included in the Dropbox folder version of Mr. Monroy's rebuttal testimony?
It is, Your Honor.
Okay, thank you. Any objection? P&M Exhibit 6 is admitted.
And thank you, Your Honor. With that, Mr. Monroy is ready for cross-examination.
All right, let's start the cross-examination of our first witness with, I'm opening my apps here so I can start the time clock with Mr. Albright, who has, I believe, 20 minutes with this witness, with Mr. Monroy. Mr. Albright, are you ready?
I am, Mr. Hearing Examiner.
Great, you're on the clock. Please proceed.
Thank you. Good morning, Mr. Monroy.
Morning, Mr. Albright.
My name is Jeff Albright with J. Albright Law LLC, and I'm here on behalf of Bernalillo County this morning. I do have some questions starting off with the P&M Exhibit 4, your direct testimony. And specifically at page 2 to start off with, at lines 17 through 22, the question is posed, what is the monthly bill impact to an average residential customer as a result of the proposed revenue increase and other projected charges? Do you see that question?
Yes, sir.
And your answer talks about the average residential customer's total monthly bill. How do you define the average residential customer?
Sure. So for these purposes, the average residential bill that I use is a residential customer that on average uses 600 kWh per month.
And when you say average, is that based upon use, or is that based upon how much energy they use, or how much electricity they use, or what forms the 600 as the metric?
Yes, 600 kWh is the consumption.
Okay, and is that consumption an average of all users, or is it just for a particular rate class?
It's the average for the residential class.
I'd like you to turn to page 6 of the same testimony, direct testimony. Toward the end of the first question there, lines basically 15 through 17 or through 18, you state that the average residential bill impact stated earlier of 0.8% reflects the projected first year impacts from the rider proposed under the grid mod plan. Do you see that?
Yes, sir. And just I believe that 0.8 was corrected to 0.9% in an errata.
Okay, thank you for that. I had overlooked that, so thank you for that. How many riders are included on the average customer's bill? Do you know?
For purposes of the bill impact that we quantified for this, we include the P&M's fuel and purchase power cost adjustment clause. We included the renewable energy rider. We included the energy efficiency rider, the transportation electrification program rider, the proposed grid mod rider that's pending approval from the commission, as well as the ETC or energy transition charge that's anticipated. And so I would point out that not all of those are currently on the bill, but those are what's included in the bill impact that we provided to the commission in this case.
And which ones of those are not yet included in the bill?
The grid modernization rider and the ETC charge, and I'm not 100% sure if the TEP is on customers' bills yet. I do not believe so, but I'd be subject to check.
Returning to page 5, we talk about the beginning around line 5 about the increase in P&M's allowed rate of return, allowed return on equity to 10.25% in order to attract shareholder funding for our capital investment program, which is largely offset by a reduction in PNM's weighted average cost of debt since the 2016 rate case. Do you see that?
Yes, sir.
Isn't it true that for the year 2022, that PNM's ROE was in excess of the 9.575 that was authorized by the commission?
That is correct. In 2022, PNM's earned return based on actual results exceeded the 9.575% return. Based on protections included in the renewable energy rider, PNM is allowed to earn the 9.575 plus 50 basis points. Anything above and beyond that is required to be returned to customers. And that amount, that excess earnings was returned to customers through the renewable energy rider beginning this year.
Would you turn to page 9 of your direct testimony, please? You there, Mr. Monroy?
I'm there, thank you.
Okay, under the question, why is it important to address revenue shortfalls? You respond in part that PNM cannot attract the capital at favorable rates that are needed over the next several years to fund capital projects. Do you see that?
Yes, sir.
So what capital projects are needed that are not being funded because there are limitations on existing rates?
So, Mr. Albright, as you're aware, PNM is filing for a future test year. And so this is to set rates for the period under which rates will be effective beginning January of 2024. And so the revenue request or revenue deficiency is referring to the revenues needed to provide or to meet its cost of service to its customers to provide service for those. And that includes funding for the capital projects that are included in the test period, as well as the requested operating expenses in the cost of service study.
And Mr. Monroy, I think we have as Exhibit J, or at least just for discussion purposes. Let me make sure I have the date right. That PNM filed a notification of Class 1 transaction pursuant to 17.6.450.11, parent A and parent NMAC. And the date of that report was August 29, 2023. Do you recall having signed that?
Give me 1 second. I was looking for Exhibit J. I apologize.
That's all right. I think it was a late addition with regard to the potential cross-examination questions that we had.
Okay, yes, I'm sorry. I have it in front of me now.
It's
Could
the
you ask the question
notification.
again? I apologize.
Yes, it's notification of Class 1 transaction pursuant to 17.6.450.11, parent A and parent NMAC, correct?
Yes, sir.
And you signed that, I believe, with regard to the certification of the formation, correct?
Correct.
And the certification was for PNM Energy Transition Bond Company. I assume that's category 1, LLC, correct?
Yes, sir.
And so with that formation, did your evaluation, and for that matter, maybe you can tell me or not, Mr. Sanders' evaluation, strike that. Let me ask another question. And PNM is the sole member of this LLC, correct?
Yes, I believe that is correct.
It states under the background, it says PNM is the sole member of LLC. I just wanted to confirm that.
Yes.
And so were any of the transactional costs associated with the formation? Is that going to mean an increase or decrease in the revenue requirement for PNM?
So the PNM Energy Transition Bond Company 1 LLC is the SPE or special purpose entity to begin the process for securitization, to issue securitization bonds. Those costs associated with the SPE are all captured within the energy transition charge itself as initial costs. And so they do not impact PNM's revenue requirement as for the 2024 test period.
Okay, so let me make sure I understand. So if those bonds get issued, say, this coming, in the next couple of months, and it's true that isn't it true that 100% of the securitization is paid for by customers, correct?
That is correct. They'll be charged through the energy transition charge, which is a separate charge from the rates that we are proposing to set in this proceeding.
Okay. And so those costs would apply whether PNM is doing it or whether some other company is doing the bond issuance, correct?
I'm sorry, what costs are you specifically referring to?
Just the transaction costs of handling and processing the bonds, of issuing the bonds, those types of things. Will that be done through the LLC?
The LLC was formed for the purpose of having the special purpose entity that is bankruptcy remote and protected once the bonds are issued. PNM itself will be preparing the transaction, working with banks and things of that nature.
And in preparing the transaction, are there any costs associated with that?
There might be incremental costs. I think probably PNM witness Greinel is probably a better witness to ask those questions as she's closer to the transaction than I am. But as I stated, at least in the revenue requirements that we've proposed in this case, there are no transactional costs associated with issuing the bonds in this proceeding.
Okay, so that's neither a revenue, additional revenue that you need from customers, nor an impact on your overall revenue requirement. Is that what you're saying?
That's right. In the cost of service study, the costs associated with securitization in that transaction are not included.
Okay, thank you for that.
You're welcome.
Turning back to your direct. I'm sorry, Mr. Lee, are you?
Yes, sir, I'm here. Go ahead. Turn
Okay,
back to your direct.
In turning back to your direct testimony at page 10, you discussed the time of day pilot, the TOD pilot. Do you see that?
Yes, sir.
And you state in lines 7 through 10 that the TOD pilot is designed to get customer feedback on incentivizing changes, customer behavior regarding energy usage through price signals during peak load periods. Do you see that?
Yes, sir.
How much of an impact do you believe that will have with regard to the rate design? Or is that a better question asked for Ms. Chan?
I believe that's a better question asked for Ms. Chan or even Dr. Pitts.
Okay. Would you turn to page 12, please? Again, still on your direct testimony.
Yes, sir.
In lines roughly 4 through 8, you speak of the Energy Transition Act to transition the state to 100% carbon-free energy generation by 2025. Do you see that?
I believe it's 2045.
I'm sorry, 2045. I misspoke.
Yes, sir.
And then you follow that and state the PNM's goal is to be carbon-free by 2040, as we believe this transition provides financial and environmental benefits to our customers. Is that a correct reading?
Yes, sir.
Your statement? Doesn't that also provide financial benefits to PNM and to PNM investors or shareholders by reducing the time but increasing what would normally be, we'll say in some cases, amortized or at least spread to 2045? Doesn't that increase the amount of revenue that gets collected from customers with going carbon free by 2040?
I'm not sure I quite follow what exact costs you're actually referring. And so I'm not sure what you're saying would be actually increasing for revenues for shareholders. I will point out here, actually shortening the terminal lives of the gas plants actually increases the annual depreciation costs from customers, which will lower the undepreciated investment of these facilities that are included in rate base. So as that, and just as a distinct item there, that will actually increase revenues that we need to collect. It reduces the amount of rate base that we include in rate base for a return on.
So it does increase revenues. Doesn't it also increase the likelihood of having additional stranded costs that aren't recovered? Well, that would only be recovered from either PNM shareholders and customers, or customers only under the ETA.
I'm not sure why you're getting an assumption of stranded costs. PNM's proposal in this case is to shorten the terminal dates to minimize those stranded costs by the time we hit our goal of 2040. And so this would actually, our proposal would actually help reduce the potential for stranded costs at that time.
With regard to some of the facilities.
Mr. Albright, you have
Yes.
3 minutes. I'm sorry. I'd like to give you a 5-minute warning, but I didn't want to interrupt you, but you have about 3 minutes left.
Thank you. I may move on. I still have some questions on that, but the 2040, would that call for early retirement of some of the gas generation plants?
As we stated in this case, we are reflecting to shorten the terminal dates of certain gas facilities that currently have a terminal date beyond 2040. And that reflects for the Afton, which currently has a 2042, so shortening of 2 years. Lordsburg plant of 2042 for 2 years. Our La Luz generating plant that has a 2055, so shortening that of 15 years. And for our Luna generating facility of 2046, shortening that by 6 years as well.
And so by shortening that, either why wouldn't there be stranded costs if you're terminating those plants early? How do you compensate for the potential of having stranded costs with those gas plants?
So the purpose of the depreciation rate of which we set, the service life or the terminal life, is a key input in setting those rates. And so by establishing a terminal date that reflects the period over which we expect to use those assets, in this case through 2040, that will increase the depreciation rate, which will lower the likelihood of stranded costs, as we will fully depreciate those, those investments basically from the period now through 2040 to try to minimize those stranded costs.
Now, I'm looking at your rebuttal testimony that you have, and I'm looking at page 7, where you talk about depreciation expense. And you talk about seeking to adjust the service life of its, at page 7, as service life of its gas generation fleet so that these plants are fully depreciated by 2040. Doesn't that necessarily, if you're going to fully depreciate, mean that you're going to have to recover those costs in some manner before the expected life expectancy ends for those?
So the depreciation rate is designed to recover the assets over the period under which they're providing service. So we will be recovering those assets over the next 16, 17 years.
Okay, that's the pause that I was waiting for, Mr. Albright. That concludes your cross-examination unless you want to take time from another witness.
No, Mr. Hearing Examiner, I do have some other questions, but I think I'll reserve them for other witnesses as well. Thank you, Mr. Monroy. I appreciate your answers and your explanations. Thank you, Mr.
Albright.
Great. Okay. Thank
Mr.
you.
Maderos, I'd like to ask some just quick follow-up question for clarity from the witness. It was a subject that Mr. Albright addressed. And I'm not sure I understood the answer, and I want to ask about that real quickly.
Hearing examiner Ryan, you don't need to ask me. This is
Sure.
your hearing. This is the time.
I'm
Go
just
ahead.
more queuing in so we're on the same page. Mr. Monroy, Mr. Albright directed
And
you.
you're not on the timer, by the way.
Yeah. Mr. Albright directed you some testimony that I'm glad he did because I found it a little confusing too. At page 6 of your direct, beginning at line 16, it says, the average residential bill impact stated earlier of 0.8% reflects the projected first-year impacts from the rider proposed under the grid mod plan. I read that and thought, okay, well, so you basically, and I'm the assigned hearing examiner to the grid mod plan. So what my understanding of that sentence was, well, we looked at what the additional cost will be as a consequence of the grid mod rider, and then we tacked that onto the request for increase in revenues we're asking from the residential class here. And that's what the number we come to. Am I misunderstanding what you wrote there?
No, Mr. Hearing Examiner, I think that's correct. I just want to make sure we're clear. Where we included it was to provide an all-in bill impact that residential customer would expect to see beginning in 2024. And so it's included in the 0.9% bill impact calculation. However, the actual revenues and collection of the grid mod riders are not included in this proceeding. And so they're not subject to the revenue requirement that we filed. And so where we included it for a bill impact perspective, so customers, assuming the grid mod fund had been approved, customers would have an idea of what their total bill may look like in 2024 as a result of applications or requests outside of this general rate case.
Okay, so I'm not trying to ask a yes or no question, but just so the 0.9 is the revenue request increase here plus the grid mod rider, or no?
Yes, that is correct. Plus also, for example, the ETC energy transition charge that was anticipated to begin in 2024.
That 0.9% incorporates that revenue request increase.
Yes, sir, for those two riders, that is correct.
All right, so then at page 13, and this is where I got confused, if you go over to 13, you give a fairly clear statement there of all the things that are not included. And I just want you to clarify this. So at beginning of line 16, the requested annual non-fuel based revenue does not reflect certain charges and riders the commission sets in other proceedings, including annual energy efficiency, transportation electrification, ETC, that they'll begin paying once SJGS bonds are issued, and the grid mod rider. So just help me understand what are you saying? And that just seems inconsistent with what you just told me. And I just want to make sure I understand what these words mean.
Sure. So in this case, we're requesting the commission to set our non-fuel based rates. And that is provided in the notice on a system basis is an 8.77% increase to the component of the customer's bills reflected in non-fuel based rates. So that is what this proceeding is here for purposes of a bill impact to customers of what they may expect to see in 2024. PNM acknowledges that there will be other changes on a customer's bills besides their non-fuel based rate that are on their customer bills. So this case is seeking approval to change the non-fuel based rates on customers that they're paying, so the tariffed rates. And so that's what is the 8.77%. However, take into account all additional riders or changes in riders that are also on customer bills that are not subject to this proceeding, P&M felt it was important for the commission and our customers to have a holistic picture of all the changes that potentially would be coming onto their bills in 2024.
And that is 0.9%.
That is the all-in bill impact for an average residential customer monthly bill.
Of 9%.
So I apologize then. So for their base, for the rates on a customer bill, that's reflective of their base rate. So their customer charge, their energy charge for residential 1A, that based on our banding is a 9.65% increase to that component of the customer's bills.
Okay. And just one final follow-up on that one. Have you looked at, or does PNM know, if you were to factor in the settlement agreement that is being proposed by these parties, the parties in this case, well, it's the parties in the other case, the San Juan settlement thing that's going on right now, do you know what that does in terms of customer bills? I mean, in light of this, you're asking for a rate increase here, and then you've proposed in this other case to settle that matter and then refund the customers some monies. Does PNM know what the net of that is?
I have not done that calc. I believe, and this is subject to check, but I believe for an average residential customer bill, they will see, I believe, a $10 or $11 credit per month for 1 year, depending upon the terms of that settlement.
And so 10 or 11 before whatever increases are here, or after?
That $10 or $11 is reflective of the bill impact for the credit that's proposed in that settlement. And so it would be a further reduction to these numbers here. So right now we are projecting a bill impact of 0.9%. That obviously would go negative in 2024. It would be a reduction to that.
And have you made those I'm going to, this again, for folks out there, this is the way these hearings work. Well, the hearing examiners and the commissioners are really active questioners. And sometimes they even team up and maybe annoy hearing examiner Ryan, but as the case may be, I'm going to do it anyway. Have you made those calculations?
Mr. Herring,
go ahead. I think you anticipate my question.
All right, Mr. Hearing Examiner, we have quantified those. I believe, I don't have them with me. I know PNM Witness Chan can provide those, or I could, at least for the average residential customer. I know that, I remember that calculation was estimated or performed. I just don't have that with me.
Has the company, Ms. Chan, or yourself, or anybody in the company, performed those calculations for all customer classes?
I believe if they haven't, they're being prepared, but that Ms. Chan would be able to explain that. Or I believe by the time Ms. Chan testifies, we could definitely have that information if that is of interest, Mr. Hearing Examiner.
And for folks out there, this again is something that you'll see through the hearing. This is the first bench request of PNM. Bench request number one, the calculation of the impact of the San Juan rate credit settlement on all customer class bills. When do you think, don't need to provide it right away, but whenever the company can get around to providing it during the course of this hearing, hopefully soon. Is that okay, Mr. Monroy?
Yes, Mr. Hearing Examiner, that's not of concern. Is it acceptable to have it by when Ms. Chan testifies, as she'll be doing the calculations, or do you want it
That's
soon?
That's acceptable to me. Hearing Examiner Ryan, is that okay with you?
Yeah, I think that'll work.
All right, bench request one is issued to PNM. And again, to follow up on the discussion tomorrow morning about conventions of format of commission exhibits, that bench request may be the first. It may not be, but it may be the first commission exhibit, which would be labeled Commission Exhibit 1, if that bench request is admitted into evidence. That's to be distinguished from the Commission AN exhibits, which relate to the issue of prudence.
Mr. Monroy, just following up on that point about Ms. Chan doing it. I mean, she's sort of far down on the roster. I suppose that what would be the most desirable would be, you know, I understand you need time. That's completely understandable. If you can get it to us before she testifies, great. Is that acceptable?
Understood, Mr. Hearing Examiner.
As soon as you're able is effectively, and I see hands going up, but I'll return it to Mr. Maderos to lead that discussion.
What do we have on that, Mr. Gould?
Yes, Mr. Hearing Examiner, we have cross-examination of PNM witness Stella Chan on Wednesday, the 13th. And this clearly is going to impact our cross. So if, you know, with all due respect, I know everyone is hugely busy, and I know Mr. Monroy, you know, being the lead witness, is hugely busy. But if we could have that by end of the day on September 11th, that'll at least give us a day to see if we need to address some, to adjust some of our cross questions. Thank you.
Mr. Monroy, would it take that long to have it by Friday, September 8th? Would it be that laborious?
I do not believe that would be an issue. If maybe perhaps after a break, I could just confirm that I'm not committing Ms. Chan to something she doesn't feel is uncomfortable, but I don't see why that would be an issue either.
We're going to make the bench request due either September 8th if Ms. Chan is able, otherwise September 11th if she needs the additional time over the weekend. But I should always put a time deadline for these bench requests and not leave it open-ended. I'm just trying to accommodate the company because we tend to ask a lot of bench requests to the parties. And so I'm mindful of that. But so either September 8th if she's able, otherwise September 11th. Thank you.
Thank you.
Anybody else? Mr. Albright, you had your hand up. Did that answer the question?
Yes, yes, sir, it did. Thank you.
Okay, thank you. All right, go ahead, Mr. Ryan.
Oh, that's all the questions I have for Mr. Monroy at the moment. There'll be others, but Mr. Albright brought us to a subject I wanted to ask about since it came up.
Okay, so since we opened up the hearing, the questioning by the hearing examiners on this particular discrete set of issues, Commissioner Ellison or Commissioner Aguilera, do you have any questions for Mr. Monroy on this particular set of issues that we were just discussing?
Not at this time, thank you.
I do not either. Thank you.
All right. Thank you, commissioners. All right. Then next up is Mexico area. We are at almost 10:30. So I suggest that Mr. Gould is up next with 90 minutes. So let's take our mid-morning break and come back at 10:45. Does that work for you, Mr. Gould?
Yes, sir.
Mr. Monroy?
Yes, sir.
All right. We are in recess until 10:45 a.m. Thank you.
Thank you.
And please remember that that we are broadcasting live here, so be sure to stop your video and mute yourself.
Mr. Gould. And
Yes.
parties. And all parties. We began again, I noticed that the timer that is built into Zoom now, I can't take it off my panel. Is that going to be annoying to council if that timer stays on there? And should I use my Mac timer that I can take off, or do you prefer to keep it on there? And just leave that open, because I was used to be able to remove it and then put it back on with, say, 5 minutes. Is it all right with the parties if it stays on?
I found it actually helpful. So,
Okay.
you know,
Okay.
it's, you know, it's there, it's unobtrusive, so.
All right, then. If there's no objection, then I will leave the timer in the little corner of my panel over here. Great. Well, we are back from our first morning break in this PNM rate case hearing. Mr. Gould for New Mexico area is up next in cross-examination of Mr. Monroy, and he has 90 minutes slated. So we're going to have to break up your cross-examination. I'd like to go till noon. But if you need to go a little bit longer, we can break up your cross-examination that way as well. Mr. Gould, I want it to be a natural progression for you, but let's shoot for thinking about our lunch break at noon if that's possible. Or a
That
little
would
bit
be-
after.
Yeah, that would be fine. And if I come to a natural break, like 10 minutes before, you know, I'll indicate that and maybe we can. So even if we break it up middle of a line across, I don't think that'll be a problem. This is, you know, we'll just accommodate. Really, I understand we need to stay on a schedule and we need to have our breaks at regular times so everybody can count on them.
Most importantly, Mr. Lee.
Mr. Lee's the
So-
man, I tell you.
He is the man. We are blessed. We are truly blessed to have him.
Well, a lot of
So,
us can kind of zone out and he can't. So anyway, I don't know how he does it, but he is excellent. Anyway.
Thank you for that acclamation. So let's go ahead and start your cross-examination. You have 1 hour and 30 minutes, correct?
Yes, I did. Thank you so much.
You're welcome.
And good morning, Mr. Monroy. How are you doing today?
Good morning, Mr. Gould. How are you?
Good. Before I start the line of cross-examination that I was going to get into, I wanted to kind of cast back and ask you a couple of questions about the issue that Jeff Albright raised, having to do with the ROE testimony on page 5, line 6. You had given him an answer, but I didn't believe you completed it. I would like to know what the actual earned ROE was for PNM in the base year of not the base year, but in the calendar year of 2022, if you have that in front of you.
So I don't have it in front of me. I know the amount of the refund was approximately $1.8 million pre-tax. And so if our authorized ROE was 9.575 plus 50 basis points, that'd be 10.075. So then my subject to check, I think it'd probably be around 10.1, but
Okay.
I don't have that number. I know the amount of the excess revenues collected was 1.8 million that we returned.
Okay. And if you know, can you tell me the highest ROE that the commission has approved in the last 5 years for an electric investor-owned utility?
This commission, the New Mexico
Yes,
Commission,
this commission.
I don't know in the last 5 years. I don't
Would
have
you
it in-
agree with me? Would you agree with me that the 9.575 that is currently approved for P&M is the highest, or at least the second highest in the state?
Subject to check. I have no reason to doubt you, Mr. Gould.
Okay. Okay, let's move on to the questions. You stated in response to your attorney that you are Vice President of Regulatory. Do you recall that testimony?
Yes, sir.
And that is on the first page of your direct, that statement as well. In that role, you're the one P&M witness that has overall responsibility for P&M's filing in this case, are you not?
Yes, sir. That is correct.
Okay. And just to kind of confirm that, on pages 14 through 18 of your direct, you introduce in a summary fashion all the other P&M witnesses, do you not?
Yes, sir, I do.
And then on pages 25 to 31, you list a host of commission rules that you testify P&M is in compliance with. Is that an accurate statement?
Yes, sir. Sorry.
And then moving on to pages 31 to 42 of your direct, you list a whole number of cases whose final orders, P&M cases at the Public Regulation Commission that your company is in compliance with. Isn't that correct?
Yes, sir, that's correct.
And then your exhibit HEM2 contains 40 pages where you address compliance with a host of prior PRC orders as well. Is that a fair statement?
Correct. P&M exhibit HEM-2 is our annual compliance filing we make with the commission.
Okay. And then on page 45 through 46, you basically state in a summary fashion that all the rates that P&M is asking for approval in this case are just and reasonable. Is that still your testimony?
Yes, sir.
Okay, so I might be jumping around and asking you at a high level to comment on some of the other witnesses, their testimony in this case, but I'm doing it in the context of you as the lead witness. And if I go into a detail that you're not able to address, just please tell me that. Is that a fair agreement?
Understood. Thank you.
Okay. And then if I ask you about a compliance with a commission rule, compliance with a prior order, compliance with the Public Utility Act or the Energy Transition Act, I just want it understood from the get-go that I'm not asking you as an attorney because you're not a licensed attorney, are you?
No, sir, I am not.
Okay, if I ask those questions, I'm asking based on your experience, your 20-year experience with the company and your current position as VP of Regulatory. Is that a fair agreement?
Understood. I will answer to the best of my knowledge.
Okay. What role did you have in overall review of the witness testimony in this case?
So I reviewed all testimony as written. So I reviewed all testimony. I reviewed outlines of testimony. I guess before the testimony was written, reviewed outlines of testimony. And then as testimony drafts were prepared, probably around the second draft of testimonies for most witnesses, I would start reviewing and reading their testimonies. I'm not sure I read through every exhibit that every witness filed or every 530 schedule, but at least through the testimonies.
So if a witness articulates a policy position in their testimony, have you gone through and ensured just as a general matter, that policy statement is consistent with the company's policy on that issue?
I have read all the positions that we filed in this position and do support them as the P&M's position in this case. Yes, sir.
Okay. Do you have available to you the Dropbox that includes the Enameria exhibits?
Well, I do have a folder on my computer, so let's see where we're going. I think I do.
Sure. Why don't you upload that folder and then we'll just kind of take it from there.
So I have
And
a
Mr.
folder that says cross-examination exhibits and then NMRA exhibits. So cross-examination exhibits or
Yes.
which one?
Cross-exam exhibits, and specifically, I would like you to turn to Anameria cross-exam exhibit number 22. We're just to make sure we're all on the same page. That is the electric utility cost allocation manual that is produced by the National Association of Regulatory Utility Commissioners.
Yes, sir. I'm able to pull it up.
Can you turn to page 12 of that document?
Is it PDF page 12 or is it the actual page 12?
The actual page 12, it's the page where chapter 2 begins.
Yes, sir. I'm there.
Okay. Are you familiar, and I'll use the common nomenclature. The National Association of Regulatory Utility Commissioners is generally referred to NARUC. Is that your understanding?
Yes, sir. Did you freeze? Or am I frozen?
You're not frozen. It's possible Mr. Gould is.
Okay.
Oh, there he goes.
Maybe both of us are. It's been awful cold at my house. No, bad joke. So are we, can you hear me now?
Yes, sir.
Okay. Do you see item number 1, cost of service studies in the regulatory process?
Yes, sir.
Would you read that first paragraph beginning with cost of service studies into the record, please?
Cost of service studies are among the basic tools of rate making. While opinions vary on the appropriate methodologies to be used to perform cost studies, few analysts seriously question the standard that service should be provided at cost. Non-cost concepts and principles often modify the cost of service standard, but it remains the primary criterion for the reasonableness of rates.
And then down further on that page, there's some bullet points, and they basically state that the use of cost studies is used to attribute costs to different categories of customers based on how those customers cause costs to be incurred. You see that?
Mr. Hearing Examiner, I have an objection.
And it is, Mr. Alvidrez?
Yes, there's been no foundation laid with respect to this exhibit, and the witness hasn't expressed any familiarity with it. We don't know if it's the latest edition or really anything about the exhibit. At least I don't at this juncture. So I object to the line of questioning until a foundation has been laid over the exhibit.
All right, for future reference, Mr. Alvidrez, it'd be advisable to lodge that objection before your witness has already started reading from the exhibit.
I wanted to see where we were going, and now that I see we're just reading from the exhibit, I'm making my objection.
Fair enough. Mr. Gould.
Let me go back then. Yeah.
Lay the foundation, please.
Okay. Mr. Monroy, are you familiar with the NARUC cost allocation manual?
I've never read this before.
Okay, so you don't recognize the NARUC cost allocation manual as the standard in the rate making field?
I didn't say that. All I said is I've just never read this document itself.
Okay.
Did
Well, let me
Mr. Gould,
ask
did
you-
you say, wait, did you say
Go ahead.
the standard or a standard?
I said the standard, but either a standard is.
I don't think the standard would be accurate. There are lots of standards, aren't
Okay.
there?
Do you, let me re-ask the question then with that correction. Mr. Monroy, do you understand that the NARUC cost allocation manual is a recognized standard for cost allocation in the electric industry?
As I stated, I don't really have a basis, not having read this NARUC cost allocation manual myself. So I don't really have a basis for opining on that statement.
Were you aware that in case 15261, the commission took the NARUC cost allocation, this version of it, as an authoritative source and used it in its final order? And I can give you the exact reference. It is ordering paragraph T on page 281 of the corrected recommended decision. Were you aware of that?
I was not.
Okay. Do you agree with the statement, regardless of your acquaintance with this particular manual? Do you agree with the statement that even though non-cost concepts and principles often modify the cost of service standard, it remains the primary criterion for the reasonableness of rates? Do you agree with that statement?
I'm sorry, I was trying to find the page again on the document. Can you reread it or point me to where you're reading? I'm sorry.
Yeah, and I apologize if I'm not giving good directions here because we want the record clear. I'm reading from page 12 as in the PDF, chapter 2, the first paragraph under the heading cost of service studies in the regulatory process. Do you see that?
Okay, so Mr. Monroy, before you answer, we've started just kind of verging back into the discussion of it, and we may still have an objection lodged to this line of questioning on this cross-examination exhibit. Do we, Mr. Alvidrez?
We do. There's been no foundation laid for this particular exhibit, and the witness has said he doesn't have any familiarity with it.
Well, regardless of that, though, it has been apparently used as an authoritative source by the commission, according to the citation Mr. Gould gave.
I haven't been able to check that, but I don't have any reason to doubt it. But I don't know what context or for what purpose or for any of the details around that.
Well, I can supply that, but I think we should move on. I'd also note for the record that PNM itself uploaded this to the Dropbox of the GridMod case. Now, they actually didn't ask the question.
I've heard enough. I've heard enough. Objection overruled. Go ahead.
Okay, so let me ask my question again, Mr. Monroy, so we're really clear. I'm reading from the statement on page 12 of this manual, and it's the last sentence of that paragraph that you read into the record. And I'm asking you, do you agree that even though non-cost concepts and principles often modify the cost of service standard, but it remains the primary criterion for the reasonableness of rates? Do you agree with that statement?
I guess I agree in that cost-based rates and cost causation is a principle that we should strive to, fully recognizing that there are inherent limitations to achieving those goals.
Okay. And the purposes of the cost causation studies are to attribute the cost to the customers that cause the utility to incur those costs. Is that a fair statement?
Did you say to the utilities? But yes, I think the cost causation is cost allocated to customers should reflect the actual cost of providing service.
Okay.
That's fair.
On page 6, line 17 through page 7, line 6, in your direct, you actually address the cost causation principle. And I want to have you turn to those pages if you would, please.
I'm there.
Okay. And just to kind of hurry this along, it is your statement is at the bottom of the page. It starts with a Q&A on line 19.
Yes, sir.
And you're asking yourself, can you highlight some key proposals in this rate filing? In your first sentence, it says, under standard rate making principles, customer class cost allocations are intended to reflect customer class cost causation. Try to say that fast. Did I read that accurately?
Yes, sir, you did.
Okay, but then you go on to state that PNM's final proposed rates in this case must take into account disparate and significant impacts among customer classes from strict adherence to that principle. Did I read that accurately?
Yes, sir.
And what did you mean by disparate and significant in this context?
So here is really getting to why P&M proposed banding or a banding proposal as opposed to a pure cost-based allocation of customer rates. And so, for example, before banding, the residential customer class increase, I believe, was approximately 25%. And so that's an example of significant impacts that we are choosing or proposing to address by using our banding proposal in this filing.
Okay, and we'll get to that. And if you would, for the next line of questions, if you would grab the testimony, the direct testimony of Stella Chan, and I want to direct your attention to page 17 of that direct testimony, because that addresses the cost causation and the banding. Can you do that?
It's getting grabbed for me as we speak. Hold on 1 second.
Thank you.
All right, I have it in front of me. Ms.
Okay.
Chan's testimony.
And just to make sure we're all on the same page, what I'm looking at is the direct testimony of Stella Chan. I don't have the P&M number in front of me. But it is page 17. And on that page, there are the whole page is taken up with tables. The top of the page, starting at line 1, is P&M table S Stella C Chan -1. Do you see that? Are we on the same page?
Yes, sir, I'm there.
And the bottom of the page, starting on line 5, is P&M table SC2.
Yes, sir, I'm there.
Okay, thank you. Should I pause, Mr. Examiner, and let everybody catch up, or are we okay going forward?
I think we're going forward. I
Thank you.
believe it's P&M Exhibit 40 that we're addressing. It hasn't
Thank
been
you so
admitted
much.
yet, but
I
that's
understand.
the exhibit.
And I want to ask you high-level questions. And if you get to a point where Mr. Monroy, you believe that Ms. Chan can answer the specifics, I want to go through this at a high level. So just so we understand where we're going. Thank you.
Thank
Okay.
you.
My first question is, P&M did a full cost of service study in this case. Isn't that a correct statement?
Yes, P&M filed a cost of service study sponsored by Kyle Sanders.
And the purpose of that cost of service study was to create a baseline to show which rate classes were causing P&M to need to increase its revenues. Is that a fair general statement?
So just to make sure me and you don't get crosswise, the cost of service study that I was talking about that Mr. Sanders prepared is designed and developed to provide the total revenue requirements needed to provide electric service to customers in the test period. I believe then in our pricing group, under the direction of Ms. Chan and Mr. Casas, they then allocate that revenue requirement to customer classes.
Okay, thanks for that clarification. So Mr. Sanders basically goes through all of the base year cost, look at the linkage, comes up with a test year number, right?
Yes, that is correct.
Revenue number, and that's roughly 790 million.
That is correct.
Okay. And then the pricing group, Ms. Casas, Ms. Chan, go and take that cost of service study, use their allocators, and allocate it to the various rate classes.
That is correct.
Okay. And in that process of doing the cost of service study, Mr. Sanders does not do any banding, does he?
No, sir, that is a rate design
Okay.
function.
Okay. And if you would look at P&M table SC1,
Yes, sir.
this is the allocation of that $790 million. Actually, at the bottom of one of the columns is so let's call $791 million revenue request. This SC1 just assigns them those costs to the rate classes according to cost causation principles. Is that a fair summary?
Yes, I would say P&M table SC1 is the cost-based non-fuel revenue increases. Yes.
Thank you for that clarification, because we're only talking about base rates. We're not talking about fuel or any of the other riders that you mentioned when you were answering the questions of Mr. Albright.
That is correct. That is non-fuel.
Okay. So I'd like to go through that with respect to a few of these rates. If you would, so I'm looking at SC1, I'm looking at large power, which is the customer class is indicated in the first column on the left. Is that correct?
Yes, that is correct.
It says 4B large power, and that is your customer class for large commercial and industrial customers that have a load of over a half a megawatt. Is that a fair statement?
Subject to check, that sounds correct, but I'm not exactly
Okay.
a megawatt.
And if you go across the page, the current revenues are about 58 million from that class. The cost base increase would be somewhere in the range of 2.7 million. The allocated revenue requirement for that class under your proposed rates would be 55.3 million. And that, in order to achieve that, that class of customers would need a rate decrease of 4.62%. Did I read that accurately?
That is what that table says. Yes, sir.
And do you have any reason? And this is one of Ms. Chan's primary tables in her testimony, so I'm assuming you reviewed that, right?
I've seen this table. Yes, sir.
Okay. And do you have any reason to doubt the accuracy of Ms. Chan's calculations?
No, I don't.
Okay. Moving on to the next line, which is 5B, large service of 8 megawatt demand and more. The current rates are 1.9 million in aggregate. The cost-based increase would be a negative $880.6 thousand. The allocated revenue requirement would go down. It would be basically $1 million. And in order to achieve cost-based rates, this class would need a 46.27% decrease. Isn't that a fair statement?
That is what this table says. That is correct.
Now, moving down to the next large customer class, 15B, universities that take service at 115 kV.
I see it.
And isn't it true that in order to take service under this rate, the university needs to own its own substation?
I don't know that.
Okay, well, if you can just accept it, subject to check, if the university has to own its own substation and maintain its own substation, that's a cost that no other customer has to bear. Would that be a fair statement?
That makes sense.
Okay, so in this case, the pre-test, the test period revenues at the current rates for that customer is about $3.7 million. And then in order to get a cost-based rate, that rate would have to come down by 1.9 million. The allocated revenue requirement under your test year rates would have to be 1.79 million. And that would require a 51.72% decrease to this customer to get the cost-based rates. And did I read that accurately?
You did read that accurately.
Okay. Manufacturing is pretty much at their cost of service. If you go across the page, they would need a 1.6% rate decrease to get to cost of service rates. So that is a large customer that's pretty much at a cost of service rate. under your proposed, under your cost of service study, right?
Based on the cost-based allocation. Yes,
Yes.
that's correct. I just want to
Yeah,
make sure
and
that's
this-
what we proposed, but yes, I follow you.
Exactly. I thank you for that correction. We'll keep the record clear. But moving on to the next large customer class, 33B, which is large station power, which is the power that you supply to power plants that you don't own, right?
I believe that is correct.
Yeah.
Got to be subject to check, but I believe that's what that tariff is. Yes, sir.
Yeah, they have to do operations. They have to use your system to start the plant and do other things, facilities and such. So they produce power, but they also purchase power from PNM. Is that your understanding of that, Ray?
That I think that's a fair.
Okay, and currently that rate class, you collect 226,000 and change. In order to get to a cost-based rate, they would need a decrease of 122,000 with a resulting rate on a cost-based basis of 104,000. And that would require a 53.97% rate decrease to get that customer class to cost of service rates. Is that a fair statement?
Yes, you are reading this correctly.
Okay.
And
And to understand where you're going, Mr. Gould, excuse me. No, go ahead, Mr. Monroy. It's you answer the question. Go ahead.
Oh, I just wanted to continue. I just wanted to tell Mr. Gould that, he's asking some detailed questions about the tariffs, and I think Ms. Chan would probably be better suited to make sure and confirm the facts of the tariff characteristics that are in this schedule.
I appreciate that. I'm not trying to put words in your mouth, but I'm just trying to put a context on these rates so that it's clear to the hearing examiners and the commission what type of rates we're talking about. So thank you for that correction.
And to be clear that I understand what you're portraying here or trying to convey for this particular customer, the station power customer, 33B large service, under a banded increase, there's an increase of 17,800 or 17 million. Is that right? $869,000.
It would be 17,000.
17,000.
Yes, sir.
That's in thousands. Okay. So it'd be it would be only a 17,869,000. Excuse me, $17,869 increase, correct?
Yes, sir, that is
Exactly.
correct. They're whole dollars. Yes, sir.
Okay. Okay, whole dollars. Go ahead.
Yeah. Yeah, and these, just to clear, thank you, Mr. Hearing Examiner. Just to be clear, this table is done in actual dollars. There's a lot of tables that you see will
Yeah.
portray the numbers in millions or thousands, but these are actual dollars, right? These tables, both these tables?
These are actual
Yeah,
dollars. Yes, sir.
Okay, and then, so 35B, which is your large service for customers that have a demand over 3 megawatts, but less than some of the other rates, they would need, just to cut to the chase, about a 5.31% rate decrease to get to cost of service rates.
Yes, sir.
And then finally, the rate 36B customer, which is the customer that supplies its own renewable energy into the system. Their current charge is 17.3 million under current rates. To get the cost-based rates, they'd need about a $4 million rate reduction, reducing their rate to 13.3 million, or a 22.91% rate decrease.
Yes, sir.
Okay.
And
then
for
moving on-
Mr. Gould, for reference throughout the hearing, the customer that we euphemistically refer to as the rate 36B customer
Yes,
is an operating subsidiary of Meta, formerly Facebook, that operates the large data center in Los Lunas, and that is Greater Kudu. Is that correct?
Yes, and usually customer data is commercially sensitive, but I don't think there's any doubt about that because they have applied 3 times, not PNM has applied 3 times at the commission to inaugurate this rate and adjust this rate, so everyone understands that it is a rate for the data center in Los Lunas, which is a subsidiary of the Meta Corporation.
And
However they are.
Well, it's not confidential, the identity of the RAID 36B customer, because I've mentioned it in recommended decisions in at least 2 cases in the past to explain what we're talking about in terms of just focusing on the fact that we're talking about the Los Lunas data center. Okay, go ahead.
Yeah, and we can refer to it as a data center customer.
No, you refer to it however you like. I just want the record to be clear.
Well, and I just wanted to be sure that you understood that as a member of NMAREA, Meta does not object at all to having that information public. So that's all.
Fantastic.
That was the only reason I was bringing that up. Okay, and then table SC2 is your banding proposal. That's the results of your banding proposal.
Correct. That reflects the proposed changes to the non-fuel revenue after the banding associated with the revenue increase requested in this case.
So even though those rates that I mentioned and I went through are currently overpaying for service from a cost of service perspective, you are asking this commission to approve an 8% across the board increase for all those customers. Isn't that a fair statement?
Yes, in this case, which I believe is consistent with prior cases, there is a subsidy between rate classes that exists within our current rate structures. As in the prior case and in this case, we did propose a banding, which then obviously reduces the cost-based increases for classes that were above the system average, and it increases for all other classes that were below the system average, different from what their cost-based allocation indicates.
But the last rate case is not really comparable, is it? Because in 16-276, the final ordered rate increase was less than 1%.
It's not comparable to what? I apologize.
To you asking for an 8% increase. In other words, to say that the last case justifies an 8% increase to customers that are already overpaying for service on a cost of service basis, that's not really a good comparison, is it?
I don't think that's what I said. I was just pointing out the subsidies amongst these classes existed prior to this case. Was the
Okay.
point.
And do you have available to you PNM's rate schedules? I want you to look at PNM rate schedule N as in Nancy 1.
Is that the 530 when you say rate
Yeah,
schedule?
the rule 530.
Okay.
PNM schedule N1, which is attached to your application.
So that would be PNM Exhibit 3, correct?
Yes.
For those wishing to look for it on Dropbox.
All right, I have it in front of me.
Okay. Are you familiar with this schedule and what the purpose of this schedule is?
Not in any great detail. No, I'm not.
As we go through it, if you can't answer the question, please so indicate. And or if I make a statement about the schedule that's not accurate, let me know. Okay. I'm actually,
I mean, other than reading numbers on a schedule, I can confirm that. But like I said, I'm not familiar with the schedule. So,
okay. I stepped on your answer. Could you finish, please?
no, I said go ahead. Like I said, I can read numbers off the schedule, but I'm
Okay.
not sure.
The.
Let's see what you want to know.
Yeah, the Schedule N1 is entitled Rate of Return by Rate Classification. And what do you understand by the term of rate of return by rate classification?
I don't have a good definition. I'd probably refer you to the sponsors of the schedule, which is Witnesses, Casas, and Pitts.
Okay. If you would look at the first page, this is a 2-page schedule, is it not?
That is correct.
And have you ever come across the term of rate unity?
I'm not familiar with that term.
Okay. What do you call it when PNM is charging a rate class exactly what it costs to provide service to that rate class?
I think that'd be a cost-based rate.
Okay. My understanding from prior rate cases is that situation is called unity. In other words, if you charge that customer class exactly what it causes PNM to incur, plus the return on equity and all the other components of the rate, that's called unity, and it's expressed as the number 1. Is that your understanding?
Like I said, I didn't have a definition for rate unity, but you provided your definition of rate unity. I'm trying not to be confrontational. I just
no.
I'm not familiar with that term, and so it doesn't have that concept in my head.
It's an old term, Mr. Monroy.
And my understanding is that in relation to the unity calculation of 1, if a customer class on this schedule, and again, if you don't understand this, is at 1.2, that means it's contributing more than the cost of service would indicate. And on the same hand, if it's at 0.8, it's contributing less by that percentage point. Is that your understanding of how this schedule expresses those relationships? Do you have any idea?
I am tracking with your logic, and I can see that at a consolidated level, it's 1, which would imply that that's rate unity because that's all classes. And I understand the concept you're explaining, and I can understand how below 1 means they're paying less than their cost-based allocation, and above 1 means they're paying more.
Yeah,
and
as a
understanding
matter,
the schedule.
and I apologize, I'm probably over caffeinated, and as I get going through the day, I have a very bad habit of stepping on your answers, so I will try to slow down. My co-counsel always reminds me of this, and it's what I usually forget. But if you look at the center of that exhibit, it starts with base period, current rates, it goes to test period, proposed rates unbanded. That's what I'm looking at. If you look at the relative rate of return for all rate classes, it is at 1. Do you see that?
I do see, I mean, Schedule 5, it's at 0.98, but I'm not sure why, but.
Yeah, I mean, slightly divergent, but pretty close to 1 on all of those test period rates if they are unbanded.
Sure, and I would fully expect with our banding proposals, the results of that would result in a number other than 1.
Okay. And if you look at the relative rates of return for, say, for instance, large power, it was over contributing, but under your banded rates, it slightly decreases. The rate of return for that class decreases from 8.12 to 7.52%. You see that?
What class are you looking at? I apologize.
Large power, Schedule 4.
Oh, Schedule 4. Okay, I apologize. Yes, your question again.
That rate, the relative rate of return for that rate class goes down slightly.
On this schedule, it looks like base period was 11.69%.
No, for schedule, it's 8.12%.
For schedule 4, large power,
Okay,
column 5, maybe there's a,
well, you know what? Let
I'm not
me,
sure.
let me go get the actual, I need to pull it off pull it off. I think I have the one, I have an incorrect, copy on that. So I just need, is it an M? I apologize. Thank you. It's what we call interface error. Okay. Okay, so I'm so for rate schedule 4, yeah, the current relative rate of return is 11.69, and it slightly decreases to 10.59. Do you see that?
I do see those numbers. Yes, sir.
Okay, but it's still at a relative rate of return under your proposed banded rates of 1.52 on a unity scale.
That is what that reflects. Yes, sir. That's correct.
And if you go to universities on the next page, schedule 15, the present rate of return for that rate is 15.85% under current rates. And it goes up to 46.87% under your proposed banded rates.
Yes,
You
sir.
see
I see
that?
those numbers. I see those numbers on the schedule. Yes, sir.
It goes from a unity number, relative rate of return number of 1.65 to 6.72.
Yes, sir. I see that on the schedule.
And then schedule 33B, station power goes from 31.59% and jumps to 53.38% under your proposed banded rates. Do you see that?
Yes, sir.
And that its relative rate of return goes from 3.29 to 7.65.
Yes, sir.
And rate 35B goes from basically under the number 1, 0.56, and jumps to 1.61 on the unity number.
Yes, sir. For 35B.
And 36B again goes down slightly from it's under current rates 48.85%, and decreases to 17.69 with a unity number of 2.54.
That's correct, from a relative rate of return of 5.14. Yes, sir.
So I guess, you know, I guess my overall question is, given those numbers, why do you believe that having a 25% increase for a class that is not paying its full cost of service is unreasonable, while other classes are paying 20, 30, 40, 50% more than their cost of service, and that's completely reasonable?
Sure. Recognizing that banding obviously has impacts to, like I said, wherever you fall on your cost based. Recognizing that our residential customers, in large part, are low income customers in the state of New Mexico. And the other class tariffs really reflect corporations or businesses or organizations. I'm not here to minimize any cost increase for any individual customer. I understand they all create pressures and cost burdens. But our perspective in setting the banding was really in focusing that our residential customers, having come across high inflation that everyone's experiencing, as well as still recovering from the impacts of COVID, we felt it appropriate to minimize that class allocation to an appropriate banding level.
But everyone in this economy has, including businesses, has experienced the stress of the inflationary cycle we're in. Wouldn't that be a fair statement?
It is true. P&M is no different. We are experiencing our own inflationary costs. That is correct.
But unlike the businesses that I represent, you have a monopoly, so you can come to the ratepayers and say, make us whole for that inflationary cycle. My members of NM area can't do that, can they?
I believe they are, not that I know every customer in NM area, but I believe they are set to change their rates for their product as they see fit to recover the cost that they're experiencing. So I would think it's a different mechanism, but they have the same opportunity to change what they are collecting or charging their customers to cover their costs.
If you had to state what P&M's corporate policy was, what is P&M's policy on retaining and attracting new large customers to the state, the customers that provide jobs for the state's residents?
I'm not sure if we have a stated corporate policy. We are supportive of economic development in the state. I believe that has numerous benefits for all citizens in the state that economic development brings for customers, for the state.
Do you believe that the large customer classes, the customers in those classes that I've mentioned?
I'm sorry, the customer in S classes?
No, the customers in the classes that we've just been discussing are unaware that they're being overcharged from a cost of service basis?
I'm sorry, what was your question? Am I aware of what those customers?
Yeah, do you
Sorry,
think
ask it
that,
again?
okay, do you think that the customers in the rate classes, the large customers in the rate classes that we've been discussing are unaware that they're being overcharged by P&M from a cost of service basis?
A couple of things. One, I don't know, presume what those customers are aware of or unaware of. As I stated previously, their previous rates were not cost based. I would not say those are not appropriate, as the commission has deemed those rates to be just and reasonable. And so I wouldn't agree that they are unfair rates. They are the rates that were proposed. I do agree they may not reflect the actual cost causation or cost allocated rates, but I wouldn't say they are unfair or unjust.
But right now, we're in the middle of a new rate hearing where the commission has the opportunity to revisit that issue and say, is it fair for a customer, for instance, like the university, that's already paying 50% more than its cost of service to actually pay another 8%? So we're in that cycle now. So the last case is the last case, but the commission has the right to go in and say, is your rate proposal reasonable given the discrepancies between your proposed rates and the cost of service rates? You would agree that the commission can relook at everything, right?
Right. As I say, I wasn't sure what your question is, but I would agree the commission has the ability to set rates based on the company has proposed rates based on a cost of service study. The company has proposed how to allocate those revenue increases across customer classes. And I believe the commission has the authority to then approve those rates or modify our proposed rates amongst the customer classes.
You understand that a lot of these large companies do have choices about where they can locate their facilities, do you not?
Once again, I'm not sure what customers you're referring to or what specific circumstance you're doing. P&M does, like I stated earlier, we are supportive of economic development. We are supportive of large manufacturing and large customers, or large industrial customers in the state, recognizing the benefits and the additional jobs they bring. And so, yes, we are supportive, or I acknowledge that the importance that those customers bring to the state.
But your actual actions in terms of being supportive are to overcharge them for the costs that they're causing your company to incur.
I believe, as I stated, I wouldn't classify how we're doing our banding proposals in that nature. I believe I've already stated what our banding proposals are intended to cover and trying to mitigate impacts on all of our customer classes.
When P&M goes out to purchase supplies for its operations, does it allow itself to be overcharged by 50%?
P&M does not. And like I said, I disagreed with your characterization about rates being overcharged. The rates that are in effect are set and approved by this commission. By definition, those rates are then fair, just, and reasonable. So I don't agree with the premise that you say that they are being overcharged. They're being charged the rates that are approved and authorized by the commission.
Isn't the purpose of regulation to mimic the competitive market to the greatest extent possible, to ensure that because P&M doesn't have competitors, that its rates are fair, just, and reasonable in an overall economic perspective?
That is one purpose of regulation. Regulation recognizes the monopolistic situation that P&M finds itself in as the sole provider of electricity. And so the regulation is intended to balance both our customers and the utilities' interest to ensure the rates are fair, just, and reasonable.
So it really, you have in I'll take this characterization, I don't want you to accept it, but so the recourse that these large customers have who are being overcharged from a cost of service basis, the only recourse they have in this case is to go to the commission and say, you know, please require P&M to pay to charge something for these rate classes that's more reasonable and closer to the cost of service. Since P&M has not proposed something that's closer to cost of service, have you?
There was a couple of questions there. So I do believe parties have the opportunity in our rate case, if they disagree with the cost of service study or the allocation of those costs to rate classes, this is their opportunity to present those issues and concerns to the commission. And I can't remember what your second question was.
Okay, well, that's fine. I wanted to move on to I'll move off of this. I think we've made our point. I want to go and shift gears to the data center rates and get a description from you from a high level of how those rates operate together. And my purpose here is to sort of provide a roadmap. So what I'd like you to look at, and let me give you the citations so we can be on the same page, is Enamaria cross-examination exhibit 24, which is the third revised special service rate 36B.
Did you say exhibit 24?
Yeah, 24.
Okay.
And then I'm also in this next line of questions, would like you to have available or be looking at the cross-exam exhibit 25, which is the second amended and restated special service contract.
Okay, I have both of those in front of me.
And then the third document is the first revised rate rider number 47, entitled the Green Energy Rider, and that is cross-examination exhibit 2626.
Hold on, Mr. Gould. We have to open, unless I'm doing this wrong, to move back and forth between the documents. I need to open several Dropbox browsers.
And I'm sorry about that. They're not very big exhibits except the special services contract, and I printed them out. So,
but I need to be able to move efficiently between the documents. So
okay,
bear with us.
No,
Just
no,
a
no, I
second.
will.
So the second one is cross-examination exhibit,
24
okay, and the third,
is cross-exam exhibit 25.
25. Thank you.
And the next one is cross-examination exhibit 26, which is the first revised rate rider 47, which is called the green energy rider.
Okay, so you have 4 exhibits that you're
And then
referring
there's one-
to. There's 5.
One additional one. So we're doing
Wow.
rate 36B, that's the first one.
I really do need that 32 gigabytes of RAM that I'm requesting. I seriously, folks, just a
No, I-
pitch there. People who are listening in know what I'm talking about here. Go ahead.
1, 2, 3. Actually, I only want to do 4. I want to do rate 36B, which is exhibit 24. The special services contract, which is 25. The green energy rider 47, that's number 3, which is 26. And then the final one, original rider 49, which is the production cost allocation rider. And that is exhibit 27.
All right. Well, thank goodness I have real time, thanks to Mr. Lee. So
Okay.
I can look back and not interrupt you any further. Go
Well,
ahead.
that's, if at any point in my questioning it becomes unclear, please do interrupt me because I'd like a clean record. Mr. Monroy, as VP of Regulatory, are you generally aware of how all these rates that the commission has approved work together?
I am aware that 36B has a special service contract. I'm aware that there's a special services agreement. I will have to say I am not the expert in these tariffs or how they interrelate with each other. So
Okay.
I have a general knowledge of them, but I am not the right witness to get into details associated with these.
If I get too far into detail, please remind me of that caveat. I'm just trying to get a roadmap. I know this seems complicated, but I think it's these rates work together in a logical fashion. So, we'll just go through that. And if you have to say, hey, stop, I can't answer that question, please do so.
Understood.
Okay. Rate 36B was specifically designed for a customer that wanted to purchase its own renewable energy through PNM to cover 100% of its load on the system. Is that a fair general statement?
Once again, I'm going to have to just give you the pause. I mean, there's a lot of qualifications in there and a lot of generalities. I once said I'm not necessarily the right person to give you what originally 36B was, what the intent was, or what the goals were of that customer. So
do you understand that rate was created for a voluntary renewable customer that is going to supply its own renewable energy to cover its load?
My understanding is it's a special service rate for customers interested in renewable energy resources, I guess
Okay.
is what I would say.
And then just jumping ahead to cross-examine exhibit 26, the green energy rate rider 47 is the mechanism through which that customer purchases that renewable energy and puts it on PNM system and pays for it. Is that your
Yes.
understanding?
Subject to check, I believe that's my understanding of the rider, of the green
Okay.
energy rider.
And under that rider, the customer pays the full cost of those energy supplies. Is that a fair statement in your understanding?
I have no reason to doubt that, but once again, I'm not that ingrained into these riders or what costs flow through them. So once
Okay.
again, I'll say perhaps another witness like Ms. Chan is better suited to answer your questions.
Okay. And then the rider 49 is simply a reconciliation rider. If the renewable customer, the voluntary renewable customer doesn't purchase enough supplies, and leans on PNM system in a given year, this Rider 47 allows PNM to charge after the fact so that they pay the full cost of leaning on the system. Is that your understanding?
Once again, Mr. Gould, I mean, I'm not trying to be a difficult witness here, but there's just a lot of qualifications you're putting in there. And once again, I'm not that familiar with it to make sure every characterization of the rider is accurate.
Okay.
My understanding of the production cost allocation rider is to provide for recovery of undercollected production costs as it states here in the tariff. And that's where I get that knowledge from.
And the impact of that is to basically hold the other customers harmless if the voluntary renewable customer is not able to supply all the renewable energy it needs to cover its load.
Once again, Mr. Gould, I'm not comfortable characterizing what these tariffs are doing. I do think Ms. Chan is the appropriate witness and can provide you those answers.
Okay. Do you have any understanding at all of the special service contract that is required for the eligibility for rate 36B?
I understand there are special service contract for customers in 36B. What was your question though? I mean, I don't.
But do you have any understanding of that contract in general?
I've read through parts of it as we prepared this case, but I'm not by any means the expert in that contract. Once again, I would suggest those questions are better asked of Ms. Chan and Mr. Casas.
Would it be fair to state, if you can state, that the special service contract, the purpose of that is to set forth the exact details of how energy will be procured by that customer through PNM and how it will pay for all of those costs that it incurs?
Once again, I don't want to characterize what the special service contract does and not having thoroughly reviewed it and kind of framing up how that should be characterized.
Do you understand that it is a negotiated contract?
That is my understanding.
And do you understand that neither party can unilaterally change the contract without negotiating with the other party?
I can't confirm that. That makes sense logically, but I don't know that for sure.
Well, let me ask you this question. In this docket, has PNM applied to the commission to change anything in the special service contract? If you know.
I don't know. I would rather, I think Ms. Chan or Mr. Casas can probably answer that.
Well, stepping back one step further, would you agree with me that the special service contract, because it's a requirement of rate 36B, is also considered a commission rate?
A commission what? I'm sorry.
Rate, R-A-T-E, if you know.
I don't know. I don't know the distinction.
Okay. I'm going to move on to a different line of questioning, if I could. You understand that one of the issues in this case is the use of the minimum distribution methodology to allocate distribution costs?
I believe that is one of the compliance issues that we have. I believe that is covered. I'm just checking. I believe it's Dr. Pitts, but let me make sure. Yes, I believe Dr. Pitts covers that topic.
Okay. Are you familiar with the final order in case 15-261, where the commission ordered PNM to employ one of the two methodologies for the minimum distribution methodology that's contained in the NARUC manual that we were discussing earlier in the cross-examination?
I don't believe, I am aware about a minimum distribution study. I don't remember what the 15 case said. I And I apologize, maybe it's Dr. Pitts or Dr. Cas or Mr. Casas. I'm not sure which one addresses that in his testimony, but I would refer to those witnesses to answer those questions. Because I'm not sure what the 15 case said or what it concluded or required.
You were aware that neither Dr. Pitts nor Mr. Casas did follow the minimum distribution methodology, either one that's outlined in the NARIC manual. Are you aware of that?
I'm not aware of that. And like I said, I
Okay.
refer to them to answer those
Well,
line of questions.
Subject to check, I'm going to read into the record, ordering paragraph T as in Tom of the corrected recommended decision, which was adopted by the commission in case 15-261. And it states
Mr. Gould.
maintaining data.
Hold on,
necessary
hold on,
to
Mr.
determine
Gould.
the demand and customer.
Hey.
Mr. Gould, listen
going
to the
to-
Mr. Lee. Listen to Mr. Lee. Okay.
I didn't hear Mr. Lee. Did he say something?
I think there's lag. There's lag between Mr. Gould, Mr. Von Roy, and Mr. Lee. That's the problem.
And myself probably too. Mr. Lee, go ahead.
Mr. Gould, can you start with the quote again? You froze or I lost you somehow.
Okay, yeah, I apologize. I will read it 5 or 6 words at a time that way and move through it that way. Would that be okay?
Yes, sir.
Okay, this is ordering paragraph T as in Tom,
On what page of the corrected recommended decision?
page 281,
Thank you. Go ahead.
case 15-261. Within 2 months of issuance of a final order in this case, P&M shall begin collecting and maintaining data necessary to determine the demand and customer components of distribution facilities, period. In its next base rate filing, P&M shall identify which of the 2 methods identified by NARUC it proposes to use in its following rate case filing to determine the demand and customers of distribution facilities.
Yeah,
I'm sorry.
We're having,
Go ahead, Judge.
well, the problem, Mr. Lee, is I think Mr. Gould is starting to freeze. You might benefit from 32 gigabits of RAM as well, or bytes.
Here's what I'm gonna, let me take off my video and see if that helps.
Just briefly, go ahead for this purpose. Yeah.
Okay, so Mr. Lee, what was the last word that you caught from me?
Shall identify which of the 2 methods identified by NARUC it proposes to use in its following rate case filing to determine the demand.
The demand and customer components of distribution facilities. And shall describe the procedure it has adopted to collect and maintain the data necessary to use this method. That's the end of the quote.
All right, turn your video back on, Mr. Gould. Thank you.
So my question, Mr. Monroy, is do you know whether in this case P&M has followed that mandate?
Once again, I would refer you to probably witness Casas or Pitts, but I do think in the 16 case, which was the case subsequent to the 2015 case, that may have been addressed, but I'm trying to remember if I read that just prepping for the hearing or not, but I believe they could probably provide you a little more information.
If you know, has PNM in this filing asked for a variance from this case 15261 mandate?
I don't know if a variance was required. And like I said, I think that's probably a question better asked of Mr. Casas or Dr. Pitts, as I believe those requirements would have been met in the 2016 case.
I guess my question is more specific. Do you know whether PNM filed for a variance from this mandate in this case?
I believe I just answered that. I'm not even sure it was a mandate required in this case, given the 2016 rate case. But PNM witness Casas or Pitts can probably provide you that answer.
So your answer is there is no variance has been filed. Is that a fair statement?
There has been no variance filed. As I said, I'm not sure one was required to be filed as you've characterized it.
Okay. We are at noon, and I see I have about 15 minutes left. Can we take a break? I'm ready to move to a new topic.
I think we can conclude your and go ahead from 12:15 or 12:17 to
Okay.
1:17 for lunch, if you'd like to just conclude your cross.
Sure.
Are you all
And I
right with
make-
that, Mr. Monroy? Mr. Monroy, are you okay with that?
Yes, sir, I'm good.
And I
thank you.
may not, excuse me, I may not take the entire 15 minutes, so we may be able
Go
to
ahead.
finish this a little quicker.
Thank you, Mr. Gould.
Would you turn to your testimony on page 10, please?
Yes, sir, I'm there.
I'm looking at lines 12 through 14, where you mention the PRAC process. Do you see that?
Yes, sir.
Could you briefly describe what is meant by the PRAC process?
Sure. So PRAC stands for the Pricing Advisory Committee that PNM has formed. Its primary purpose is to get input from stakeholders as PNM evaluates future rate options and rate considerations.
The PRAC meetings are ongoing, correct?
That is correct. It was started in 2022 and is continuing into 2023.
And the PRAC meetings and the discussions therein are not confidential, are they?
I don't believe so.
The process, as I understand it, of the PRAC is to collect recommendations, data from stakeholders, and for PNM to propose rate methodologies that might be used in future rate cases. Is that, do you understand the process any differently from that?
I think that's a fair summary of one of its goals. That's correct. I'm not sure if it has other goals, but that's a fair characterization. Or my
And-
understanding.
And in an ideal world, the stakeholders and the utility would come to some type of agreement about what those future rate methodologies might look like, correct?
That would be an ideal world.
Okay, but at the present time, there have been no definitive proposals about future rate methodologies made in that process, correct?
I'm not 100% sure. I think Ms. Chan could probably give you a little bit more clarity on what has been the results of those committee discussions and what has been proposed or what the outcomes are. I do think I know some of the information on the time of day pilot. My understanding is some of those recommendations were gathered through that pricing advisory committee.
Other than the time of day rates that you're proposing in this case, are there any other definitive rate-making proposals that have emerged from the PRAC process?
Not that I'm aware of. That's the one that I was aware of. But like I said, Ms. Chan may be able to provide you more information on that answer, but I'm not aware of any.
would it be fair to state that other than the time of day rates, any outcome that a PNM witness may testify to about the PrAC process would be speculation?
Could you ask that question again? I didn't quite follow
Yes.
what you're asking me.
Would it be fair to say that any statement other than with respect to the TOD rates that a PNM witness would make about the PrAC, the outcome of the PrAC process would be speculation at this point?
I couldn't answer that question. I would assume the PNM witness who could comment on it was participating in the PrAC or has knowledge of it and can better characterize what their opinions or outcomes of that process are. I can't agree that it would be speculation. I mean, it seems like a
Right.
hypothetical question you're asking me, so.
Right, it is a hypothetical question, but it's based upon your statement that other than TOD, there are no proposals that have come out of the PrAC process that are being adopted or pushed in this case.
I believe my
Right.
testimony is that's the one I'm aware of. I wasn't sure if there are others, but
Well, casting your mind back over the testimony of your witnesses, can you isolate in the testimony of Ms. Chan or Mr. Casas or any other witness, any proposal other than TOD that's come out of the PrAC process that's being considered in this case?
if I'd already knew about it, I would have mentioned it, Mr. Gould. Like I said, I can't definitively say there were no others. I'm just not aware of any.
Okay, and if they were going to be definitive, they would have been included in one of your witnesses' testimonies, right?
I believe the purpose of that committee is to incorporate feedback on a multitude of topics. Looking at my notes, I'll just remind another thing we talked about, or was talked about in the PrAC meetings, is the cost model or COST model. I know we did utilize the cost model in this filing. So that's why I qualified my answer that there may be other things that were discussed in the PrAC that have been included in this case that I think Ms. Chan or Mr. Casas could be better suited to answer. I don't want to close the door if I'm not thinking of other things.
But PNM made the decision and did the analysis using the COST cost allocation model well before the PrAC began, didn't it?
I don't know the timeline of when the system was acquired versus the PrAC meetings began. It may have been
But you-
information sharing at the PrAC meeting. I'm not 100% sure. I just know that
Right.
was a topic that was discussed.
But, and maybe my question isn't clear, PNM had in prior cases, had a cost of service model called the ECOS, ECOSS. I don't know what that stands for. And in this case, it replaced that model with the COST model, right?
That is correct.
PNM did not wait to get consensus from all of the participants in the PrAC process to purchase that model and use it to design the rates in this case, did they?
I don't think so. Like I said, I'm not sure if that was a topic that was informational at the PrAC meeting, meeting, or I know that was a topic covered.
Okay. In other words, PNM shared the fact that it was changing cost of service models, but it didn't ask the parties to say, is this okay? Is that a fair statement?
I wasn't involved in that PrAC meeting, so I can't say that yes or no. I can't say.
Okay. And overall, and I'll finish this line of questioning with a couple more questions. The purpose of the PrAC meeting is to make recommendations about future rate proposals. Isn't that a fair statement? Other than TOD, it's aimed towards the future, not this case.
It is aimed towards the future. That I would agree with, yes.
Okay, and I think those are all the questions that I have for Mr. Monroy, and we can all go to lunch.
Thank you, Mr. Gould. I do have a quick question on this PrAC committee with stakeholders. Ms. Monroy, I looked at Ms. Chan's testimony on this, and I was wondering, I don't believe it's there. What was the genesis or impetus for developing this pricing advisory committee? Was it a commission order or was it something of PNM's own volition and initiative to develop a quote unquote modern rate design strategy? What is the genesis of the PRAC?
Sure, it was a P&M initiative that we felt, given the future of the rate design and the significant issues that are coming as we transition to a carbon-free and how that will shift how costs are allocated to customers. It was a P&M initiative. I don't believe it was a requirement from the commission.
Thank you. Commissioners or Hearing Examiner Ryan, do you have any questions on this? I'd like to allow you to do this if you have any questions at this point, or you can obviously save them for later.
Not at this time, thank you.
Great.
Me either. Thank you.
Okay. Thank you very much. So folks, it's 12:10. We're going to break for lunch for an hour. We'll be in recess until 1:11 p.m. Mountain Time. Have a good lunch, everybody. Thank you all.
Mr. Hearing Examiner, I have a question not on the record. Does it help or hurt if I'm not?
We're off the record.
Yeah, but yeah, we're off the record. This is just a process question. Does it help or hurt?
Sure.
The freezing problem if I have my video on or have it off? I just don't.
Well, the process that you employed, where you're not freezing now, so I would say please keep it on unless you start to freeze, and then we'll just flip it off and flip it back on. So I like to have folks on video. However, I've been informed that keeping people off video who aren't participating actually helps the process. Is that the speed of the hearing? Is that right, Hearing Examiner Ryan?
Yeah, Mr. Gould, probably the major function for you is are you operating off of a wireless connection, or do you have your computer plugged into the Ethernet jack?
I am on this computer operating on wireless.
Okay, well, that's step one. Plug your computer directly into the Ethernet jack. And then the second thing to do is, look in the background of your machine to see if there's other programs that might be utilizing any auto functions. And if anyone else in your house is utilizing any sort of Netflix, whatever, that'll chew into your bandwidth.
And also, obviously, the number of apps you have open on your laptop or
we'll
computer.
go through. Okay,
Okay.
thank you.
So
That's all.
we're in recess until now 1:12.
Okay, thank you.
Thank you. Have a good lunch, all.
Mr. Lee, are you there? Hey, Brad, can you tell me, is my audio working better?
I can hear you.
Does it sound like I'm calling from the bottom of a 50-gallon drum?
It doesn't sound perfect, but it sounds better than it did earlier.
Okay.
Yeah,
So
I would
good
agree.
enough for
Maybe,
government work?
yeah, Jason, I was just gonna suggest maybe if you just reduce the volume just a little bit,
Okay.
might be a little bit better.
Audio settings. Is this any better, Jeff?
I think so. Yeah, that sounds
Okay.
much, that sounds much better.
Yeah, I think so too.
Okay. Thank you, gentlemen.
Yes, sir.
Now,
Mr. Hearing Examiner,
Mhm.
can I ask you a question before we go back on the record?
Sure.
I don't seem to know where the new administrative notice documents are. Not by just pressing the same link that you sent before.
Mhm. No, they, to the extent to which there's been any renaming, I'd have to confirm with Mr. Maderos, but I'm not sure that we've shared them yet, unless he did, but I don't think so.
Okay, okay.
That's the nature of your question, is where are
Yeah,
the,
that's all I wanted to know. So if I refer to something in my cross-examination, I just refer to it as administrative notice Four Corners and then just say what the document is. Is that right?
that sounds correct. I mean, for the moment, we're just trying to all operate off the same documents. And then to the extent to which it's essential for the record in the long term to correctly reflect, you know, the point about administrative notice versus commission exhibits, that should solve that issue.
Thank you.
Judge, we can't hear you.
Mr. Maderos, before we go back,
I believe he's trying to sync up his mic.
okay.
Okay, can you hear me now?
Yes.
Same thing happened during the pre-hearing conference. These other headphones I have mute themselves and I haven't figured out how to unmute them yet. Forgot to do that. Apologies. Mr. Nazi, what I'm attempting to do with the administrative
Be on the
notice
record,
exhibits.
Are we on the
No,
record, Judge?
no, sir, not yet. Thank you. What I'm attempting to do there very quickly is to simply come up with a citation convention or for citing in briefs the Commission A and exhibit with a brief description when you are going through your narrative and putting in your footnote citations. So that we have a sort of a handy reference. I should have done it in the beginning and done it as well on the Dropbox. So, but please do follow that convention if it makes sense to you. And like I said, we can go over it tomorrow morning when we address that issue on the parties' positions on the documents that are in that folder. Are you having problems accessing it?
Excuse me.
Your Honor.
Yeah, I'm sorry. Yes, thank you so much. I don't know where that is. When I press that link again, it just goes back to the Dropbox. Is there another list or another link? Because I don't know where that is.
There were two separate links that Hearing Examiner Ryan sent out, I believe. Is that correct, Hearing Examiner Ryan?
Yes, but there was only one link of the administrative notice exhibits that were shared, which was the one that we've had shared previously.
That was my understanding. The other one is everybody's exchange documents. That I have that, but I wanted to know, like, okay, if it's new energy economy number 7, is that, I don't know what number that is. That's what I was trying to figure out. It's 1, 2, 3, 4, 5, whatever it is, 22 of the administrative notice. So that's what I wanted to know, if there's like a number to label, to cite it. And how should I refer to it during cross-examination with Mr. Monroy? That's what I didn't know. I could just refer to it as what you have here in the administrative notice, but it's not numbered.
It is numbered on that order I issued yesterday. There's the tables I numbered 1 to 75. And I put all the conventions or the formatting, suggested formatting conventions in there. But every document in there from, what is it, Commission Exhibit 1 are listed in there in enumerated order. Do you have that document? I issued it yesterday.
I'm so sorry. I don't know. I have Exhibit A and Exhibit B, but what time? I don't see it.
I issued it. Well, did everybody receive that document?
It was sent at 3:18 p.m.
Okay, thank you. I'll look. No.
The order
There's just
establishing.
so-
Go
Go
ahead.
ahead. Here,
No, I was just going to say it's entitled "The Order Establishing Citation Format for Commission Administrative Notice Exhibits." So I think the question Ms. Nanasi is asking, Mr. Medeiros, is basically if since we exchange a series of exhibits that may not line up exactly with the renumbered exhibits, to the extent to which we've modified their names so that there's a understanding that these are administrative notice exhibits, what should she do? And I think simple answer would be just sort of cross-reference, perhaps.
the table here, the tables I have here in this order.
Yeah.
That's the guide. I don't, unless I think we should all follow, unless you think this numbering
convention is inane or wrong somehow. It's the best I could come up with at the last moment, but just simply go through what, starting with Commission Exhibit 1, which is Commission AN1, as you see in there in the bullets. And the bullets, I put the examples, the different examples for, say, one of the Excel slides from investor presentations. That's AN Exhibit 9. You could even just say AN Exhibit. We'll know it's Commission Exhibit as long as you say it's AN Exhibit, or AN Exhibit 66, which is Sierra Club witness Pierce's revised stipulation testimony. And then the citation would be at page 3, lines 7 to 16. And by the way, those citations there are to innocuous portions. I'm not providing any hints. They're just innocuous, illustrative citations. Does that work?
Yes,
Mr.
thank you
Nosy?
so much. I don't know why, but I missed that.
Well, it was styled and spurred based on your timely query. So
I know. Thank you. I'm sorry. I got
No
it.
good
it's a
deed.
bit as Alanis Morissette said, isn't it a little bit ironic? But in any event, we're moving on now, and we're on the record now. Good afternoon. We are back on the record after our lunch. I hope everybody had a pleasant lunch. The next cross-examination of Mr. Monroy is the water authorities. Mr. Herman, you have 30 minutes. Are you prepared to proceed?
Yes, thank you, Mr. Examiner.
Mr.
I have
Examiner?
Mr. Gould's hand up. Yes, sir.
Yes, I neglected, Mr. Nasi pointed out to me in a text, I neglected to ask for admission into the record of the exhibits, the cross-exam exhibits that I used in our cross-examination of Mr. Monroy. I'd like to do that now before Mr. Herman starts. Would that be permissible?
P&M.
You're on mute.
Can you remind us which exhibits those are?
Yes, I will move Anna Cross Exhibit number 22, which is the NARUC Cost Allocation Manual. Exhibit 24, which is P&M's current approved third revised rate 36B, as in beta. Anna Cross-Examination Exhibit 25, which is the second amended and restated special services contract. Anna Cross Exhibit 26, which is the commission approved first revised rate rider 47, the green energy tariff. And Anna Cross Exhibit 27, which is original rate rider 49, which is the contribution to production reconciliation rider.
I have no objections to 24 through 27. I do have objections to 22 since there was only one minor portion of that exhibit that was discussed at all. And I don't have an objection to that particular page, but not the whole document since it wasn't used.
Mr. Examiner, if I might respond.
Please, go ahead.
Yes, the NARUC manual is cited extensively in P&M's own testimony, to wit, the CASAS Direct on page 3.
Okay, I'll take that. I'm gonna try and fast forward here because I know where this is going. You have a series of citations that P&M witnesses are relying on for this manual. Did you do excerpts of that in Exhibit 22, or did you just have the whole manual?
We just have the entire manual.
That's unacceptable. Because there's a lot of stuff in there that's not discussed. If you had excerpted everything meticulously that was addressed, or just excerpted the portion that you cross-examined, actually more appropriately, the excerpt that you cross-examined Mr. Monroy on, that would be acceptable. But to include the entire document and everything that's stated in there into evidence outside the context of the cross-examination, that's unacceptable. So the objection is sustained with regard to cross-examination, exhibit 22. Now, as to 24, 25, 26, and 27, the commission could take administrative notice of documents that are already in commission records, and so it's unnecessary to admit those documents.
Well, Mr. Hearing Examiner, your order goes beyond what Mr. Alvidrez stated. He stated that he had no objection to the page 12 being admitted. You've stated.
Well, you have to make that excerpt.
Okay,
And
and
if that's your, hold on. We did a lot of this in the pre-hearing conference, so we're going to have to both slow down because we both over caffeinate to try and keep going, or at least I do. So we share the same habit, Mr. Gould, of being active in our conversation. So yeah, if you do the excerpt and PNM does not object to that, just that one page, then that would be acceptable. But
would it be
I
more
had a
efficient?
feeling, frankly, I had a feeling you were going to try and admit the whole thing. And, just for future reference out there, don't try and admit a whole book, folks, like Bond Bride or something. Just come prepared with your excerpt of the relevant material, and then we can look at that. This goes back, way back to cases since I began. We've had this problem. So it just adds superfluous material to the record that then you can cite to say it's evidence, that that's not acceptable. So it would be acceptable to admit the excerpt subject to PNM reviewing the excerpt and agreeing. We'll have to circle back around to this on New Mexico Area 22. The other four, though, 24, 25, and 24, 25, 26, and 27, I believe they're in commission records, and it's consistent with orders that we've issued, the pre-hearing order or another order, where we've said that we'll simply take administrative notice of those documents that are already in other commission records, like the special services contract, the rider number 47, etc. Is that acceptable, Mr. Gould?
Had a question to perhaps short circuit any controversy, which is if we reload the specific portions, it would seem that appropriate to include those pages that are referenced in PNM's testimony and that will likely be the subject of future cross-examination. So
I'm amenable to that. Does that work
Okay.
for Mr. Alvidrez for PNM?
Yes, it does, Your Honor.
Okay, thank you.
Okay, thank you. Appreciate it. We'll get that done.
Yeah, so
We'll get that
to
done before the
clarify,
other witnesses come in.
here we go again. So, okay, thank you. So to clarify, though, you'll make excerpts of those provisions that are cited in testimony, and beginning with what you cross-examined Mr. Monroy on, correct?
Yes, and one additional,
And make sure that you redact irrelevant materials from that exhibit.
the one adder would be the citation in the 15261 that also mentions? Okay,
On page 280, whatever,
281.
paragraph T, 281 paragraph T or something. Yeah, add that one too, please. Thank
Okay.
you.
Thank you.
So is there anything else before Mr. DeSalen has his hand up? Go ahead.
Thank you, Mr. Hearing Examiner. At the risk of butting in here, I would just suggest that Mr. Gould, when he puts together the exhibit, include a copy of the title page so that we have a good record that it's clear what this document comes from. That's all I have. Thank you.
Thank you, Mr. DeSalen. It's a good suggestion. But Mr. Alvidrez, go ahead.
Yes, I apologize. Do I understand that exhibits 24 through 27, in exhibits 24 through 27 are not admitted, but you're taking administrative notice or will take administrative notice of the...
Would you object to that, taking administrative notice of those documents?
No, I have no objection to either way, to either admitting them or administrative notice.
I'd prefer to just take administrative notice of them. We know where they are. They're helpfully provided by New Mexico area, and we thank New Mexico area for that. But I don't think it's necessary to do that. We have the documents in other records. Thank you. We're all familiar with them, or most of us are. We deal with these issues regularly.
Thank you. That's all I have, Mr.
Thank you, Mr. Gould. I appreciate that. Anything else? We need to move along to the cross now. So, Mr. Herman, I have it down for 30 minutes. Is that right?
Yes, that's correct.
Okay, please proceed.
Okay, thank you. And just as a preliminary note, I have been having some internet connection issues. So if I could ask some of my colleagues to maybe text me if I freeze. Otherwise, I won't know right away. Normally, I would go to I noticed my internet outages were coinciding with some of the issues we were having with Mr. Gould, and I think it's just Comcast doing some work in the Santa Fe area. I would normally go to my office, but my second issue is that as a public service announcement, I'm getting over COVID. So just as far as
I'm getting over COVID.
As far as you all go, I'm getting over COVID, and seems like that is making another roundabout. So whatever precautions you may have let go of, you might want to bring them back, because COVID is not fun. And COVID brain is also real, so I apologize, Mr. Monroy, if I go over some territory we've already crossed.
No worries.
Okay, good afternoon, Mr. Monroy. With that all said, Keith Herman on behalf of the Water Utility Authority, and we've met before, correct?
Yes, sir. Good afternoon, Mr. Herman.
Good to see you. I wanted to start my cross-examination revisiting the hearing examiner's bench request number 1. Do you recall that request?
Yes, sir.
Okay. The settlement we are discussing, that was filed in a separate docket relating to the outstanding issues related to the 19-00018 case, correct?
That is correct.
So is it PNM's position that settlement would affect any other of the outstanding items in this case?
It's PNM's position that through that settlement, assuming if it is ultimately approved by the commission, understanding it has to come back from the Supreme Court first, that the areas within that settlement would resolve certain issues within this this proceeding here.
Well, let me be more specific. PNM's requesting approximately a $64 million increase in its revenue requirement, correct?
Yes, sir.
So would the settlement affect that request by PNM?
No, it does not affect our requested revenue requirement.
And saying PNM is asking for a 10.25% ROE and nothing in that settlement agreement would affect PNM's ROE request, correct?
That is correct.
Now, if you recall your cross-examination by Mr. Gould, he asked you what materials did you review in preparation for your testimony. Do you recall that?
I believe he asked me, did I review testimony and what was my process for that? Yes, sir.
Okay. Did you also review certain hearings or certain commission orders that were cited in your or other witnesses' testimony?
I have reviewed a few commission orders.
Specifically, did you review the recommended decision and final order in case number 15261?
Parts of them. I can't say I went and reread the entire.
What about 21-00083 regarding Palo Verde?
Part of them, yes, sir.
And 16276?
Yes, sir.
Okay, my next line of questioning is going to be regarding the reg liability associated with Palo Verde, which
yes, sir.
You did address in your rebuttal testimony to ABCWA witness Mark Garrett, correct?
Correct.
So in your preparation for the hearing or testimony, are you aware that the commission did require PNM to set up a reg liability for the expired leases in 21-00083?
Yes, I am aware that as part of 21-00083, the commission did order PNM to have a regulatory liability related to the Palo Verde leases from the time of expiration until rates are put into effect.
Can I direct you to page 57 of your rebuttal testimony?
I'm there.
Thank you. Starting at line 11, you state that to avoid the harm from both piecemeal and retroactive rate making, the commission should identify and place utilities on notice in advance of specific cost of service items that are subject to adjustment outside of a general rate review proceeding. So did I correctly reflect your testimony?
Yes, sir.
Okay, let's move on to PNM's request for a Palo Verde regulatory asset. Can I direct you to page 38 of your direct testimony? I'm sorry, 37.
Yes, sir, I'm there.
Bear with me 1 second, I'm not frozen. Starting at line 7, you discuss a rapid transition that is infrequent in occurrence and unusual in nature. What are you referring to as that rapid transition?
I believe this. I'm sorry, did you have another question?
No, that was my question.
Okay, sure. So this answer is in response to unusual nature and frequency of occurrence. So what we're referring to here, the rapid transition, is really how quickly our generation portfolio And the factors under which these long-lived generation assets or economic factors are evolving quickly. With the advent of renewable energy and how quickly it has become affordable, it is becoming a rapid transition to move to cleaner carbon-free resources or different resources than were contemplated when the original decisions to enter into these facilities were made. And so from that perspective, that's the rapid transition that I was referring to, specifically regarding the transition of our generation portfolio.
Okay, so you aren't referring to specifically the Energy Transition Act or any legislative directives?
It's broader than that. It's just how quickly our transition portfolio is transitioning. I'm not saying those policies aren't playing a part of it or influencing it. However, it is part of it. It's not the only part.
But there's nothing in the Energy Transition Act that would require you to divest from Palo Verde.
Oh, no, sir. That's correct.
In fact, there's no legislative directive that would have influenced your decision to not renew the leases in Palo Verde, correct?
I believe the decision was whether to reacquire the leases as the lease extensions had expired under the terms of the sale leaseback.
I'm sorry, under the sale leaseback?
Yeah, under the terms of the sale leaseback.
Thank you.
Let me direct you to your rebuttal testimony, starting at page 44, line 18.
Yes, sir, I'm there.
And there you're generally critical of ABCWA witness Mark Garrett on his citation to 15261, the corrected recommended decision, correct?
Yes, I did. I disagree with him.
Now, when Mr. Garrett testified that the commission found PNM's decision to extend the Palo Verde leases to be imprudent, was that testimony correct when he was citing the corrected RD?
I'm not sure exactly what you are referring to. The commission did confirm that the extension of the Palo Verde leases were deemed to be imprudent. However, portions of that related to disallowance of the lease costs themselves was not adopted by the commission. And the remedy for that prudence, for that determination of imprudence, was less than what was included in the recommended decision or the corrected recommended decision.
Do you agree that one of the bases for the commission to make that determination was that at that time, Palo Verde was still used and useful?
For what basis are you asking me to agree for the commission to determine?
Maybe I can direct you. Let me direct you to what PNM has labeled PNM Exhibit 59, the final order in 15261.
All right, I'm there.
Specifically, paragraph 110.
Yes, sir, I'm there.
Would you agree that the second sentence in paragraph 110 states that the leased Palo Verde capacity has always been certificated capacity and has long been used and useful.
Yes, that is what it says, has long been found to be used and useful.
So you aren't contending that after expiration, the Palo Verde leases continue to be used and useful for Palo Verde customers, are you?
No, we are not. We are not seeking to continue to recover the leasehold improvements associated with the Palo Verde leases as plant and service. We're requesting recovery of them as a regulatory asset.
Thank you. Let's move on to your direct testimony regarding your PNM's request for accelerated depreciation of its gas plants. In preparation of that testimony, did you review any other commission decisions?
No, I did not. For direct testimony, that was the decision to change the terminal dates was made by management at PNM.
So are you aware that a similar decision in PRC case 20-00104 by El Paso Electric in their last general rate case proceeding? El Paso Electric made a similar request that was ultimately denied. Are you familiar with that?
I am aware that they had a similar request to shorten the lives of their gas facilities.
Are you aware of any distinguishing factors between your request and El Paso Electric's that would warrant a different approach by the commission?
I didn't study the El Paso order all that in depth. From the interest of our customers and what makes sense for PNM, we believe it's the right decision and the right choice to reflect depreciation rates and service lives for the facilities based on our expected and intended use for those lives. And so we believe the request is appropriate to propose to the commission to adjust our depreciation rates for those gas facilities.
All right, my last line of questioning is going to be around your testimony regarding Four Corners power plant.
Yes, sir.
Could you follow me to your rebuttal testimony at page 64? Specifically at line 2, where you state that Four Corners has proven to be a necessary resource. Can you tell me?
Sorry, is that unnecessary resource or unnecessary?
A necessary resource.
Thank you, sir.
Mr. Monroy, can you tell me the basis for that statement?
Sure. Four Corners continues to provide electricity and capacity to meet our customers' needs and has been operational since that time. And so that's what it is based on.
Do you have access to ABCWA Exhibit 6A as an apple?
Yes, sir, I do.
And would you please identify that?
This is interrogatory NEE 15-4.
And you sponsored that response along with Mr. Frank Graves, correct?
That is correct.
And if I asked you that question again today, would your answer remain the same?
Yes, it would.
So at the time of the application in PRC case 21-00017, PNM stated it would be in customers' benefits to abandon Four Corners, correct?
That is correct. That was the conclusion reached at that time. And PNM then sought approval to abandon its interest in the Four Corners power plant.
So if it's true that customers would have benefited by being served by replacement power instead of Four Corners replacement, or instead of Four Corners power plant, haven't customers been harmed by PNM's continued involvement in Four Corners power plant?
No, I disagree. And really, you're looking at two different time periods under which a decision was being made. And what has, as we mentioned earlier, through this rapid transition of our generation portfolio, facts and circumstances that may have existed earlier in 2010, in the earlier part of that decade, are much different than the facts and circumstances that existed when PNM filed for its abandonment or for its application to abandon its interest in Four Corners. And absent that abandonment, there is a need to serve our customers' needs, and Four Corners is providing that need to meet our need, to meet the customer's energy and capacity needs.
Moving to your rebuttal at page 67, line 10, you refer to the generally accepted accounting principles, or GAAP, regarding newly completed plant in service.
Yes, sir, I'm there.
Do you recall what year Four Corners power plant was completed?
I don't.
Would it be fair to represent around 1969 and 1970?
That seems fair. I have no reason to doubt that.
So do you believe that PNM's interest in Four Corners still meets the definition of newly completed plant in service?
Yes, it does. The accounting requirements is referring specifically to new capital projects that are put into rate base in this instance. It is not referring to the Four Corners initial completion of plant. And so the accounting standard requires new capital projects, or considers new capital projects as newly completed plant in service.
At lines 18 through 19, you state that the charge to earnings for GAAP still reduces the equity balance of PNM, resulting in additional harm to PNM that is unwarranted. Correct?
Correct.
Has PNM estimated any equity balance reductions for any changes to earnings and how much damage that would cause PNM?
Relative to what?
If there were any disallowance for Four Corners?
Oh, yes. Yes, we have. Relative to, for example, the recommendation from the Attorney General, which is a debt-only return, I believe, for capital investments through from 2019 through the end of the test period. PNM is estimating the impairment that would be required is in the range of $16 million to $21 million.
And that may have been a table in your testimony. I wonder if you could tell me what you're referring to for that.
That is not in, oh, sorry, I didn't mean to cut you off. That is not in my testimony. What is in my testimony on page 65 is the annual reduction to the requested revenue requirement as a result of those proposed debt only, or as a result of those proposed recommendations from the parties. Because the impairment is recognized for accounting or GAAP purposes only and not for regulatory purposes, that 16 to 21 million dollar range is not included in this table. So they would be above and beyond these amounts that are stated on page 65 in PNM table HEM-2 rebuttal.
Where is that analysis provided in the record, Mr. Monroy? The 16 to 21 million dollar range.
It was not provided at the time we prepared the rebuttal testimony. The analysis wasn't complete. And so we just added the reference to the impairment analysis, but we did not provide as an exhibit or the calculation of that estimate.
Okay, thank you.
Just so, sorry, Mr. Hearing Examiner. Just so I'm clear, you said that 16 to 21 million dollars would be above and beyond. So just so we're speaking clearly, would that be in addition to the numbers in table HEM-2 or some combination of those numbers?
It would be in addition to, and so just to be clear, the numbers on page 65 is an annual reduction to the requested revenue requirement, right? So I believe we're asking for approximately $791 million. These adjustments here would be reducing that $791 million by the amounts. The 16, so that'd be an annual reduction in revenues every year. The 16 to 21 million dollars would be a one-time charge to the income statement if these recommendations are adopted. And so they would be in addition to.
So that cuts into PNM's earnings.
It does reflect, it does hurt the earnings for that year. That is correct. Because it's a one-time charge to the earnings. So that would reduce the earnings in that year recorded. And as a result, reduces the equity balance.
And that's as a result of applying GAAP principles.
Correct. Under generally accepted accounting principles, it looks at that newly completed plant that's not getting a full return, and it requires an impairment analysis to account for the difference.
Right.
Okay. Thank you. I believe that is all of my questions, but at this time I will move to admit ABCWA Exhibit 6A.
Any objection
No objection from PNM.
from anybody else? Very well. ABCWA Exhibit 6A is admitted.
Thank you, Mr. Examiner. Thank you, Mr. Monroe.
Thank you, Mr. Herman. Hope you feel better.
Thank you.
Yeah, I convey the same to Mr. Herman. Feel better.
Thank you.
Thank you. Okay. We are on to the next cross-examination, which I believe is the Attorney General, who has also requested 30 minutes with Mr. Monroy. Is that correct, Mr. Elliott?
Yes.
Okay, please start.
Mr. Hearing Examiner, so the timer that there was a timer up. Should I just be using my own?
I'm starting it now. I just
Okay.
wanted to wait till you started talking, to be
Thank
fair,
Appreciate
to
that.
not cut into your time. So go ahead.
Thank you. Good afternoon, Mr. Monroy.
Good afternoon, Mr. Elliott.
It's good to see you.
Thank you. Likewise.
So if you would turn to the bottom of page 12 of your direct testimony, please. This is where you are discussing the company's non-fuel revenue requirement. And you state that it includes the costs of cleaner energy resources that will be serving customers during the test year. You see that?
Yes, sir.
Just to clarify, that's the calendar year 2024, right?
Excuse me. Yes, sir. That is the test period I was referring to. Is calendar year 2024.
Okay. So some of the resources in the test year are projects that have yet to come online, but those are projects the company anticipates will be serving customers in 2024. Is that right?
That is correct.
Okay. Once these new energy resources are online, does PNM plan to remove Four Corners from its portfolio?
No, sir, it does not. These resources that I'm referring to are primarily associated with the expiration of the Palo Verde leases, as well as additional resources to meet our system planning requirements.
Well, what is the planned disposition for Four Corners? Is it shut down, sale? Has that changed since its last abandonment filing?
So subsequent to the Supreme Court decision that confirmed the commission's decision in the abandonment application, PNM is currently evaluating what is in the best interest of its customers regarding the abandonment of Four Corners. If at that time it is in the best interest of customers to abandon Four Corners, PNM would make abandonment filing as such and request that from the commission.
And you referred to at that time. What time would that be after? Can you elaborate on that?
So PNM's currently evaluating it. No decision has been made, but I assume that based on it, we're doing that analysis currently. PNM previously had an outstanding RFP for resources in the 2026, 2027, and 2028 time period. And so based on those RFPs, the information there, we're evaluating if it makes sense for PNM to abandon its interest and at what time and at what period. I do anticipate that evaluation to be complete by the end of this year into the first quarter of next year.
And does that evaluation include discussions with stakeholders in Four Corners?
Yes, sir. We do have some planned stakeholder outreach regarding the 2026, 2027, 2028 resources. We probably plan to primarily use the biweekly meetings that we currently have in effect, as that already has a lot of parties and schedules already aligned to get their input.
And what about with by stakeholders? I'm including the partners in Four Corners and the Navajo Utility Authority as well.
I apologize with that. I apologize for not being clear. As regarding to the exit of Four Corners, there currently is an agreement with NTEC to exit by 2024. Any evaluations would have to consider whether additional agreements are different, whether that agreement remains or modifications of that agreement or different agreements would have to be made to facilitate that exit. So that's part of the evaluation on whether exiting Four Corners, it makes sense for our customers.
And refresh our recollection, NTEC stands for Navajo Transitional Energy
Corporation.
I forget. Corporation. NTEC, yeah.
That's
okay.
Subject to check, I believe that's what it stands for.
Okay. Go ahead, Mr. Elliott.
Thank you.
Mr. Marks?
I believe the C is company.
Company. Thank you, Mr. Marks. You don't, okay.
Thank you.
Right, thank you. Thank you, Mr. Marks. Go ahead, Mr. Elliott.
Thank you, Mr. Monroy. If you would now turn to page 32 of your direct. This is where we begin the discussion on regulatory assets and liabilities.
Yes, sir, I'm there.
Okay. So in the next few pages here, you discuss whether regulatory assets should be limited to costs that are unusual in nature or occur infrequently. You recall this?
Yes, sir.
And you conclude in your opinion, a regulatory asset should not necessarily be required to meet either of those standards in order to be recovered from ratepayers. I believe that's on page 37. Do Do you see that?
Yes, I agree. I do not think that unusual nature or infrequency of occurrence should be a threshold requirement. I don't disagree. It can be a consideration, but I don't think it should be a limiting requirement.
Okay, so staying with the standard of unusual in nature or infrequent occurrence, you say on pages 36, 37, that if the commission does apply that standard, you believe that the undepreciated investments in Palo Verde leases meet those standards. Is that right?
Yes, I do believe that if they want to apply that standard, then due to the rapid transition, which I believe I
Right.
covered, I can't remember if that was you or another
Mr.
attorney, I
Herman.
apologize. Mr. Herman, correct. Justify that it meets those criteria.
Okay. So in your opinion, do all of the regulatory assets being requested in this case meet the standard of costs that are unusual in nature or occur infrequently?
No, they do not.
So if we could just go to page, I'm looking at page 34 here of your direct, and you state on lines 16 through 17 that, quote, by their nature, each regulatory asset or liability should be evaluated on its individual merits. Do you see that?
Yes, sir.
Okay. So do you believe there should be any standard or criteria that a cost must meet in order to be recovered as a regulatory asset?
Not necessarily. Well, yes, but I think it's difficult to put parameters around when it makes sense. And I guess I would point the commission really back to the purpose of them, right? And it's really for regulators to allow costs in a period other than in the period in which they would be charged an expense. Excuse me. And so then I would think that is kind of the guiding principle of regulatory assets and regulatory liabilities, is really that ability for the commission to have costs from one period be reflected in another. And I guess that makes the same for regulatory liabilities, which could be the inverse of the cost, which would be like a refund. And so it's difficult to put a specific criteria on them. For example, and I'll give you a couple examples of why it's not, or why it's difficult to kind of put there. One is, most utilities have these treatment of rate case expenses. It's been longstanding commission policy to collect those prudent allowable rate case expenses over a period beyond in just 1 year of the test period. So a regulatory asset allows the commission, the utility, to spread those costs from one period into future periods to try to match up the benefit of when those rates are in effect to the cost incurred. Another example is the regulatory assets associated with the costs we've incurred, say, for defined replacement resources for the Palo Verde assets, for the Palo Verde leases, excuse me. Those costs, had the replacement resources inevitably been, say, utility-owned generation assets, then those costs would have normally been capitalized as part of plant and service, as they were costs necessary incurred to deliver that asset to serve our customers. You know, in the instance where we've seen the proliferation of energy storage agreements, PPA agreements, there's no underlying hard asset under which to capitalize those costs. So in those examples, the regulatory asset serves its purpose to collect those costs from customers over the life of those resources, as they were the costs necessary incurred to lock up or identify or procure those resources that benefit customers.
Great.
So that's just kind of examples of why it's difficult to put a box in there, because getting replacement resources is not unusual in nature or infrequent of occurrence, but the concept there is a logical, valid rate-making principle.
Will, we can come back to this subject. I just want to move on to another one. On page 38 of your direct testimony, you discuss, you respond to the question, Well, you state that the commission should not consider what role a utility played in developing legislation promoting early plant closures when it decides whether to authorize a regulatory asset, right?
That's correct. Yes, that's my testimony says on page 38.
Okay, so for example, and tell me if I'm correct, that your position is that if PNM was instrumental in developing the ETA and working for its passage, that fact should not be considered by the commission when it evaluates whether or not to approve a regulatory asset for stranded cost recovery.
I guess I would state whatever role PNM takes in legislation, ETA or anything else, I don't believe that should have any impact on recoverability, as that's a protected right for PNM to exercise in the legislative process, same as any other individual or party who would like to participate in those processes.
And PNM has two facilities that would qualify for securitization. The first is San Juan and the other is Four Corners, correct?
That is correct. Those are qualified generating facilities under the Energy Transition Act. That is correct.
And just to be clear, there are no others that you're aware
Not that I'm aware of.
Okay. So would you agree there's at least two, maybe more categories of regulatory assets? Those associated with stranded costs and those associated with some other type of cost?
I don't necessarily think of stranded costs as its own category of regulatory assets. I think, for example, in the instance of Palo Verde leases, a stranded cost, it looks a lot very similar to other regulatory assets where we've demonstrated benefits to customers based on a course of action taken by the utility. Those benefits flow through to customers, and there's a cost to achieve those benefits. In this instance, it was beneficial for PNM to not reacquire the leases, to have alternative replacement power serve our customers. And based on that cost benefit, and those benefits existed even with the full recovery of these stranded costs. And so I don't put them in its own category. I put it in as a very much category, very similar to EIM, where we demonstrated benefits to customers, how we demonstrate on loss on required debt, where there's benefits to taking certain actions. And those regulatory assets allow recovery of the cost to achieve those benefits.
So then let me ask you, so there is no real category or types of regulatory assets in your view?
I really would go back to as far as what the purpose of the regulatory asset, which is really to include costs allowable in one period to a period other than when they normally been charged to expense.
So the commission shouldn't even really consider whether it's a stranded cost when evaluating the regulatory asset and whether to permit recovery. The fact that it's stranded shouldn't be a factor.
It's a factor in that it's the nature of what created the regulatory asset to begin with.
Okay.
I was responding to you saying there was two categories, stranded costs and then others. And I was trying to highlight where it's not that black and white.
Okay. Well, let me ask you this about another factor or possible factor. Do you think there should be any consideration of the materiality by the commission in terms of thresholds for a regulatory asset, when to permit recovery through an asset or otherwise?
So materiality, and I think I covered this in my rebuttal testimony as well, I think is a valid consideration. However, should not be, once again, a threshold requirement. But I do think there is a certain point of common sense of just what makes sense to even address from those perspectives of moving costs from one period to another or vice versa.
Okay. And are there certain costs that are not reflected in rates that in your view should be absorbed by shareholders and not recovered through a regulatory asset? And if so, could you provide some examples?
There are costs not included in rates. I mean, there's always costs that aren't included in rates. I mean, rates are set on a cost of service or a test period. that the, commission reviews and then sets rates at that period. Until rates are reset, underlying costs always fluctuate and move up and down. And so I don't know if there's a specific set of costs, but there's always certain costs that we've incurred that may be higher or lower than when rates were set, or things of that nature, that really are the responsibility of the utility to manage those costs. And if the rates that are in effect are insufficient, then the utility should request to change those rates before the commission.
It'd be great if you could provide an example.
Four Corners?
I'm not sure, Mr. Hearing Examiner, should we have Four Corners? I would say the ESA charge, the demand charges associated with the energy storage agreements are an example. I mean, those costs have not been reflected in our cost of service studies, as they're all post 2018 test period. They're not flowing through PNM's fuel and purchase power cost adjustment clause. They are costs that we are incurring, and until rates from this proceeding are put into a place that reflect those costs, then those are just new costs that are just borne by the utility.
Well, weren't you seeking recovery of the Four Corners and undepreciated investments through securitization? And so isn't that another regulatory asset?
Oh, yes, sir. That would be an example of a regulatory asset that
That's
upon
what I was mentioning by Four Corners. I'm sorry.
Okay, yes, that upon abandonment, when that plant's no longer used and useful for customers, then that would be removed from plant and service, recorded as a regulatory asset to be securitized under PNM's old application.
Right.
Mr. Hearing Examiner, may I continue?
Just trying to help out, Mr. Gill.
Yep,
Mr.
absolutely.
Elliott.
You looked as if you had another question forthcoming, so
No, I was waiting for you to go ahead. I'm
Okay,
sorry.
thank you.
Apologies. I'll add a minute to your.
Okay, all right,
process.
thank you. Mr. Monroy, if we could just turn to your rebuttal testimony, page 4. Are you there?
Yes, sir, I'm there.
So lines 3 to 5. You state that since 2019, when the last phase of PNM's last rate case went into effect, PNM has been able to manage costs, which has permitted PNM to defer filing a base rate case until now. Am I correct that one of the factors that delayed the filing of this rate case was the Avangrid merger?
Yes, subsequent within the Avangrid merger, there was an agreement reached with PNM and the parties to delay the filing of this case.
Okay, but for that filing, it's likely this rate application would have been made earlier.
That was the intent.
Okay.
Yes, sir.
PNM did file for approval of the grid modernization program, right?
Yes, sir.
And that filing sought approval for a new investment of $344 million. Is that right?
That's correct. I believe over a 6 or 7 year period. I'm not sure exactly the time period, but.
Do you know if PNM plans to use the funds received from securitizing its stranded assets in San Juan to fund the grid modernization program?
I don't. I think that's a question better asked of PNM witness Greinel, who's our assistant treasurer.
Okay. Well, generally, how does PNM obtain cash to fund that kind of capital expenditure?
So no different than how we fund any of our capital programs. We issue debt as needed we have to increase our debt. We also then receive equity infusions from PNM Resources to keep a balanced capital structure.
Okay. So now I do want to go back to Palo Verde. Specifically, if you could turn to pages 40 to 58, turn to 40 of your rebuttal testimony, please.
Yeah, Yes, sir.
And I just want to try and summarize the issues that are still in dispute here. PNM originally sold some of its Palo Verde capacity and then leased it back from the new owners. Is that right?
PNM entered into sale leaseback transactions for
Okay.
PNM built in New Palo Verde units 1, 2, and 3, and then entered into sale leaseback agreements for a component of that capacity for units
Okay.
1 and 2.
And during the time that the leases were in place, PNM was responsible for making capital expenditures associated with the leases. Is that right?
That is correct. We call
Okay.
them leasehold improvements. Yes, sir.
Leasehold improvements. And when the leases originally expired in 2015, PNM chose to extend the leases for an additional 8 years. Is that right?
That is for the ones that are subject that we're talking about. I mean, there's been multiple leases throughout the periods, but for the 104 megawatts of unit 1 and 10 megawatts of unit 2, there were 5 leases. And yes, PNM extended those leases pursuant to the extension agreements within the sale leaseback agreement. However,
Okay.
those leasehold improvements were not being depreciated or recovered over the life of the leases. They were being recovered through the terminal date of Palo Verde, which has to do with the NRC license extension. So they were being depreciated over a much longer period of time.
Okay. So one of the issues that's being addressed in this case by other witnesses is whether or not PNM should have extended those leases and whether that was a prudent decision, right?
Could you refer to me which witness is raising that issue? I don't. I thought most of the issues were on recovery of the requested regulatory asset associated with those 5 leases. Because because I believe the commission already ruled that the extension of the leases themselves were imprudent and already provided for the remedy to that imprudence in the 15 case.
Okay, well, let's put the issue of prudence aside. PNM did extend the leases and was responsible for capital investments during the lease period until the leases finally expired in January of 23, right?
That is correct for unit 1. That is correct.
And about $93 million of that investment has not been recovered yet. Is that right?
So we are requesting $90 million associated with the 104 megawatts for unit 1 and $7 million for associated with the 10 megawatts in unit 2. Those represents the leasehold improvements that will not be fully depreciated and will be reflected as stranded investments that we're seeking recovery. Those are not necessarily as a regulatory asset. Those are not necessarily the capital improvements that were made subsequent to the extension of the leases. That's not the same number.
Okay. But PNM is seeking a return of the investment as well as a return on the investment at its weighted average cost of capital, right?
That is correct.
Okay. So one issue regarding Palo Verde is whether that stranded investment should be recovered from ratepayers. Mr. Herman alluded to that as well, right?
Yes, that is that we have requested recovery of those stranded investments in this proceeding, and other parties have taken a different position.
And a second issue is whether the company should have continued to collect the Palo Verde lease costs from ratepayers once the lease is expired, right?
No, I don't believe that is an issue before this commission. As I said, when in the 2015 rate dates or 15-261, the commission ruled that as a remedy for that prudence, they did not exclude the lease costs nor the leasehold improvements from the revenue requirements. And so we've continued to include those lease costs and leasehold improvements in our subsequent 2016 rate case. And at this point now, the leases have expired by the time you get to the test period, so we're seeking recovery of those stranded costs.
Well, when you say it's not an issue, if you turn to page 10 of your rebuttal testimony, this is lines 6 through 7. He says, I'm sorry, you say, he says, you say that certain parties are seeking regulatory liability to recover the amounts represented by the expired leases. And you say that this recommendation should be rejected for what it is. You see that? You can
Yes,
finish
sir.
that sentence.
It says this recommendation should be rejected for what it is, an opportunistic attempt to use this rate case to engage in improper piecemeal and retroactive rate making.
Okay. So am I correct that in order to avoid the prohibition on retroactive rate making, regulatory commissions generally have to authorize a regulatory asset so that the utility can defer costs and seek future recovery?
Could you ask your question again? I'm not sure I get what
Well,
point, what
I
you're
guess,
saying.
let me see if I can say it this way. In order to avoid the prohibition on retroactive rate making, the utilities have to be on notice that.
Yes, I would agree with that statement.
Okay.
Especially when, in the instance for the Palo Verde reg liability, really the rates were set and PNM was not put on notice that subsequent to those lease costs or any cost changing or going away, those rates may be subject to refund or subject to adjustment. And so that's why PNM's view that regulatory liability is really more a request to refund previously approved current rates.
So, but the commission did establish a regulatory liability for lease payments that were collected in base rates after the leases expired, correct?
The commission did require PNM order an accounting order for a regulatory liability to be dealt with in this proceeding.
And that's about $38.4 million as of January. Is that right?
That's subject to check. That sounds right.
Okay. And another Palo Verde issue is whether that regulatory liability should be refunded to customers, right? That's what we're talking about here.
Correct. Yes, that's fair.
So with Palo Verde,
3 minutes, Mr. Elliott, 3 minutes.
okay, thank you. So with Palo Verde, the two principal issues are the lease payments collected after the lease is expired and the stranded costs for capital investments made during the lease period, correct?
So in the first one, if the lease payments, you're referring to the unit 104 megawatts as a regulatory
After the expiration.
Yes, sir. I understand.
Okay.
Those are two issues that are raised in this case.
And just want to make sure that we get this for the record. It's PNM's position that it should not have to refund the regulatory liability and it should be permitted to recover 100% of its stranded costs. Is that right?
That is correct for the reasons outlined in our testimony. That is correct.
Okay. And PNM has also included two other regulatory liabilities associated with Palo Verde in its filing. One was for the cost of getting replacement resources approved, and one for the true-up costs versus proceeds received from the Salt River project. Is that right?
Yeah, I believe you said regulatory liability, but they are regulatory assets. But yes, sir, I agree that those are the two associated with Palo Verde.
Okay. And these regulatory assets, they all relate to Palo Verde or to certain common plant sold once the lease is expired. Is that right? The common plant, I guess, is related to Salt River project, isn't it?
The regulatory asset for the Salt River project, I would defer you to Mr. Sanders. I think he has a little bit more detail on that one than that I have in my hand.
So
regarding the undepreciated investments, I think I've covered what those reflect. They're the investments we've made as leasehold improvements that have not been fully recovered from our customers.
Okay. And lastly, in addition to the costs we've just been discussing, PNM is also included in rate base other investments in Palo Verde that it is still continuing to serve customers, correct?
Yes, for the remaining portion of Palo Verde not associated with the 114 megawatts leases.
And the AG has not recommended any disallowance for those costs, has it?
No, sir.
I have no further questions, Mr. Monroy. Thank you very much for your time.
Thank you, Mr. Elliott.
Perfect timing, Mr. Elliott.
Thank you.
Thank you, Mr. Elliott. Thank you, sir. And apologies for interrupting you, but I added a minute.
Most welcomed interruptions. Thank you.
Thank you, sir. All right, Mr. DeSalen, you have 20 minutes with Mr. Monroy, is that correct?
Yes, that's correct, Mr. Hearing Examiner, and I am optimistic that it will take less than 20 minutes.
Well, that's great. Let's go ahead and start then. Thank you.
Okay, thank you. Good afternoon, Mr. Monroy. My name is Charles DeSalen, and I'm an attorney representing Coalition for Clean, Affordable Energy. And I have just a few questions for you, and all of them will refer to your direct testimony.
All right, thank you. Good afternoon, Mr. DeSalen.
So my first question is on page 1 of your direct testimony. And right about on line 14, you make a reference to PNM's pledge to have a carbon-free generation portfolio by 2040. And there are other places in your testimony, in your written testimony, where you reference this pledge. And I just want to clarify, is that, to your knowledge, and as with previous questioners, I'm not asking for a legal opinion here, but in your experience and to your knowledge, is that pledge in any way binding on the company?
No, it's not. It's a stated intent, and it's been reflected in our integrated resource planning documents beginning in 2020, where we also confirmed that was our goal, or that was our target that we were trying to achieve, to have a carbon-free portfolio by 2040. But not being a lawyer, my understanding is it's not a binding requirement. However, it is the direction under which PNM is currently operating and moving towards.
Okay, thank you. Then my next few questions are on, I'll refer you to page 4 of your direct testimony. And Mr. Albright touched on this a little bit, but I have a few more questions, and there were actually some, you threw out some numbers on the gas plants that I wasn't quick enough to get them all down. So I'd like to go over that with you quickly again. So starting on line 13 there, you refer to the shortening of the terminal dates of several natural gas-fired facilities. And I believe that you said that for the Afton facility, that was going to be shortened by 2 years and would be terminated or shut down in 2042. Did I get that right?
Right, so the current terminal date for Afton is 2042 of what PNM's previous depreciation rates are based on. In this case, PNM requested its depreciation witness to develop rates that reflected a terminal date of 2040 for Afton, so 2 years less.
Okay. And then I think you said that a second one, I think it was Lalouse, but I might be incorrect on that, had basically the same schedule.
And so the second one that had a 2042 that moved to 2040 is the Lordsburg Generation Station.
Okay, I think that the too many L's got me a little confused. And then the Luna, I think you said was going to be closed 6 years early.
Yes, so Luna Generating Station currently is 2046, so that's moving to 2040.
Okay, and then the last one was Lalouse, and that one I think you said was 15 years early.
Yes, sir. That one is currently 2055.
Okay, and how is PNM planning to replace these resources?
So at this time, there's many options. They could be repowered with cleaner fuel instead of gas, or they could be retired and replaced with other resources. There has been no firm decision on how those gas plants will be treated and how they'll be transitioned out by the time we get to 2040 at this time. Those are better,
Okay.
those are analysis and things that are typically done in our integrated resource planning process.
Okay. And when you say cleaner fuels than gas, are you referring to hydrogen?
That my understanding is that could be an option.
Okay. Is there anything else?
I'm really not the expert in technologies and what those transitions should be, but I have heard hydrogen. I'm sure, I don't know, there could be other technologies as well.
Okay. And then also on line 14 there, you say certain natural gas facilities, including, and then you list those 4. Are there any others?
Yes, sir, there is. We have our Reeves generation station, and I believe also our Rio Bravo generating station.
Okay, what was the first one?
Reeves generating
Could you
station.
spell that?
REEVES.
Okay. And do you know what the schedule is for those?
I'm not sure I wrote that down. So Reeves, and this is from the 2020 IRP, has an assumed in life in 2030.
I'm sorry, the what number IRP?
Oh, the Reeves in life pursuant to the 2020 IRP is,
REEVES.
apologize, yes, Reeves, apology, is 2030. And then Rio Bravo, let's see, just says through 2039, but it doesn't read the same about assumed end of life. So I don't necessarily have Rio Bravos in front of me.
Okay. So 2030 is the new date for Reeves?
It's not new in that that's not a change from what our current depreciation rates are today.
I see. So you're not changing Reeves. Are you changing Rio Bravo?
Not the terminal date.
Okay.
There are the depreciation rates that we propose for the generating facilities. There are changes, and so there is a different depreciation rates, and I believe they have increased, for example, at Rio Bravo, but it's not because of the change of the terminal date.
Okay. Oh, okay. So the next thing I want to ask you about is on page 8 of your direct testimony.
Yes, sir, I'm there.
And let's see. About, let's see, line 15, 16, 17. You talk about, it's on line 17, I guess. You mentioned that the shift from large central generation resources to smaller, more distributed resources, and that includes the cost of batteries to store renewable energy. And when you refer to the cost of batteries, does that include the battery storage that is the subject of a pending application before the PRC? And I believe that is number 23-00162 UT.
It does. The test period includes the associated capital project associated with the 12 megawatts of distribution sided energy storage. As well, It also refers to recovery of the energy storage agreement demand costs that we've effectively contracted for.
Okay. And that answers my next question. Okay, so My last few questions are on page 10 of your direct testimony. We'll refer to page 10. And there you talk briefly about the time of day pilot project, which is time of day, as I understand it, is a reference to time of use rates.
Correct. That's our time of day pilot program that we are proposing in this proceeding. Is what I'm
Okay. Okay. Now, did PNM give consideration to just sort of skipping the pilot program and going directly to time of use rates or time of day rates based on its experience with time of use rates so far and based on other states' experience?
I think the determination for the pilot program was based on, I think, some feedback received during the Pricey Advisory Committee. However, I did not participate in those, so I think that's probably a question better asked of Ms. Chan.
Okay. And do you know if PNM considered a larger sample for the pilot project?
I don't know. I didn't get into the details at that level. So perhaps Ms. Chan or Dr. Pitts, who I think covers it more fully in her testimony. Dr. Pitts may actually be more appropriate.
Okay. And then my last question is kind of along the same lines. And that is, did PNM consider leaving the pilot project open to all of its customers?
Once again, I'll defer you to Ms. Chan or Dr. Pitts to give you a little additional information on that.
Okay. Thank you, Mr. Monroy. That is all the questions I have.
Great. Thank you.
Thank you, Mr. DeSalen.
Thank you, Mr. Hearing
Thank
Examiner.
you very much. Thank you, sir. All right, let's, Mr. Marks, are you available? Yes, you are. You have 20 minutes with Mr. Monroy. Would you like to begin now?
Yes, I think I only have 10 minutes though, Mr. Medeiros. I think we cut it.
I'm sorry, Mr. Marks, I can barely hear you.
Is this better, Mr. Lee? No?
No, sir.
Oh, you cut it to 10. That's right.
We did cut it to 10, but I need to. We checked.
You sounded better before.
Well,
how's
this?
That's better.
That's better.
Okay. I tested it during the break and they said it was better. Are we ready to go?
Yes, please.
Okay.
Starting your 10
Thank you.
minutes.
Mr. Monroy, I'm going to refer you to your table HEM2, page 65 of your rebuttal.
Yes, sir.
Okay. Who did the calculations for that table?
They were prepared by the cost of service group. So under the direction of Kyle Sanders.
And am I correct that they were prepared by making some changes and running them through the cost of service model?
Yes, sir.
Okay. What was the cost of debt used? Was it the 3.72% in Ms. Greinell's SGG1?
Subject to, yes, 3.72%. Yes, sir.
Okay. And do the numbers in that table assume approval of PNM's requested 10.25% ROE?
Yes, they do.
Okay. And then you discuss a 4.7 million in an existing rate reduction for debt only return on certain Four Corners investment, same page. Is that calculated based on the new ROE and debt or based on the historic cost of debt, which I think is 4.86 in your response to SC13?
That 4.7 is actually referring to the revenue reduction that was included in rates from the 2016 rate case. So it would reflect that capital structure at that time.
So that'd be a higher cost of debt and a lower cost of equity.
Yes, sir.
Okay, so prospectively, the amount of the reduction for the debt only that's PNM is not contesting would be greater. Is that correct?
Correct. I believe that number, and I thought I wrote it down in my notes, but I did not. But I know Mr. Sanders can give you what that equivalent number is based on our as filed case. I just,
But it's not anywhere in the record, is it?
it should be within his cost of service exhibits that you could calculate. I don't know if it's clearly stated, but I believe he may have an exhibit that calculates that.
And in any event, the cost of service does reflect. Would you agree? Can you confirm the cost of service that PNM is requesting does reflect the lower cost of debt?
Yes, sir. And it reflects this debt only reduction.
Okay. And then in terms of the base that you calculate, that PNM calculated for this HEM2, is that based on the 148.7 million in investments that were identified in the commission's order from case 16-00276, or based on the 130 million in 2016 to 2018 investments that you provided in discovery in this case? And I'm referring to NEE 8-1.
So the 4.7 million would have been based on the $148 million. Whatever the debt only return on would be for the actual capital investments from the period of July 16 through 12/31/18. The $130.3 million. I know where that number is coming from. I don't remember if it's based on that or the actual net book value associated with those capital investments. But Mr. Sanders could clarify, but the numbers are approximately right. I mean, that I know what you're talking about. I would believe it'd be based on the 125.1, but that's the estimated net book value at 24. So.
Okay, and you think that's what HEM2 is based on?
I'm sorry,
I know-
Mr. Marks, I can't hear you.
You think that's what HEM2 is based on, the actual net book value?
So HEM-2 has nothing, isn't based on, yes, we based on the actual values during those periods. I apologize. That's right, because yes.
And the difference between the 148 million and the 130 million are investments. Do you know what that difference is?
I believe they were just the projected investments that were used in the future test year compared to the actual investments that were actually cleared and placed in service for the same time period.
Do you know what the difference was specifically? Was it particular items, or were the cost same items, but they cost less?
I don't have a reconciliation of the two.
Okay. You rebut Dr. Fisher. Do you agree with Dr. Fisher that PNM uses Encompass, and that's all caps, ENCOMPASS, a sophisticated capacity expansion model to select its new generation resources?
I don't specifically talk about Encompass, and I'm not that familiar with Encompass itself. So I'm not sure how to answer your question. I wouldn't.
Are you aware whether PNM uses it?
I mean, I have heard of that system. I'm not involved in the resource planning, so I can't say. I have no reason to disagree with you. I just don't know what or for what purpose Encompass is used in our integrated resource planning.
You were asked earlier about the NTEC purchase and sale agreement. Do you know if it can be terminated by the seller if regulatory approvals are not obtained?
I don't. PNM witness Heffington would probably be a better person to ask for that question.
Do you know if PNM is required by that agreement to resubmit an application to get it approved?
I don't know.
Okay. Are you familiar with the Four Corners Seasonal Operation Agreement, which is also known formally as the 2022-2025 Coal Supply Agreement Amendment?
Other than I know there was a seasonal operational agreement. I'm not familiar with the details of that agreement.
Do you know if it automatically terminates if the purchase and sale agreement doesn't close?
I don't know, but I believe P&M Witness Heffington can probably provide you that information.
Do you know if it has been terminated?
I do not know.
Do you know if it's going into effect as stated in the fall of 2023?
I don't know that either.
Well, thank you, Mr. Monroy. You, the things you did know, the details of the capital numbers were impressive. And I think we've reached the end of the questions I have about things within your knowledge. Thank you.
Thank you.
Thank you, Mr. Marks. Before we turn to Ms. Nanazi's 55 minutes of cross-examination, is that right, 55 minutes, Ms. Nanazi? Let's go ahead and take our afternoon break, if that works for the parties. 15 minutes, we'll be back at approximately 5 after the hour, 3:05. All right, thank you all. We're in recess until 3:05.
Thank you.
All right, Ms. Nanazi, are you prepared to start your 55 minutes with Mr. Monroe?
Yes, I am, sir.
Please go ahead.
Good afternoon, Mr. Monroy.
Good afternoon, Ms. Nanazi.
You are a PNM Resources Vice President of Regulatory and Corporate Controller. Is that right?
So I am the Vice President of Regulatory and Corporate Controller for Public Service Company of New Mexico. For PNM Resources, my title is just Vice President Corporate Controller.
And you're paid by PNM Resources?
That is correct. I am a PNMR Shared Services employee.
And I think we've already established that you are the highest ranking PNM officer to testify in this case. Is that right?
That is correct.
Is it true that in the fall of 2013, I'm referring to the September through December timeframe, that you were the Director of Cost of Service and Corporate Budget for PNM Resources and its subsidiary PNM?
Subject to check. That's fine. I don't recall, but
it sounds right.
Sounds right.
It came from your HEM testimony in 13390. So
great. Okay, thank you. Yeah.
You would agree, would you not, that higher rate-based earnings result from capital investment?
Not higher rate-based earnings. I mean, the allowed return is the same on rate base as authorized by the commission. So I guess, yes, increased rate base results in increased return on that rate base.
Would you also agree that investing in core capital results in rate-based growth, which leads to earnings growth and sustains dividend growth for investors?
Relative to everything else being constant, yes. I mean, rate base also is reduced by depreciation on previously expended capital projects, which lowers rate base.
Sometimes, right?
Depreciation always lowers rate base.
Even when you continually add capital expenditures?
Oh, in totality, I was just giving you, there's pluses and minuses to how rate base grows at a utility.
In August and November 2013, PNM was announcing publicly that it expected core capital investments between 2013 and 2017 to be 1.8 billion and expected depreciation in 2013 to be 153 million. Is that correct?
I don't recall those numbers. I don't have a basis for them.
Could you please look at Administrative Notice 12?
Could you identify it for Mr. Monroe?
Yes, it was New Energy Economy number 4.
Thank you. And it's in Dropbox labeled as such.
Yes, it is.
And Mr. Hearing Examiner, I'd like to make an objection. If I may. It appears that this line of questioning is going against one of your admonitions, which is to recross, in effect, witnesses that were presented in prior cases, and getting into matters that were taken up in case in the 2016 rate case. And so I think as I understood what you had intended is that we would not revisit that type of examination, and simply examine the witness on the matters in this case.
Well, we do. Before I have, I'm sorry, I have a doctor calling me that did you hear that in the background, by the way?
I did not.
Oh, good, because I had a call coming in from one of my doctors, and I couldn't quite, I think I got the gist of the objection. I apologize for that, but it's unavoidable because this is connected to things for the case as well. I'm holding up my iPhone. In any event, yeah, Ms. Nanazi, we have a dilemma here because we're going to focus on only those witnesses in the case who provided testimony on the prudence issue, although Mr. Monroy did provide some of that in his rebuttal, right? Yes?
Yes, he did, yes.
Okay. So how do you respond to the objection?
Well, basically, this is testimony that I believe is in the record already through your administrative notice. I only have one or two more questions. This is background for what I'm about to go into, which is questions about both depreciation and the prudence of Four Corners, as he said.
And yeah, exploring remedy issues and that sort of thing. Okay.
I have two more questions in this area before I go into that.
Okay, objection overruled.
So could you please look at that document, which is Administrative Notice 12, and which was NE Exhibit 4. And could you see that on the third page that, in fact, it's what I had just asked you about, that this is a November presentation on PNM resource from PNM Resources, and that the third page talks about PNM's core capital plan of 1.8 billion between 2013 and 2017, and 2013 expected depreciation of $153 million.
Yes, I do see that slide. The 1.8 billion is not the PNM core capital plan. I believe on that same slide, the PNM core capital plan is 1.2 billion. But yes, I mean, this appears to be an investor relations or an EEI financial conference exhibit where we provide our 5-year capital plan.
Is it PNM's PNMR's goal to provide above average dividend growth to investors?
I'm not sure if that's our goal still today. PNM Witness Greinel could probably confirm that a little better on the dividend growth. I know what we target certain dividend payouts, but I'm not sure if it's above industry growth.
But is it your understanding that that, at least in 2013, was true?
Yes, that was what it says back in 2013.
Would you agree with me that the hearing examiners, the commission, and the Supreme Court have all determined that the issue of whether PNM acted prudently when the company continued its participation and made investments in Four Corners Power Plant is properly at issue and shall be determined in this case?
I do agree that the prudency issue associated with Four Corners Power Plant is an issue for this case.
Would you agree that if I refer to Four Corners instead of Four Corners Power Plant or FCPP, that all means the same thing?
I agree with that's fine.
Okay, thank you. Would you turn to your rebuttal testimony, page 63, please?
I'm there.
You testified at page 63, line 21, that PNM was not imprudent in its decision to continue with Four Corners as a resource because the company analyzed and compared known options at the time. A decision needed to be made in the 2012-2013 time period and evaluated the reasonableness of the long-term fuel supply.
Yes, that's my testimony.
And then if you go to page 64, line 5, you testified, as PNM witness Graves' testimony demonstrates, even assuming there were flaws in PNM's analyses in 2012 and 2013, customers were not harmed by PNM remaining in Four Corners compared to other resources available at that time. That's all. Did I read that correctly?
Yes, ma'am.
You are using the word flaws as a noun. And I looked up that the definition of the noun flaw, and it was defined as, quote, a defect impairing legal soundness or validity. Do you agree with that definition?
I'm not an English person, but I have no reason to doubt that's what the definition is. I was
So-
thinking mistakes.
I'm sorry, I was thinking mistakes.
Yes.
Thank you.
PNM relied on the May 2012 strategist economic analysis to justify its continued participation in Four Corners, including the coal supply agreement and the then anticipated installation of additional pollution control equipment, correct?
That is my understanding of the analysis that was done in 2012.
According to PNM and the May 2012 strategist run, PNM found replacing Four Corners with a natural gas combined cycle unit to be either 33.5 million to 44 million, depending on the price of coal that was used, more expensive on a net present value basis. Is that your understanding?
I would refer to PNM witness Graves to confirm those numbers. I know that the analysis did confirm that it was in the customer's best interest to continue.
So if you could just go quickly to the administrative notice 59, which is PNM Exhibit 12 O'Connell.
Okay, I have it in front of me.
And could you go to page 10?
Okay.
And do you see there on line 11 and 12, Mr. O'Connell says at that time that depending on what fuel prices, coal price forecasts were, that the difference was between 33.5 million to 44 million more expensive on a net present value basis?
Yes, it says using feasible coal price forecasts, PNM found replacing Four Corners with a natural gas combined cycle unit to be 33.5 million to 44.0 million more expensive on a net present value basis.
But you know now that the May 2012 strategist run omitted capital expenditures. Isn't that true?
Yes, at the time, resource planning did not include ongoing capital expenditures. I believe Mr. Graves gets into this testimony that adjusting for ongoing capital on both sides, both for Four Corners and the replacement resource, while changes the numbers, does not change the overall outcome of the analysis. But yes, that was a change from previous how we used to do integrated resource planning.
So in 16-276, the PNM's last rate case, PNM was allowed to recover 90.1 million of the SCR investment and 58 million of the additional life extending capital expenditures for a total of 148 million. Is that correct?
Subject check on the numbers. That does reflect the capital investments included from July of 2016 through December of 2018.
SCR were required pollution controls and 58 million were necessary capital expenditures to keep the plant operational. Is that also true?
I believe that is correct. The expenditures would have been used to keep the plant running. That is correct.
Can you explain, please, how the commission ordered PNM to treat the $148 million of capital expenditures in the 2016 case?
Pursuant to the stipulation reached in that agreement, PNM agreed to only have a debt-only return for the capital projects related to Four Corners from July of 2016 through December of 2018 at a debt-only return.
So that didn't apply to all other capital expenditures, correct?
Correct. That was related to Four Corners and for
No,
that
no.
time period.
Okay, what I meant by my follow-up question was it only applied to the $148 million. Is that correct? From 2016 to 2018. Not other capital expenditures that were not the SCR or the Arizona Health System that was made up the 58 million.
I don't know about the Arizona Health System, but like I said, the $448 million received a debt-only return in that cost of service study.
And any other capital expenditures that PNM incurred on Four Corners, how was that treated?
There was no adjustment. So they would have been just included in rate base, recovered at our weighted average cost of capital.
You made a calculation in your rebuttal that at page 65, you were talking with Mr. Marks about this, HEM2 there, that NEES Four Corners remedy would cause a loss in its non-fuel revenue requirement for the company, correct?
Yes, I did that does exclude the impact associated with including recovery of 50% of Four Corners investments prior to 2016 over 3 years. So this is reflective of the no return on, or I apologize, I don't want to summarize what your proposal was, but
what does
yeah,
it refer?
no,
That's what I
no
want
return. I'm sorry, no return on or of Four Corners
from pre-2016.
post 2016.
Post 2016, and does it also include collection of 50% of pre-2016 at weighted average cost of capital?
No, it doesn't. And I say that on lines 8 through 10.
What did you look at to determine this calculation here?
I looked at the investments from from July 2016 through the end of the test period.
And anything else?
No.
You have agreed that capital expenditures were omitted from the May 12th strategist model that PNM relied on to make its decision to continue at Four Corners, correct?
Yes, they were excluded from both the Four Corners side as well as the replacement resources side. As I said, that was a previous assumption in integrated resource planning that has subsequently been adjusted.
And what about decommissioning costs? Those were also omitted from the May 12th strategist model. Is that correct?
I'm not 100% sure on that. I believe that's correct based on my review of Mr. Graves' testimony.
Did this HEM2 number that you came up with regarding the New Energy Economy Sandberg remedy, did that include or exclude decommissioning costs?
I don't believe so. However, Mr. Sanders can confirm the calculations, but I believe it was reflective of just the impacts of no return on or of associated with the period of time.
And didn't Mr. Sandberg said that what he was recommending was that Four Corners be removed from rate base and that ratepayers only pay for fuel and O&M, not anything else regarding Four Corners except for the pre-2016 stranded assets or undepreciated investments?
I believe that's an accurate summary of witness Sandberg's testimony, subject to check. I don't.
Okay, so you don't know if Mr. Sanders, when he was making this calculation in HEM2, dealt with decommissioning costs, for instance.
No, I do not.
Okay, I will save that for him. So could you just explain to me what this $17.7 million figure represents? Is that an annual deduction from the $791 million non-fuel revenue requirement increase that you're asking for?
Yes, that's a correct summary of what that represents.
What would be the one-time gap write-off for the knee Sandberg reduction?
I have not quantified that impact. I don't know. It would be larger than the 16 to 21 million associated with the New Mexico Attorney General. As I believe NEE's position is no return on or of. Actually, I can't tell you NEE's because that's not an impairment calc. That's a full disallowance of those investments. So with no revenues, there's no impairment. So it would be the entire net book value of those investments would be the one-time charge.
Could you look at New Energy Economy Exhibit 11, please? Tell me when you're there, sir.
I'm there.
Does this document list the qualified environmental investments required to operate the Four Corners plant in service from 2017 to 2022? From Arizona Public Service Company, the operator of the Four Corners plant?
I have no idea what this exhibit is.
Okay. Could you turn to New Energy Economy Exhibit 6?
Now, are these in the administrative notice folder?
No, sir, they are just part of this case.
Understood. Thank you.
Okay, I have NEE 6 in front of me.
And could you go to page 3 of 7? And I'm asking to direct your attention to New Energy Economy 4-31, which basically just asks, I'm just using this as an intro. Please provide a list of all capital expenditures at Four Corners since July 1st, 2016, and explain the reasons for said investments. Did I read that correctly?
That is what interrogatory NEE 4-31, that is the question.
Okay, and then after objections, it says, please see P&M Exhibit NE 4-31, right?
For capital additions by work order for the period of July 1, 2016 through December 31, 2022.
Thank you. And could you turn now to New Energy Economy 7, which is P&M Exhibit NE 4-31. And just for the record, this is a copy. The original is also included in New Energy Economy's exhibit as New Energy Economy 7A, but that's an Excel spreadsheet that couldn't be recorded by the court reporters. So we transferred it to a PDF and did change the font size.
So that it would fit.
So that it would fit and that we could also attach it to the record.
Hold on. Mr. Alvidrez, is this NEE Exhibit 7 acceptable to the company based on Ms. Nazi's representation?
I think so. I'm looking at where they.
Okay, subject to check.
Numbers are the same, subject to check, yes.
Okay, thank you. Go ahead, Ms. Nazi.
These are the company's exhibit. This is the company's exhibit that reflects Four Corners power plant capital additions from July 1st, 2016 through December 31st, 2022. Is that what it appears to be?
That is what it says. I will point out that PNM witnesses Heffington and Sanders sponsored the exhibit, so they may be a better witness to ask, but that is what the exhibit is called.
Yes. And could you please go to page 160 of this document and tell and state for the record how many millions of dollars PNM has invested in total since July 2016 through December 22 at Four Corners?
So my exhibit doesn't have a page number, but there is a total on the last page that says,
Yeah, there are no page numbers here, Ms. Nanazi, but are you talking about the very last page?
Yes, sir.
Okay, go ahead, Mr.
But just for
Conrad.
the record, just before you even say that, if you look the PDF, it says page 160 of 160. So it's in the corner. It should be in the left.
Well, I'm in Dropbox in the document and it doesn't show that in the Dropbox document. I'm sorry, I don't have it on. I didn't upload it or download it yet. Go ahead.
okay, so the last page of this exhibit says total capital additions, including ARC asset, is $194,520,598.
So is it correct that to the extent that this 194 million approximately encompasses the 148 million, the 148 million of capital expenditures at Four Corners is on only a debt return, but all the rest of the capital expenditures are at the full whack?
I believe I followed a couple of things. Yes, this would include the $148 million that we previously described. It would probably be the actual capital expenditures. I believe, as we talked about with another attorney, I can't remember who it was. The 148 million was based on our forecasted capital expenditures at the time. I believe the actual capital expenditures for that same period was a little bit lower. And so I don't think it would include exactly 148 million, but it includes the investments from that period of time. And those investments from July of 16 through December of 18 are currently in rates or what receiving a debt only return. Any investments post that test period have not been reflected in rates. They are requested to be recovered in rates in this proceeding at a full return on and return of.
And so do you have any idea what the return on equity would be for, just even roughly, for this $194 million? Like, how much does that equal?
I don't have those calcs, but a large chunk of it is receiving no return on equity because it's getting only a debt only return. But I haven't done that calculation, nor do I have it.
So give me 1 second, please. So you understand that New Energy Economy's Sandberg testified that in order to hold ratepayers at least partially harmless, he recommends that Four Corners be excluded from PNM's non-fuel revenue requirement, essentially removing Four Corners from rate base, correct?
I did read witness Sandberg's testimony. I can't say I recall exactly his exact arguments or what his claim was. I have no reason to disagree with your positioning. I can't confirm that.
So if Four Corners was removed from rate base, that would mean that ratepayers would no longer have to reimburse the company for Four Corners capital expenditures, correct?
If Four Corners is removed from rate base, then customers' rates will no longer reflect recovery or payment for that facility. However, well, obviously P&M disagrees with that. So, but yes, that is the effect of removing it from no return on and no return of would mean customers are no longer including those dollars in rates.
Would that be also true with respect to decommissioning costs for Four Corners?
Would what be true? I mean, your example was talking about capital, so.
Right, and now I'm asking you the same question, but I'm asking you about decommissioning costs. If Four Corners was removed from rate base, P&M would not be allowed to recover from ratepayers any costs associated with decommissioning going forward. Is that correct?
I guess I'm not understanding your hypotheticals. I mean, whatever the commission includes in rates will be reflected in rates. If the commission removes decommissioning costs from rates, then they would not be in rates. I guess I'm struggling with what question you're asking me.
What I'm asking you is if the commission orders the company to remove Four Corners from rate base because it was imprudent and it's no longer used and useful. For instance, you have already stated that ratepayers would no longer pay for capital expenditures going forward in 2024 going forward. Would that also include no recovery for decommissioning costs?
I mean, they're your hypothetical, Ms. Nasi. So if you're asking me, is there a hypothetical where the commission disallows decommissioning costs, then they would be disallowed and removed from our revenue requirements.
Those Four Corners capital expenditure and decommissioning costs were omitted from the May 2012 strategist run that P&M claims formed the basis, the justification, if you will, for its decision to reinvest in and keep the plant open in 2016. So why wouldn't it be fair to exclude those same costs from P&M's non-fuel revenue requirement?
I don't agree with your statement. I believe the SCR, I believe you even stated that the analysis included capital costs associated with, for example, SCRs.
I did, because that's what you've done, right? But now I'm asking you a different question. Now the commission gets to decide if P&M's actions in that plant at that time were in fact prudent and what's the appropriate remedy, right?
I agree that decision of prudency for Four Corners is at issue in this case.
Okay, so I'm saying to you, P&M omitted, it ran strategists. This is allegedly the basis or justification for investing in Four Corners, but P&M omitted, as you've testified already, decommissioning costs and capital expenditures from that analysis. So why not just remove those two things from the allowable cost recovery for P&M? Wouldn't that be fair? You left it out. We're saying, okay, don't charge us for it. You've already been charging us for it since 2016 till today, till 2024. But going forward, if that's what you omitted, why do you get to now keep on charging it going forward?
So those were a lot of questions. And I would say, no, that would not be appropriate to remove those.
Why wouldn't that be fair, though?
I guess I would refer you to P&M witness Graves' testimony that addresses all of those issues. For example, on the ongoing capital, one point I would like to point out is the SCRs were included in that additional analysis. And that is not what, and so when you keep saying none of those investments were included, I don't believe that is accurate. Secondarily, as Mr. Graves testifies, when you adjust the modeling to include ongoing capital for both sides, both abandoning Four Corners or staying in Four Corners, and the replacement resource, when you account for it for both sides, it does not change the conclusion that was reached back in 2012.
Could you please look at New Energy Economy Exhibit 9? And if you would go to the 4th page of that exhibit, and this is P&M Resources depreciation study.
I am there. I'm not sure who, I hope someone's okay. Sorry. Go ahead.
It sounds like Mr. Alvidrez just lost
on my book,
his
yeah.
trial book.
Okay.
What is the-
Precisely why I've gone almost all screen digital is because of doing that, as I've told Mr. Ryan many times.
is the current depreciation schedule for Four Corners 2041?
That is correct.
I'm sorry, Mr. Nasi, I lost you.
I believe that I asked, is the current depreciation schedule for Four Corners until 2041? And Mr. Monroy answered, yes, that is correct.
What page is that, Mr. Nazi, of this NEE Exhibit 9?
It's 4.
4. And what this document is ABCWA 3-34.
Yes, sir.
Is that right? Okay, so page 4. Okay, go ahead.
And so isn't the objective of any sound depreciation philosophy is to match the expense with revenue over the life of the asset?
I'm sorry, can you ask that one more time?
Yeah, that was a bad question. I'm going to change it. Isn't the objective of any sound depreciation philosophy is to match the depreciation life with the life of the asset?
Yes, generally, one of the tenets of depreciation is to set the service life to equal to the period that customers will receive the value of those assets.
And didn't P&M in its 2017 IRP determine that it would be beneficial to ratepayers and to the company to close San Juan in 2022 and to close Four Corners in 2031?
Subject to check, that sounds familiar, but I don't recall the 2017 IRP or its conclusions.
Since 2017, P&M has made many filings at the commission. Is that right?
That is correct.
And none of them included a change of the depreciation rate from 2041 to 2031.
No, that is correct.
And the reason you have a depreciation schedule that matches the asset is to, first of all, comply with commission rules. Sorry about that. 17.3.340.10 NMAC, but also to avoid intergenerational inequity. Isn't that true?
Those are both tenets. I mean, I will say, as far as the Four Corners, P&M had actually proposed to keep a terminal date of 2031 in its 15 rate case, and the commission determined to change its rates to change the terminal date to 2041.
That's
So
because
by default-
P&M
Hold on, let the witness finish, Mr. Nazi.
So by default, then those are just and reasonable depreciation rates pursuant to commission rules. And I believe you quoted the depreciation rule. I don't have it in front of me, but and so that's where that date came from, was set by the commission.
So
they determined that was the appropriate period over which to cover Four Corners at that time.
you indicated in cross-examination with Mr. Herman, I believe, that you are treating the PNM Palo Verde Unit 1 and Unit 2 stranded assets under regulatory asset rules, not plant and service. Is that right?
PNM is requesting to recover the undepreciated investments associated with the leases as a regulatory asset.
And is that depreciated out till 2045?
We are proposing an amortization period of that regulatory asset. I believe to 2045, but that'd be subject to check with Mr. Sanders on the amortization period. I thought he picked 20 years, so that would be subject to check. I'd have to confirm with Mr. Sanders.
And if PNM had acted consistent with Commission Rule 17.3.340.10 and the straight line method of depreciation, the 114 megawatt leases should have been recovered by January of 2023. Is that correct?
No, that's not correct.
Well,
I disagree with
no PNM ratepayers are receiving any electricity, energy capacity, anything from those 114 megawatts, are they?
After the leases were returned, I agree with that statement.
So why should the essentially the tenants still have to pay the landlord money after the tenants are getting no housing or abode for it, and in this case energy?
So I'm not sure I get your analogy, but the decision to return the leases and not reacquire them was based on an analysis that demonstrated it's in our customers' best interest to not renew or reacquire those leases. Previous commissions, as well as PNM, fully intended to recover those leasehold improvements, not through the life of the leases, but through the life of the NRC license extension at Palo Verde. And so under commission-approved depreciation schedules, that is the period of time under which PNM was recovering the leasehold improvements. Circumstances have changed. PNM performed the analysis and determined it was in their better interest for our customers to return the leases and acquire different replacement resources at a lower cost overall to our customers. That analysis includes recovering the previously incurred leasehold improvements that have yet to be collected from customers.
But
because there's an overall benefit to customers as a result of those actions, that is why I believe it is appropriate to recover those regulatory assets over the remaining lives of the NRC license, or 20 years, whichever it is.
Well, first of all, hasn't every single commission decision dealing with those Palo Verde leases, every single one said that they are subject to an imprudence disallowance or a used and useful disallowance?
No, I don't agree with your characterization, and I'm not sure what specifically you're referring to.
Okay, well, I'll deal with Mr. Miller on that, but the reason there's still room is because the nuclear assets ratepayers were paying so much money for those nuclear shares that even if you considered replacement power plus stranded assets, there would still be a benefit to ratepayers getting out. Is that true?
I don't agree with your characterization of a few of those words in your question. As I stated before, we compared continuing to reacquire the nuclear leases and continue to use that power versus alternatives, and determined it was in our customers' best interest to not reacquire the 5 leases.
So ratepayers if PNM has their way, ratepayers will not only pay for new replacement power, but continuing to pay on undepreciated investments for the 114 megawatts and future decommissioning costs. Is that correct?
So a couple of comments there. It's not correct in the fact that customers will receive the benefit of our decision to exit those leases and not reacquire them. That over time is a net reduction or savings to customers. And that includes the cost to achieve those savings, which is to not continue participating in those leases for Palo Verde, recovering the undepreciated investments from customers, reflecting prudent investments that were previously incurred. And as regarding decommissioning, that's where I got lost. You'll have to ask that part again, because I do not believe extending the leases had any impact on the decommissioning liability. But I would refer you to witness Greinel for that information.
Well, PNM is asking for the only remedy that that the commission instituted upon the imprudent actions of PNM in extending the lease and repurchasing the leases for the 114 megawatts, or the 114 megawatts and the 64 megawatts, was to disallow any future decommissioning costs. Is that correct? When the commission made its decision?
So when the commission made its decision relative to the 64 megawatts, they also disallowed additional the acquisition adjustment related to the 64 megawatts. In regards to the extension of the leases, the commission did determine to on decommissioning liability to no longer allow for additional recovery of decommissioning funding from customers. That decision was appealed and was returned back to the commission, and that issue is now subject for this case today. But the commission did already provide its remedy for the imprudence of the decision to extend the leases in the 15 case.
But the extension of the leases, what was the remedy that they decided?
To disallow future decommissioning liability recover from customers.
So on the extension of the leases, if you are allowed in this case to start recollecting for decommissioning costs, then there will be no remedy whatsoever for PNM's imprudence on extending the 114 megawatt leases. Is that correct?
PNM is arguing that as a result of the extension of the leases, that there was no additional decommissioning liability as a result of that transaction.
That's not what I asked you.
And so the commission ruled what its prudence remedy would be, and that's what we're trying to determine in this case here, is whether the decommissioning liability should be limited. Recovery of the decommissioning liability related to the leases and the 64 megawatts.
But if the commission allows future decommissioning costs as PNM requests for the 114 megawatts going forward, then there will be no remedy going forward for PNM's imprudence in extending those leases. Is that correct?
I think it's correct that the commission will decide if that remedy is appropriate or not.
And regarding the 64 megawatts, while PNM had their net book value reduced, that was also the recovery for future decommissioning costs was also part of the remedy that the commission decided was appropriate for PNM's imprudence, correct?
That's correct. I believe both the write-off associated with the 64 megawatts as well as decommissioning liability.
Could you, in the fall of 2013, PNM was relying on Strategist to justify its CCN application at the San Juan Generating Station. Is that correct?
I don't know. That
Could-
sounds correct. I don't know.
Okay. Could you turn to New Energy Economy Exhibit 15, please? And
I'm there.
could you go to page 11 of Mr. O'Connell's testimony in 13,390?
I'm there.
And could you just read to yourself the first paragraph and the next couple of lines of this, and the first line of the second paragraph?
Okay.
So do you have any reason to doubt that when Mr. O'Connell provided his direct testimony in the 13,390 case, that it was true that PNM, when the PNM was issuing its running its strategist runs, that the choices of resources that were included were wind, solar, gas, and nuclear?
I'm going to Mr. Exam, if I may lodge an objection. This witness is being asked about testimony of another witness in another case, and there's been no foundation for this. We don't have an opportunity to cross-examine Mr. O'Connell, and so I think that this is inappropriate line of questioning.
Objection sustained.
Do you have any reason to disagree that at the time when PNM was running strategist in November of 2013, that among the resources strategist, and therefore PNM was considering, included wind, solar, gas, and nuclear? You remember what PNM's application for replacement power for the San Juan Generating Station was, correct?
There was two questions, so I'm not sure which question you want me to answer. I do not remember what was included in strategist runs from that time period.
But you know that at that time, PNM was concerned about meeting its renewable portfolio standard, correct?
PNM is still concerned with meeting its renewable portfolio standard.
And so therefore, solar and wind were among the resources that were being considered at that time period.
Going to object, asked and answered.
Sustained.
The problem with that, Mr. Medeiros, is that I didn't get.
Sustained, move on. Mr. Nazi, please. You can take this up with other witnesses potentially.
Could you please go to New Energy Economy Exhibit I?
1 minute.
Exhibit I. Mr. Hearing Examiner, while the witness is going to that, is it possible that I could have 10 minutes of Mr. Peters?
Whereas Peter's on our list here.
I had 20 minutes and I'd like to reduce it to 10.
So that's Jason Peters. You're reducing it to 10
Yes, please, sir.
and going 65 now. Right?
Yes,
Okay, I'm gonna reset to 10.
thank you.
welcome.
Sir, could you please, are you at New Energy Economy Exhibit number 1, which is the certification of stipulation, number I, excuse me, of stipulation in 16276?
Yes, I'm there.
Could you please turn to page 68 of that document?
I'm there.
Could you please read the first 2 sentences beginning with the second paragraph on page 68?
Starting with the hearing examiners.
Yes.
The hearing examiners find that the appropriate remedy for PNM's imprudence in extending its participation in Four Corners and pursuing the 90.1 million of the SCR investment and the 58 million of the additional life extending capital improvements is the disallowance of all costs associated with the investment and improvements. This follows the precedent established in PNM's last rate case as a remedy for PNM's imprudence on the balanced draft investment, and as such, it would likely be the appropriate remedy if this case were being tried on its merits.
Thank you. The 16276 case was not a case on the merits, but a case on a contested stipulation. Is that correct?
Yes, that is correct. I don't know if it was on the merits, but it was a contested stipulation.
On the other than the possible settlement of the case 1918 show cause rate credit issue, in this case, this is a fully litigated proceeding, correct?
I didn't understand your reference to the 1918 case, but this is a litigated rate case proceeding.
The last rate case that the hearing examiners were referring to was the 15261 rate case, right?
I believe so.
And there was a finding of PNM imprudence with respect to PNM's investment in balanced draft in that case, correct?
I believe so.
You're saying balanced draft or imbalanced draft?
Balance draft.
Thank you very much.
Thank you. Is it the position? Is it PNM's position that the May 12 strategist runs shouldn't be the barometer of prudence because it really didn't influence the decision by PNM?
I'm not sure I understand your question. Could you ask it again?
Is it PNM's position that the May 12 strategist runs shouldn't be the barometer of prudence because it didn't really influence PNM's decision to stay in Four Corners?
No, I don't believe that's correct. You had some double negatives in there, so I just want to make sure. I'm not quite sure what you're asking, but as PNM did have an analysis in 2012 that it used to make its decision regarding Four Corners. Oh, sorry. Go ahead, Mr. Hearing Examiner.
No. I was anticipating Ms. Minazzi cutting you off. I apologize, Mr. Monroe. I wanted you to be able to get through your answer. Go ahead.
So did I. I'm sorry. That was just like a regular conversational moment, not a cross-examination moment. So it's PNM's position that the May 12th strategist run is the barometer for which prudence should be decided on, right? Isn't that correct?
I guess I'm thrown by your phrasing of the barometer under which prudence should be determined on. I guess I'm struggling with what you mean by that phrasing.
Okay, I'll rephrase. So is the May 12th, May 2012 strategist run the main analysis that P&M used to make its decision to continue participation in Four Corners?
Yes, at that time, that is correct. And I believe Mr. Graves then addresses further analysis that was done addressing issues or concerns with that analysis. But yes, that is correct.
About 5 minutes, Ms. Nnazi.
As you sit here today, you know that when P&M repurchased the 64 megawatts and extended the leases of the 114 megawatts at Palo Verde, it did so without performing any strategist runs, economic modeling, or financial analysis.
I
Is
don't
that-
know that today. I don't know that.
P&M acknowledges that climate change is real. Is that right?
I believe P&M acknowledges that there are environmental issues that will be addressed by reducing emissions that we provide into the environment.
And reducing emissions, you're talking about fossil fuel carbon emissions, correct?
Yes, CO2, NOx, SO2, various emissions, mercury, various emissions that we are tracking.
Methane?
I don't recall, Mr. Hearing Examiner. I was trying to look at our sustainability report that has key metrics of the things we are tracking. Methane may be something maybe I'm just not aware, but
The gas plants emit methane, right? The gas plants?
Not to embarrass myself as not being an engineer, but subject to check.
That's fine.
Early.
Subject to check.
Yes, sir.
I don't want to cut it. Go ahead, Mr. Nnazi.
Have you heard?
I'm adding a minute for that methane question.
I appreciate that. Are you aware that the head of the UN, Antonio Gutierrez, has characterized this period that we're entering into as the time of global boiling?
I am not aware of that.
Is it P&M's plan to still burn coal at Four Corners or sell its share to NTEC for NTEC to continue to burn coal until at least 2031?
As I stated earlier, Four Corners is still a certificated asset and is still providing electric service to our customers. P&M is currently evaluating whether what to do with Four Corners and whether an early abandonment is in the best interest of our customers. That analysis is not complete, and so the company has not made a final determination associated with Four Corners at this time.
If the commission held that P&M shareholders had to pay for capital expenditures and decommissioning costs at Four Corners Power Plant instead of ratepayers, because that would partially hold ratepayers harmless for P&M's imprudent actions when it used flawed and outdated analysis to allegedly justify continuing its participation in the plant, would P&M appeal?
Going to object on multiple grounds, if I may. It's a compound question, it's argumentative, and it also calls for a legal conclusion.
P&M agrees with the New Mexico Supreme Court that ratepayers should be held harmless for the imprudent actions of utility management, correct?
I don't know what you're referring to. P&M does agree that if a prudency finding, there is a requirement to demonstrate what the impact to the customers as a result of that decision is.
And that ratepayers are to be held harmless, right?
I'm not sure if that's the Supreme Court's view. From my perspective, I think it's up for the commission to decide. I do think a harmless analysis as a remedy is an appropriate way to determine what, if any, there should be as a result of any imprudence.
Thank you, Mr. Monroy.
Thank you, Ms. Nanasi.
Thank you.
I'd like to move the admission of certain exhibits.
Go ahead.
Let's see. I'd like to move the admission of exhibit 9 and 7.
Okay. NEE7 and NEE9. Any objection to what we have as that Excel spreadsheet, which is converted to a PDF that's subject to check, but that's the document you're referring to as an NEE7, right, Ms. Nanazi?
Yes, sir.
And then how about go ahead. That's
Oh.
PNM exhibit NEE 4-31, FCPP Capital Editions, July 1, 2016 through December 31, 2022. Subject to check for verification and
Yes.
accuracy. Is that any objection?
No, subject to check, and we'll, if you don't mind, we'll report back tomorrow morning first thing if we find any anomaly.
That's admitted, subject to renewing the objection tomorrow morning. Otherwise, it will be deemed admitted.
And no
That's
objection.
any exhibit 7. Now, NEE9.
No objection to any E9.
NEE9 is admitted. Anything else, Ms. Nanazi?
No, thank you.
All right, thank you, Ms. Nanazi. Let's move on then to Ms. Beatles. We have 20 minutes with Mr. Monroy. Mr. Monroy, are you good to go still?
Yes, sir, I'm good.
Thank you. Go ahead, Ms. Beatles.
Thank you, Mr. Hearing Examiner. Good afternoon, Mr. Monroy.
Good afternoon, Ms. Beatles.
As you know, I am representing Western Resource Advocates in this proceeding. My questions are going to take you in a different direction, back to something that you addressed earlier today. Would you agree that the purpose of cost allocation is to attribute a share of the utilities revenue requirement to its various customer classes in a manner that reflects the cost of providing service to each class?
I think that's a fair definition of what I think of with cost causation and cost-based rates.
And would you agree that cost of service analysis also involves classification of cost by either demand, energy, or customer related?
Yes, I agree with that as well.
And you were asked a number of questions this morning on cross by Mr. Gould that referred to the NARUC 1992 cost allocation manual. Is that right?
I remember his cross on the NARUC manual. Yes.
Do you have any reason to disagree that that manual includes more than one method of classifying distribution cost?
As I say with Mr. Gould, I have no basis for what that manual says, as I have not read it.
Do you have any reason to disagree that it contains more than one method of allocating cost to the various customer classes?
I'll say the same answer, having not read it. I don't have a reason to state what that manual does or does not do.
Would you expect that there are methods of allocating and classifying cost other than those presented in this 1992 manual?
Not subject to what's in the manual. I do agree there are different methodologies on how you would allocate costs amongst its customer classes, but I'm not sure exactly what's covered in that manual. But I do, just from my experience with working with the pricing team, there does appear to be many methodologies or approaches.
And would you agree that there are reasonable differences in opinion among the various methodologies?
I think as forming the pricing advisory committee is illustrating, there are definitely different opinions on allocation of costs and cost causations.
So I'm going to read a couple of sentences from the NARUC 1992 Cost Allocation Manual, page 13 specifically, and ask you a couple of questions about it. Regulators design rates, the prices charged to customer classes using the cost incurred by each class as a major determinant. Other non-cost attributes considered by regulators in designing rates include revenue-related considerations of effectiveness in yielding total revenue requirements, revenue stability for the company, and rate continuity for the customer, as well as such practical criteria as simplicity and public acceptance. Do you generally agree with that description, that rate design goes beyond cost allocation?
I do agree that there's other considerations beyond cost causation. As demonstrated in our own filing, PNM's proposed a banding proposal that moves away or shifts away from true cost allocation to customer classes. So I do agree there are other considerations that should be taken into consideration, excuse me.
Is that at least in part what you meant when you testified earlier today, that there are inherent limitations to cost causation?
Yes, that is one of the things inherent is rate shock, all those impacts, gradualism of rates, all those concepts to make sure that customer classes are as a result of cost allocation versus what actual customers have been paying or what they're expected to pay in their rates.
Mr. Hearing Examiner, I don't know if it's appropriate for me to object. This seems like Friendly Cross asking Mr. Monroy to double down on his own testimony.
I didn't hear that so far, but if it's an objection based on Friendly Cross, that was an appropriate objection. Ms. Beatles, are you going to?
I think this illustrates one of the limitations of the prohibition on Friendly Cross. You know, Mr. Gould this morning used Mr. Monroy as PNM's chief witness to introduce evidence regarding the NARUC cost allocation manual and what it says, and regarding
Right, I am not striking his answer to the question. I think it's appropriate. So to that extent, the objection is overruled. However, let's not move it any further into getting the witness who already agrees with you to get him to say so on the record. So let's stop and move on.
Yeah, my questions are intended to just round out the picture, and I don't know how PNM is going to answer.
Right.
So
what you asked was fair, and the answer you got was also fair. But because that can was opened by Mr. Gould, frankly, with cost allocation and unity.
okay.
Go ahead.
So this is related, but not directly. So I'll find out whether it's acceptable. At some point, Mr. Monroy, the exercise of whether the parts and pieces of the electric grid should be assigned for recovery from one customer class or another, or from both, becomes subjective. Would you agree?
I do think there is some expertise and knowledge of what assumptions are included. However, I do think PNM witness Casas and Chan are probably better apt to get into those details.
Have you ever heard the description that rate design is more of an art than a science?
I have heard that characterization before.
Is it your understanding, Mr. Monroy, that the requirement from the 15-00261 decision, which was your last fully litigated general rate case, regarding the minimum distribution system method of classifying cost, was to collect and maintain the necessary data, not to use it as the basis of your proposed rates?
I don't have the details of that requirement, as I stated earlier. I do think that's a question better asked of Mr. Casas or Ms. Chan.
Okay, I'll move on to another topic. Do you recall the questions you were asked this morning on Cross by Mr. Albright about the change that PNM is proposing in this case to the depreciation rates of certain gas plants so that their terminal lives were consistent with your decarbonization goals and requirements?
I remember that cross from this morning.
And is it fair to say that your proposed changes accelerate the rate of depreciation of those plants?
Yes, by decreasing the terminal date to a shorter life has the effect of increasing the depreciation rate or increasing depreciation.
And it would also have the effect of reducing or eliminating stranded cost exposure when those plants are retired or abandoned. Is that right?
It does have the effect of reducing potential stranded costs.
So that reduces the risk of recovery for PNM and its shareholders, right?
I think it also reduces, I think it does, but I would more clarify that it really reflects that customers who are receiving the benefit for those assets, trying to match the cost associated with that period of benefits.
Are you referring to the, what is it, intergenerational equity or intergenerational inequity concept?
It is. I was more thinking of just the tenet of depreciation within the depreciation rule that talks about depreciation accounting's attempt to match the costs associated with the period under which customers benefit.
And would you also agree that your proposed depreciation treatment also reduces the lump sum of unrecovered investment that ratepayers may be responsible for?
I guess if that's a way of saying reduces potential stranded cost investments at the time of the retirement, then yes, I think that is one of the advantages of adjusting the terminal dates today for those plants.
So I'm just, so would you agree that it reduces the risk for both shareholders and ratepayers?
I would agree that I guess I don't think of it as risk. I don't know if there's risk associated with prudent utility decisions. I look at it more the period of benefits to the period of costs that are required to meet those benefits. The benefits being generation from those facilities, the cost being the return of or depreciation of that facility.
Okay, I won't belabor that. I think I made my point regarding the risk of recovery or non-recovery. So my final question is, let me just look at how I wrote that down to make sure I'm getting it accurately. I think you testified earlier this morning with respect to your earnings test that was approved in conjunction with your renewable energy rider, that you were, and I believe you used the word allowed a return of 50 basis points over your last authorized ROE. And I just want to clarify that what you're allowed is to retain over earnings, to retain over earnings up to 50 basis points over your last ROE. You weren't allowed a higher ROE.
That's correct. I'll accept that correction. Yes.
Okay, that's all I have. Thank you, Mr. Monroy.
Thank you.
Mr. Hearing Examiner.
Thank you, Ms. Beatles. Okay, Mr. Foreman, for staff, I have you down for 25 minutes.
Thank
Please,
you. Thank you, Mr. Hearing Examiner.
Thank you.
Good afternoon, Mr. Monroy.
Good afternoon, Mr. Borman.
I think you confirmed with Ms. Nanasi earlier that you are a vice president and corporate controller of PNM. Is that right?
Yes, I'm also over regulatory at PNM.
Yes. Would you say that this makes you part of the company's management?
Yes.
Okay. And certainly you're an officer of the corporation, correct?
That is correct.
Okay. Do you have your rebuttal handy?
Yes, sir.
Okay, I'll direct you first to page 3.
I'm there.
Line 15. I think you say this is PNM's first base rate case in nearly 7 years. You see that?
Yes, sir.
Okay. Is it true to say that PNM is in control of when it files a base rate case?
Yes, that is true. PNM determines when we file our general rate cases, as well as I believe commissioner parties have the ability to request a rate case from PNM.
Okay, thank you. Could you turn to page 53 of your rebuttal?
I'm there.
Be there. I think you state that the commission in PNM's previous rate case did not identify or put PNM on notice that the approved cost recovery for the Palo Verde leases would be subject to expiration or refund. Do you see that?
Yes, sir.
Okay. And then if you turn to page 57 of your rebuttal, and I think it's on line 6 to 13. Are you there yet?
57 line 13. Yes, sir.
Yeah, you state that the commission should the commission seek a more fair approach to the matters that you term piecemeal and retroactive rate making, then it should identify and place utilities on notice of specific costs of service items that should be adjusted. Is that right?
I say to avoid the harm from both piecemeal and retroactive rate making.
Okay.
And you say outside of a general rate review proceeding, right?
Correct.
Isn't this a general?
Oh, sorry.
Go ahead. No, you go
Yes,
ahead.
I was just saying that are subject to adjustment outside of a general rate review proceeding.
And isn't this a general rate review proceeding?
This is a general rate review proceeding for the test
Go
period
ahead.
of 2024.
Thank you. Now you're familiar with case number 21-00083 UT PNM's application for the abandonment of its leasehold interest in Palo Verde, correct?
Yes, sir.
Okay. Now you didn't testify in that case, but you do have a section of your direct testimony in this case that deals with the accounting order issued by the commission on November 18, 2022 in that docket, correct?
Yes, I do address certain requirements of the accounting order from that case.
Okay, and despite PNM's opposition in that case, the commission authorized the creation of a regulatory liability account in that accounting order. Is that correct?
Oh, that is
That's right, regulatory liability.
A regulatory liability account.
Thank you.
That is correct, and for final disposition of that to be determined in this proceeding.
And PNM was directed to track and account for all costs currently borne by ratepayers associated with those leases during the pendency of PNM's pending rate case in such regulatory liability account, right?
That is correct.
Do you know when that accounting order was issued?
I don't have that date just off the top of my head. I believe it was in Q3 or Q4 of last year, but
Would you accept such a check that it was issued on December 5th, 2022?
subject to check. Fine.
I mean, obviously it'd be in the record and we can look. What does CWIP stand for?
Construction work in progress.
And that is sometimes called CWIP or QUIP, is that correct?
That is correct.
Okay. Now the commission has issued rules which require the filing of a detailed schedule that shows the items included in CWIP for both the base period and test period to support a rate increase adjustment. Are you familiar with those rules?
I believe they are a 530 schedule within the 530 rules.
Yes, if I told you they were 17.9.530.14B, would you accept that?
I will accept that.
Okay. Now, did PNM seek a variance from that schedule requirement in this case?
Yes, sir.
Okay. And that was based on the representation that CWIP would not be included in the general rate case. Is that correct?
That is correct, in the test period. That is correct.
And that requested variance was granted by the commission, was it not?
Yes, sir, it was.
Thank you. I have no further questions for Mr. Monroy. Thank you very much.
Thank you, Mr. Borman.
Thank you very much, Mr. Borman. That concludes the cross-examination by interveners and staff. We do have some additional questions, I believe, from Commissioner Ellison, and he would be up next if he's prepared now to ask his questions of you, Mr. Monroy. Commissioner Ellison, are you there? While we're waiting for Commissioner Ellison, who I do think has some questions for you, Mr. Monroy, Hearing Examiner Ryan, do you have questions for Mr. Monroy?
I do. Good afternoon, Mr. Monroy. How are you?
Good afternoon, Mr. Hearing Examiner Ryan. I'm well.
During the exchange between you and Mr. Gould about unity and subsidies, you said to him, and I don't think I'm not going to be able to capture the words exactly, but the general point you made was your customers can increase rates to capture any subsidies. Was that a point you made to him?
Mr. Hearing Examiner, I think he was referring to the ability for PNM as a regulated entity to change its rates versus the ability of a non-regulated customer in what they charge their customers. I think my point was that they have the ability to set the price for their product with their customers, absent regulation.
Okay, I understand that point. Does PNM have any data or otherwise know what the consequence to consumers of the subsidies are?
When you say data, I mean, I believe Ms. Chan's tables identify the impact from a cost allocated to a customer class versus the impacts from a banding to look at what the delta is between those two proposals. But I'm not sure I'm following your question.
So it seems like on one hand, we were to say 41% of PNM's customers are within 200% of the federal poverty line, right? That's the testimony in this case, not necessarily from you, but from others.
That is correct.
And I have to assume that in fact is what generates some of the desire to have banding, is to absorb some of the impact of what would otherwise be a large residential increase on people of limited means.
That is definitely a consideration.
So then my question is, if Mr. Gould's answer is, well, if you pass along the cost to us, we're just going to increase the cost of our products. How does that impact customer, like the consumer in New Mexico?
Oh, I see what you mean.
And do we know? Do we know? Does anyone know?
I don't know, and I'm not aware of anyone at this company who has done any analysis or studies, as I don't know how our customer base uses the products from those other individual classes and how it ultimately flows back out to customers. So I don't know of any analysis that has been done.
And you've read all the testimony in this case. That's what your testimony was before, if I understand correctly.
Yes,
yeah,
sir.
I did too, and it was quite a bear when you said that. So I don't recall seeing anywhere in the testimony. I recall seeing testimony that said these are problematic subsidies. But then the next question I had was, well, how? And I understand the basic point to say, well, it's unfair. But you know, as we sort of mediate those unfairnesses, we would want to know what the impacts of them are. And so I just guess I'm asking you, and I think you've already answered the question. There is no real guidance to us about what those subsidies produce in terms of end results economically in either direction, as far as I can tell.
Mr.
You
Hearing
agree?
Examiner, I'm not aware of any other analysis or any economic studies or anything that would provide an answer to that question of what the impacts are of any of subsidies between class costs.
Okay. Just another question. When you said to Ms. Nanasi that depreciation, well, I just confirm this is what you said. I believe you said to her that depreciation always decreases rate base. Is that what you said to her?
Yes, as depreciation is recorded, it's reflected as a reduction to plant and service.
And if it's a reduction to plant and service, then theoretically the return that you would get on the plant and service decreases as depreciation increases. Is that a basically correct proposition?
That is correct.
Did PNM, when you were deciding whether or not to propose accelerated depreciation, evaluate the economics of what the costs are to ratepayers now versus the costs to ratepayers in the future, given the dynamic nature of rate base and the return on? In other words, can we model what the expenses are, what the costs are of those choices?
PNM did not prepare any type of economic analysis that would have resulted in the reduction in service life to 2040 as we proposed for our rates versus leaving the existing terminal lives and what those impacts would be for future customers. PNM did not perform that analysis.
Was the basis for saying that the accelerated depreciation should occur, did it turn just solely on, well, we're shooting for a 24 carbon-free target, and therefore let's just reset all of this to 2040? Was that the basic idea?
I think the basic idea is to match what our intent is for our generation portfolio. Beginning in our 2020 IRP, we indicated that we expected those gas plants to end by 2040 based on our stated goal. And so I think our intent was to match rates reflecting what we currently expect the service life of those assets to be for our customers.
Which, if I understand correctly, is sort of saying in a long way, match up the life of the resource with who's getting the benefit of it. Is that, or have I too simplified what you've just said a moment ago?
Mr. Hearing Examiner, I'm okay with that summary.
Okay. As I was reading through all the varying materials in this case and trying to get my head around the how we get from a negative 70 million decrease to a $63 million increase, the question naturally poses itself, well, how is it that everyone sees this so differently? Obviously there's why that happens is complex, and so there's lots of explanations. But I was trying to sort of single out, are there big ticket items that explain those differences? And I'm just curious, you are offered as the witness here to give the 35,000 foot perspective, kind of the macro vision of all of this. And as far as I can tell, the main points of disagreement that generate the differences in the money really come down to a difference on the return on equity, projections of plant in service, and then to a certain extent, the depreciation schedules. Is that right, or have I misunderstood what the sort of the big picture? And you can comment on that as you wish.
Sure, I believe those are fair. Those are rather large adjustments that really swing the request. I would add to that, I think it's the treatment of the Palo Verde regulatory liability. I think that has a significant impact to an annual revenue requirement in the various parties' proposals. I also believe the treatment of the San Juan show cause issues that had kind of been put aside, but however certain parties made recommendations on how to treat that is another large revenue requirement driver that kind of delineates the company's request versus intervener proposals. And I think the final large ticket item is also treatment of the Palo Verde undepreciated investments request for a regulatory asset. I think those are really the major topics that swing the revenue requirements materially based on the varying position.
Yeah, and as I was thinking about the case, I mean, from my perspective, you know, you all have been involved in this for so long, and I'm somewhat new to the commission, but if you bracket off Palo Verde and San Juan and sort of leave those to the side, right? And we just ask, what is PNM really after in this rate case in terms of your bread and butter provision of service? It does seem like return on equity, depreciation schedules, and plant and service sort of are the things that we're really fighting about here. And then I don't know if you would agree with that or not, if it's fair to even bracket those other things off.
Yeah, I don't disagree, Mr. Hearing Examiner. I do think this case is rather straightforward. And we are looking to include in rates our investments over the last 6 years that we've invested in our transmission, generation, and distribution system. And we're reflecting the increased cost, reflecting the high inflation that we've seen as a result of the pandemic. And I think those are offset portfolio, namely the reduction or the closure of San Juan Generating Station, the return of the Palo Verde leases, and the lower operating costs associated with that are the primary, true ups to the overall rates that we're charging customers.
Where I'm going to tag team with Hearing Examiner Ryan here. Where would you put Four Corners prudence and a determination on prudence or imprudence in this? On which side would you put this on?
Four Corners prudence is an issue, and I think, first there's a determination whether prudency or imprudence occurred or not. Then I think where then you start getting the differentiation is what would be the remedy of that prudence. And I believe, PNM's position is first and foremost, there was no imprudence. And then if there were imprudence, the remedies is really where you start to diverge from what parties have proposed. From PNM's continued debt-only return on approximately 45% of the Four Corners investments as is, or whether other parties want to increase that debt only as a remedy. So I would say that's where you get the divergence from that perspective related to Four Corners.
Okay, placehold that because I'll come back to that, but I want to go back to Hearing Examiner Ryan, and then we have to get to Commissioner Ellis.
No, I've asked all my questions that I have. That's all. Thank you.
Great, thank you, Hearing Examiner Ryan. Let's move to Commissioner Ellison now. Commissioner Ellison, you have the floor.
Great, thank you. Good afternoon, Mr. Monroy.
Good afternoon, Commissioner Ellison.
It's been a long day. Appreciate you answering all the questions. I've got a few more.
Go ahead.
Great. So one thing that you stated in your testimony on page 12 was that PNM's goal is to be carbon-free by 2040, as we believe this transition provides financial and environmental benefits to our customers. Could you discuss what the financial benefits to customers might be of this early transition?
Sure. I think from our perspective, PNM recognizes the value of the state's policy to have a carbon-free generation portfolio. In as much that PNM believes if we can achieve that state policy earlier, we think that underwriting principle that having a carbon-free generation portfolio is in the best interest of our customers. From a financial perspective, that would mean compared to alternatives, that would be financially beneficial to our customers in regards to the rates they pay and the overall cost of environmental compliance. Recognizing, there's a cost to extreme weather, there's a cost to all of the impacts on the environment associated with emissions. And so recognizing that getting ahead of those emissions, getting ahead of those impacts provides overall benefits to our customers.
Well, if we focus directly on the costs that you can control, your generation fleet costs, clearly, as we go to a 20%, or I'm sorry, an 80% renewable mandate, it would seem that firm dispatchable generation is going to become all the more valuable. The more variable generation you put on the system, the more valuable your dispatchable capacity should be. And at the moment, what technologies and what resources may be available for long-term storage seems unclear. Would you agree with that?
I would agree with that. I would agree. I don't think we have the answer to what it'll take to get to carbon free at this point. I mean, a couple of things I just point out, Commissioner Ellison, with the resources coming online in 2024, PNM's system will already be 70% carbon free, which I believe is a remarkable testament to the policies of the state, to the commission's actions in setting our resource portfolios. And so I do think we are well on our way. Getting that last 20%, I don't know if there's an exactly known answer. I don't know if there's an exact known of what the cost will be to customers. That is something that is the subject of our integrated resource planning activities as we start to look to analyze what those future technologies may or may not be to get us to that goal.
But there is a distinction between 70% carbon free and renewable generation, correct? Because you're adding in the nuclear component there.
That is correct. That is correct. I apologize. Yes.
Okay, so could it be that this achieving this, the state mandate is for 2045. So could it be that accelerating it by 5 years ends up being more expensive to the ratepayer?
I think those are considerations that the company will definitely partake as it goes to reach its goal of 2040. I think there's requirements in there to analyze those cost impacts and what the state has deemed to be cost prohibitive to achieve the carbon-free goals. And so I think those are all considerations that we will need to be mindful of as we set paths towards long-term solutions to hit that 100% carbon-free.
So I guess my question is that goal of being 100% carbon free by 2040, is that something that PNM is intending to achieve no matter what the cost, or is it a goal that you're striving for and you're going to be evaluating the cost of that transition to determine whether it's a good idea or not?
Commissioner Ellison, I would agree with the latter part. I think cost consideration is always something we have to consider as we make all the decisions at the utility. And so I don't think we can achieve that goal in a vacuum and not be mindful of the costs and impacts to our customers.
Okay, and on page 12 of your testimony, you also discuss the proposed natural gas-fired plant accelerated depreciation, justifying it based on that 2040 goal. If accepted, by how much will depreciation increase?
So Commissioner Ellison, we have, as far as quantified the change to the depreciation rates for the 4 gas facilities. That total change is approximately $5.4 million on an annual basis. However, what I don't have available is how much of that change is related to the shortening of the terminal dates versus just other normal updates as performed by our depreciation expert. And so there's two things that are changing. It's not just changing the terminal dates. And so the impact would be something less than 5.4 million, but I have not quantified of that 5.4 million for those 4 gas generation facilities. How much is solely related to shortening of the terminal lives versus how much is related to other updates as performed by our depreciation witness?
Can you provide that analysis?
I don't have, I will have to confirm, I'll have to confer with our depreciation witness. It seems like it would be a variable that he could model to get a feel. I mean, that would make sense to me, right? You can change a component and do that. I'm not sure if he has done that analysis. I'd have to confer with him.
Well, that's a placeholder for a potential bench request on that. So could you report back or have Mr. Alvidrez report back in the morning on that?
Yes, sir.
Go
We
with
will
it.
contact our depreciation witness and get a response on when that analysis can be done or and
Thank you, sir.
provide that information.
Mr. Alvidrez, could you put that on the list for us for tomorrow morning, please? Thank you, sir.
So following up on that, it sounds like the goal of transitioning to zero carbon by 2040 is a goal and is not a commitment, no matter what the cost. Given that, does it make sense to, if we were to adjust the depreciation rates for these 4 plants for the 2040 date, aren't we essentially assuming that that's going to happen?
Commissioner Ellison, yes, I would agree with that. I think that reflects the company's intent. That's their belief of what makes sense for our customers at this time. I will say depreciation rates are subject to change, as are the assumptions. I think it's appropriate at this point based on what our expected remaining usefulness of those facilities are to have depreciation rates that reflect that assumption today.
I understand, but doesn't it seem like you're essentially asking ratepayers to pay for accelerated depreciation to meet a corporate goal as opposed to a statutory requirement?
I understand that. I do understand, Commissioner Ellison, I understand that point. I will point out one of the facilities is already 10 years beyond even the requirements under the ETA. Currently, our La Luz is depreciated through 2055, as well as the Luna facilities through 2046. So both of those are beyond the statutory requirements. I just believe as a policy perspective, there are a lot of unknowns of how we're going to get there by 2040 or 2045. The company, like I said, believes it's in our customer interest. And so we are analyzing and making decisions and trying to evaluate our portfolio to achieve that goal, as we do think there's benefits to moving those state policies or achieving those goals as quickly as possible. However, you are correct, and cost implications are always a consideration and nothing can be done in a vacuum. However, I just think it's a good choice now to accelerate those lives today, given with what information we have today.
I understand. Thank you for your response. I did want to ask about the BB2 line. You bring that up in your testimony as well on page 40, where you state the BB2 line expanded PNM's transmission capacity, improving PNM's ability to integrate and deliver generating resources to its retail customers, including renewable resources such as wind. Has PNM, so this line is in operation today, correct?
That is correct.
Has PNM used the line to bring additional wind to its retail customers?
Yes, I mean, first so specifically, BB2 as a network upgrade provides for the entire system to operate as a whole. And so whereas there might be direct power interconnections within a transmission line from generating facilities, the value of the BB2 line goes beyond any generating facility that connects directly to that line. Specifically associated with BB2, what I'm referring to there is the La Jolla Wind Farm, which is providing through a purchase power agreement, power to our retail customers.
So which is it? Is it one of the La Jolla wind farms that is providing power, or both?
I don't have the megawatts, but I believe there's over 300 megawatts of the La Jolla that through PPAs are providing energy to our retail customers.
And who is that PPA with?
Mr. Hearing Examiner, I apologize, I don't have that information.
I believe one of them is with Meta. Does that sound correct? At least, a portion of that capacity is being purchased by Meta.
The energy from La Jolla, one of the agreements is PPA that is in turn delivered to Meta. However, go ahead.
No, I was just going to ask, the other La Jolla wind farm is who is purchasing that wind?
I believe it's for our RPS compliance requirements. So for the benefit of retail customers.
Okay. Do you have a table of annual power flows on the line, sort of breaking out which customers are benefiting from the power flows?
Commissioner Ellison, I do not have that information. Perhaps PNM witness Gray may be able to better respond to that question.
Okay, that's fine. I'll ask him some more questions around the BB2 line. Let's see. Another question on page 42 of your testimony. This is on the Four Corners plant. You say that the SCR, the selective catalytic reduction pollution control equipment, and the additional investment required to keep Four Corners functioning properly, that has been in rates as of January 2019 as debt only return. Is that correct?
That is correct, Commissioner Ellison.
I seem to remember reading in a recommended decision about the SCR portion only as being in rates as debt only return. Am I mistaken about that?
Commissioner Ellison, this would be kind of subject to check, but I know in the 16 case, there was an original stipulation or original settlement and then a modified settlement. Perhaps there was an original requirement or proposal for just the SCRs, but the modified settlement that was approved by the commission and adopted by the parties reflected a debt-only return for basically all the capital investments from July of 16 through December of 18.
So not only the SCR.
Correct, but all the capital investments. I can't remember exactly the regulatory history of if it moved, but I know that was the modified stipulation that both PNM and the parties to the stipulation agree to, as well as that was approved by the commission.
Okay. I guess just one other question on the San Juan, and I think that'll be enough for me. Is your position that the ETA allows for recovery of the entire undepreciated balance, even for amounts that may be determined to be imprudent?
Let me think about that. Not really. I didn't really thought about the ETA. In regards to San Juan, I believe our position is that we have a financing order. Within that financing order, we did provide evidence, or we provided information on the projected capital expenditures that made up the estimated $283 million. I believe the ETA does have an ability, or not even the ETA, but maybe the financing order does have the ability to reconcile the abandonment costs, which would include the undepreciated investment that is ultimately securitized with the bonds, and through that review. But there has been no claims or arguments regarding any of the investments in San Juan.
I misspoke. I meant to say Four Corners.
Oh, okay. Let me think about your question. So your question now is regarding to Four Corners and prudency. Is that correct?
Yes, that's correct. Whether it's your view that the ETA allows for recovery of the entire undepreciated balance, even those amounts that may be determined to be imprudent.
Well, not being a lawyer, so I don't want to get beyond that, but Commissioner Ellison, my understanding is the ETA allows for recovery of undepreciated investments that were included in rates as of January of 2019, and then should include recovery for additional capital improvements beyond that date. And I don't have the exact language or criteria, but they're basically necessary to continue operation of those facilities. Whether those, I believe there's also provision about if a commission deems investments have been imprudent. I'm not 100% sure, but I believe there's language within the ETA that addresses that circumstance, but I don't have that in front of me.
Okay, great. Thank you, Mr. Monroy. I appreciate your answering my questions.
Thank
And
you.
Mr. Medeiros, if I could follow up just one with what Commissioner Ellison asked, I'd like to just real quickly.
Please do.
Mr. Monroy, with respect to the depreciation question, and Commissioner Ellison indicated, well, we're sort of assuming all of this is actually going to happen. Part of that process of figuring out what's going to happen inevitably is the IRP process at PNM, correct? As you're thinking about the future, the IRP process helps guide along what the choices are going to be and where the utility will head.
That is correct, Hearing Examiner Ryan.
So as I thought about that, I thought, well, you're familiar that the IRP process, there was just a new rule that the commission changed that dramatically and imposed a whole bunch of new requirements, right?
Yes, sir.
So as you're thinking about depreciation schedules in the future and plant addition or taking things offline, I mean, was the IRP process and the commission's new process necessarily driven by the new rule at all factored into those decision-making processes?
In regards to changing the terminal dates for the gas plants, I would say no. And the reason why is I would point to, we had already in the 2020 IRP, which was obviously filed before the commission's new rule, had already indicated our intent to have those gas useful lives to terminate by 2040. And so the decision on just related to those gas facilities, I guess, predated the IRP new rules. I do think the IRP is the avenue to begin to analyze what the implications are from our resources as we look into that planning horizon, as we start to get into that 20-year planning horizon.
Okay, thank you.
Thank you.
Mr. Alvidrez? Can you hear me okay?
Yes, Your Honor, I can, and I have just a few questions of follow-up, if I might.
Yes. Mr. Lee, are you okay going a little bit over? I'm sorry. Okay, go ahead.
I think that was an okay. Mr. Monroy, you recall that you were asked questions about the implications of the proposed settlement of the what I'll call the show cause proceeding on PNM's request in this rate case.
Yes, sir. I remember those questions.
And relative to PNM's revenue requirements request, is there any impact to PNM's revenue requirements in request if that settlement should be approved?
Yes, there is. And I apologize for misspeaking earlier, but one of the items as pursuant to that settlement would be we would remove the request to recover the carrying charges on the prepayments related to Section 16 of the ETA. That would reduce the annual non-fuel revenue requirement by $120,000, $120,509. And so I would correct my answer to reflect that.
Okay, and you were asked some questions about the BB2 transmission line. And one of the things that you said about it was that it is part of PNM's electrical grid system. Can you elaborate on that?
Sure. So the BB2 line is deemed a network upgrade, and it's deemed a network upgrade because it provides benefits to the entire system, whether that's through the ability for transmission to flow through different points on TNM's system. And because it's a network upgrade, those upgrades are generally paid for all customers, as the transmission system is operated as a single piece of equipment. And so when it benefits all customers, those costs are then allocated first between our retail customers who use the transmission system and our FERC wholesale customers who also benefit from that transmission system. And so those network upgrades are first allocated between FERC and retail customers, and then the remaining network upgrades are allocated to all customers that benefit and utilize that system.
Okay. You were also asked some questions about the La Jolla wind farm, and there was reference made to contracts for energy relative to Meta or the facility down in Los Lunas. Do you know who are the contracts with to procure that energy from the La Jolla wind farm?
I don't know.
Bobbin Grid Renewables, isn't it? Subject to check.
Yeah, and to clarify, my question was really between the supplier and the purchaser, if you will, of the energy. That was what my question is, but it appears I should ask a different witness that.
I was going to say, I would suggest Mr. Hevington can provide that information or confirm.
Right. And Mr. Hearing Examiner, those are my questions.
Okay, thank you, Mr. Alvidrez. Mr. Monroy, so you don't have to come back tomorrow morning unless the Commissioner or Hearing Examiner Ryan have any other further questions. We are not doing any recross, consistent with my longstanding policy. So we do have some homework for you to report back on through Mr. Alvidrez on a depreciation analysis, consistent with the colloquy with Commissioner Ellison, correct? Are you there?
Yes, I believe that's correct. And if I understand,
yeah, let me ask I have something for Mr. Monroy too. Go ahead, Mr. Monroy. Is that correct?
Yes, I believe the request was, what would be the impact if the useful lives with the 4 facilities remain intact to what
Yeah,
based on the previous terminal dates.
Let's make that bench request too now. Okay, and I want to talk very quickly, and then we'll have you all go, and then you won't have to come back tomorrow. And that is, could you pull up PNM Exhibit 28 in the administrative notice folder, please? Now, do you recall this document? I believe you were the sponsor of it.
Give me 1 second. They're getting it to me. I apologize for the delay.
No problem.
It's administrative notice exhibit 28. Is that correct, Mr. Hearing Examiner?
Did Mr. Maderos disappear?
I'm not sure.
Yes, he did. I'm assuming that was either his internet went down, power went off. And we should just,
Mr. Hearing Examiner Ryan, did he refer though to administrative notice exhibit 28?
if I understood correctly, it's PNM, the naming conventions are a little, but it would have been what is referred to as PNM Exhibit 28.
Okay, at least.
And that is, it looks like it's a chart, an Excel chart. And it's an affidavit, which is Henry Monroy, that accompanies it. So I think that's what he wants you to look at.
I'm gonna need help from my attorney because what I'm being handled is not that. So I'm looking.
Yeah, so if you go into the administrative notice in the Dropbox, that might be the fastest way to get there. And then scroll all the way down to PNM Exhibit 28 in that file.
It appears, well, what's in my
And here's Mr. Maderos is back.
Okay.
It appears that it is the AN Exhibit 64.
Okay.
I apologize. Can you hear me now?
Yes, Mr. Hearing Examiner.
Apologize. I had a power outage here because I inadvertently closed the lid on my MacBook because I ran out of power on the battery powered earbuds. What I was referring to was PNM Exhibit 28 from the administrative notice folder. I missed what was going on in the meantime, but I have it on real time so I can go back to it. What I wanted to
Mr.
ask.
Hearing Examiner, I was just trying to get the right reference. That was all. I was confused.
Okay.
I have it in front of me.
Do you recall that document? From the 2016 rate case?
I do. I mean, yes, in general, I believe it was analyzing different outcomes related to Four Corners included in the test period at that time.
And we cross-referenced that in our certification of stipulation on approximately in the table on page 67, subject to check. What I'd like you to do, this is the other further homework, is to take, if you could, all the disallowance methodologies and recommendations made by the interveners and perhaps staff, and update the disallowances in a similar set of tables. Could you do that for the commission?
Yes, Mr. Hearing Examiner, just to make sure. So using test period values.
Yes.
Make similar adjustments based on the various recommendations from the Attorney General, from Sierra Club, from NEE, And then did you say staff? Did staff have a recommendation?
I don't think so, but it just be all inclusive of all the parties that seek disallowances.
Associated with Four Corners? Yes, sir.
Yeah. Yes, sir. Could you
Okay.
provide- Okay, that will be bench request number 3. And when do you think you could provide that one? We'll get back to bench request 2 on depreciation.
I'd really like to confer with my cost of service expert, Kyle Sanders, to see the timeline on that. I can update on bench request number 1. We will be able to provide that by Friday. The 8th, I believe, is what was, I know that's for tomorrow. I apologize. I don't need to bounce around.
That's okay.
But I really would, if acceptable to you, Mr. Hearing Examiner, perhaps Mr. Alvidrez could update the timing on that tomorrow, fully understanding it'll be of utmost importance that we will get to work on immediately.
That's terrific. Thank you. Because we do have Mr. Graves on Thursday. But if it's not ready by then, that's fine. That's your witness. Yeah, so that's the third bench request, is to do an analysis along the lines of what's in PNM Exhibit 28, only updated for the the current circumstances, the test year period. Is that feasible?
Understood.
Okay, great. Thank you. And with that, we're going to recess.
Mr. Hearing,
Unless there's anything else, we really do have to go because we are keeping Mr. Lee over the 5 p.m. Time that I like to conclude. Go ahead, Mr. Nozzi.
I have one question, and that is, clearly, Mr. Monroy made a distinction between capital expenditure, all capital expenditures, and just the $148 million for the kind of treatment that PNM has been given. So I believe, and so I'm just asking you for clarification.
Well, doesn't your witness require a full disallowance of all the capital expenditures? That would be included in that category for PNM for the new for bench request 3, the response, wouldn't it? Isn't that true?
Yes, it is, sir, but the capital expenditures are apparently treated differently by PNM, and I don't know if they'd be broken out, and that's the question I'm asking you.
They ought to be broken out because that's your recommendation. And so in that column for Sandberg NE or NEE, it should reflect what the recommendation is and the impact on the revenue requirement.
Thank you.
You're welcome. Is that what you were looking for, Mr. Nozzi?
I guess what I was really looking for was 2 numbers in the capital expenditure bucket. One for the 148 at debt and the other at capital expenditures at WAC. That's what I was trying to just ask about, if that distinction was going to be made so that it would be apparent to you and the commission. That's
right, but that distinction includes the fact that you're seeking a complete disallowance, including of the capital expenditures that are subject to the weighted average cost of capital, correct?
Yes, but the reason I'm saying that is because you might decide that it should only apply, something should only apply to the 148 million, not the rest of the capital expenditures.
But we want to see it apply to what your recommendation is, and I think Mr. Monroy understands that. Correct, Mr. Monroy?
Correct. We will model each party's individual proposals.
Perfect. Well said.
Thank you.
Well said, Mr. Monroy. Okay. Well, as indicated during the pre-hearing conference, 5 hours is about the maximum cross-examination that we can have. We went over that by about 5¼ hours, which then added the commission questioning, and which includes the hearing examiners and myself, obviously included. So that just goes to show that my estimate was approximately correct. Mr. Monroy, I'm going to excuse you now and do a little housekeeping for the rest for the next couple of days. So Mr. Monroy, thank you so much. You're excused, subject to being potentially recalled to address the bench request responses and the like, if that's okay. Subject to when you're available.
Of course, thank you. Thank you, Mr. Hearing Examiner.
Thank you, Mr. Monroy. I really appreciate your testimony over this long day. Now, so you're excused. Now, Mr. Alidrez, assuming since Mr. Sanders' cross-examination was reduced by the amount that Mr. Monroy's was increased, if possible, that we may be able to slot in another witness for tomorrow afternoon. Would Mr. Watson be available to come in tomorrow afternoon potentially?
We are working on that, and I believe have confirmed, provided his flights are on time and everything, he should be able to slot in.
Okay, if not, maybe a Friday witness? Because I want to keep Graves for Thursday.
Hearing examiner, Mr. Alvitraz has been with Mr. Monroy. I've talked to Mr. Watson. He is in Albuquerque and can be available tomorrow, so.
Terrific.
Yeah.
So our loss for Mr. Lee, I'm so sorry tonight, will hopefully be gained tomorrow. So we'll start with Mr. Sanders in the morning. We'll talk about the bench requests that are outstanding, bench requests 2 and 3. And we'll talk about the administrative notice documents in the folder for the issue of prudence. And that's, so I've given the company the homework for the evening. And we've confirmed that Mr. Watson may be able to slot in if we're successful with completing Mr. Sanders' cross-examination tomorrow. And also be prepared to slot in potentially a witness or two for after Mr. Graves, if possible, on Thursday afternoon or sometime if possible. All right, is there anything else before we adjourn for the evening? Okay, hearing nothing further, thank you. The first day of hearings in this PNM rate case evidentiary hearing are concluded. Have a good night all. Thank you.
Thank you.